All right, good morning, ladies and gentlemen. Welcome to the March edition of the Tennessee Real Estate Commission meeting. We appreciate you being here. We will also appreciate the fact that you've turned your phones off or down, iPads off or down. We look forward to you all paying attention and not playing words with friends or whatever else you all do during the day when you're trying to kill time. Hopefully you'll learn something from what you hear and see today, and you should all feel free to approach any of us anytime during the break if you have questions, concerns, or opinions. Now tomorrow, we have 2 formal hearings with the judge, attorneys, and we don't need you approaching us with your opinions during those hearings because we are the jury at that point. So we look forward to a productive 2 days and encourage you to talk with us at any time. We're pretty nice people when you get right down to it. All right, with that said, we are going to ask Malcolm Young, first read into the record a public statement and then call the roll.
I'm Malcolm Young, and thank you for being with us this morning, and I need to read a public disclaimer into the record. The meeting date and time and location have been noticed on the TN Real Estate Commission's website, included as a part of this year's meeting calendar since July 1st, 2015. Additionally, the agenda for this month's meeting has been posted on the TN Real Estate Commission's website since Thursday, March the 3rd. Also, this meeting has been noticed on the TN Government GOV website since Thursday, March the 3rd, 2016. Thank you. And at this time, I'll do a roll call. John Grease, Chairman.
Here.
Janet DeChera,
Here.
Vice Chair. Gary Bloom, absent due to illness. Diane Hills.
Here.
Austin McMullen, also absent due to illness. Marcia Franks.
Here.
Bobby Woods.
Here.
Fontaine Taylor.
Here.
Mr. Chairman, you have a quorum to
Thank
conduct
you.
business.
Thank you, Mr. Young. At this time, I'm going to ask Commissioner Johnny Horn. Are you here, Johnny Horn?
I'm here. He didn't call my name, but he.
Oh,
he
I'm
knows
sorry.
I'm here.
Johnny Horn, here.
We still have a quorum.
I have you on my list over here.
We're going to ask Commissioner Johnny Horn from Chattanooga to lead us in the invocation. And following the invocation, if you all will please rise, he will then lead us in the pledge to the flag. Commissioner Horn.
Father, we do indeed thank you for the day that thou hast given. We thank you, Lord, for peace. We thank you, Father, for the process that we are in, even in America. And Lord, we pray you bless this commission, that you would give them a foresight, give them an understanding, that they may be able to do things that's pleasing in your sight, that the people's business may be up front. And Father, we pray now that you just bless in a special way. In Jesus' name we pray. Would you stand with me, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner. Members of the audience, if you have any special needs today, Commissioner Horn is also a preacher down in Chattanooga, so he'll be glad to counsel with you on an individual basis if necessary. All right, at this time, we need to approve today's agenda.
Motion to approve. Second.
I have a motion by Commissioner Chars, seconded by Commissioner Franks, that the agenda be approved as submitted. Is there discussion or comments? I'd like to, I have 2 things I'd like to mention. We had a hearing, a discussion or an appearance by a licensee out of Knoxville. His attorney, Larry Leibowitz, called and asked that be transferred until our June meeting. I'm not certain it'll ever occur, but as a courtesy, I'd like for that to happen. Is it still on the agenda at this point, Mr. Young, or Scott Boroff?
I think we've removed it.
Yeah,
It's off we've deleted it from the summary.
Okay, so could I?
it was on the published agenda, so you may want to just motion to remove it.
Yeah, I'd like to just move it to June.
Right.
Is there objection to that? All right. The second item, I will do that by consent. The second item, we had put on our agenda today a discussion, an ongoing discussion about teams.
It's in the minutes, it's for April.
It's for April?
Yes.
Perfect. That works. I'd like to make sure Commissioner Bloom's here. I'd like to make sure Commissioner McMullen's here. I'd like for people to go to Arello first. Frankly, I'd like for our rules to kind of take a little time before we get too far into that discussion. So that, in case anybody else other than the chair thought it was on the agenda today, is now on the April agenda. Thank you very much. Other amendments to the agenda. All right, is there a motion to approve the agenda as amended?
So moved. Second.
Okay, Commissioner Tachara, Commissioner Franks have moved to accept the agenda as amended. Ms. Taylor?
Would you like for us to go ahead and move the hearing on teams till a later date? When Arello's in,
April. It'll be after the April meeting. It's the following week.
would you like,
That'd
would
be
this
great.
be a good time?
Yeah, let's
Excuse me,
do it.
not would you like, would this be a good time to say, let's move the team discussion? I would like to make the motion to move the team discussion.
Okay, well, let's save that because it's
Okay.
not on today's agenda. Let's approve today's agenda, then we'll go right to that topic.
Right, okay.
All right. Yes, Ms. Kirby. It is on the, ha, I was right.
Well, it's in the minutes, it's April.
In any case, it's not
I
today.
don't see it on the agenda.
Under commission discussion.
I thought I saw it when we originally got it, but I don't see it on my iPad today.
Well, that-
We're good.
Are we, okay, so let's vote on the agenda. As long as everybody's in agreement, there is not a discussion about teams today. Everybody clear on that and okay with that? All right, then let's vote. If you're in favor of the amended agenda, you'll vote aye.
Aye.
Opposed, no. That motion passes unanimously. So the agenda is set. Now, Ms. Taylor, back to your proposal that discussion on teams occur, do you want to suggest a month?
Yes, I would like to make the motion that the hearing on teams be not till the June meeting, I would say.
All right, is there a second to that motion?
Second.
Now, let me ask you this, is the June meeting in Nashville or in
Nashville.
Nashville? All right, great.
All right, and I would like to just comment that if we started a discussion in June on it, it might not end in June.
Right, I
Okay, it may
start the discussion, I
Okay.
agree with that.
Is there any objection to Ms. Taylor's motion? I don't think it's necessary to vote on it. We'll just ask that that be added to the June agenda. Thank you, Ms. Taylor. All right, next up is to approve the minutes of our previous meeting, that which we held in February. Is there a motion?
Motion to approve.
Thank you, Mr. Char. Is there a second?
Second.
Seconded by Ms. Franks. Is there discussion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Special, we have a category called special appearances, which is next up. Could that be one or more commissioners from the Department of Commerce and Insurance, or just one, or how's this going to look? Commissioner Giannini's just here to observe.
Yeah. So, well, yeah, thanks.
This, for the audience's edification and ours as well, would you like to identify yourself for the record?
Sure. I'm Brian McCormack, Assistant Commissioner of the Tennessee Department of Commerce and Insurance.
What brings you here today, Mr.
Well,
McCormack?
thanks. I've got a couple things I just wanted to point out. The first thing I wanted to just mention is, I think I've already praised Malcolm, so I won't heap too much on him, but I think one of the things I'm really proud of, and I think I committed to you when Eve had retired, one of the things that I committed to you is that we were going to improve our pace of licensing. And so one of the things I just wanted to take a moment just to tell you from February, this past February, you all had received in initial applications, and these are comparing this February 2016 to February of 2015, so it's a year-over-year comparison of initial licensing numbers. You had 300 initial applications in 2015, and your average processing time was 21 days. And in this February of 2016, you had actually 105 more applications, but you processed them at 15 days, which is 6 days faster than the previous year. And so I think I'm very excited to tell you that, and I just think I just wanted to say that, I think we're really seeing improvement there and pretty excited.
Questions about that topic? Is there a bogey? I mean, what are we trying to get to? 10 days or?
Well, I think we're continuing to try to improve what that looks like. We're working on really narrowing. We're reviewing our processes, and Malcolm's working with us, but we're doing this department-wide or division-wide and really hammering out how to use CORE more effectively to measure the day-to-day time of our staff. And so we're gonna really hammer down exactly how quickly we can do it in time. What's specifically related to the staff. Some of these things relate to the fact that you have to have back and forth between someone didn't fill out their application right. We're trying to do various things to make sure that we're improving our forms, making it more accessible online. As we do initial applications, we're moving toward initial applications online. I think what you'll see is that automated process is going to really prevent a lot less back and forth, which we think will even make that process a better experience for our licensees. So.
Great news.
Okay. So that's the first thing. I thought that was positive. The second reason I came down here, I wanted to discuss the conversation around mandatory meeting requirements as part of consent orders. This conversation was, I've kind of reserved comment on that, both really in the year I've been here, and it was something I observed while I was kind of serving. I don't want to call myself interim director, but while I was serving in that season. And I had heard the conversation that your attorney shared with you all last week. And I think because there's been a public discussion, and I felt like it was appropriate this time for me to chime in and share the position of the department, I would strongly encourage you all to follow the advice that's been submitted to you by legal on this subject. And I'm glad to kind of give you a few reasons why I believe that the recommendation is positive, or why I support their recommendation. And I think one of the primary reasons I would say is this is overly burdensome on individuals who do not live in Nashville. If you're not from Nashville, you're often having to spend multiple nights here in Nashville, and in some cases, we don't actually know if the second day of the meeting is even going to occur. But when they find out, it's often late in the day, and so people who, once they find out, they don't have time to cancel their night for the second night, so they're stuck with a hotel bill, even for a night they didn't have to stay. And I know sometimes we travel around. So let's say we go to Knoxville, for instance, and Johnson City, which is where I'm from, that's what I'm going to focus on. You're still probably going to have to spend the night when you're in Knoxville for a meeting, because that's at least a 4-hour round trip to Knoxville. And so I think it's particularly burdensome on those who are not close to meeting locations. And I was going to give you an example. I think this will really illuminate to you why I have concerns about this. So if you have, for instance, you have $1,000 civil. I'm going to give you some examples. So we'll call the first person Malcolm, because he lives in Nashville. He actually lives right. Well, shouldn't probably say exactly where he lives, but he lives downtown somewhere, and pretty close to the office. So pretty easy for him to get to the TREC meeting here in Nashville. You've given Malcolm a $1,000 civil penalty. Well, these are hypothetical real estate agents. Well, I'm going to make another hypothetical real estate agent, my dad, who lives in Johnson City. So what I did was calculate how far that drive would be for him. It's a 550-mile round trip for my dad if he was an agent. So you've given Malcolm a $1,000 civil penalty, who lives here, and my dad a $500 civil penalty, who lives in Johnson City. So what I did, and this is just two calculations, I calculated the mileage reimbursement rate that the state has for mileage. The mileage reimbursement rate is $258.50, and the state lodging rate is $145 per night. So if you have to stay for 2 nights, that's $290. Now, this is not including what would be meal expenses or other calculations. These are just two very ones I think are pretty clear. That total cost to the licensee from Johnson City would be $548.50 to come to Nashville for travel expenses. So when you add that to the $500 civil penalty, that would essentially make this a total penalty of $1,048.50. So Malcolm, who lives in Nashville, who had the $1,000, obviously the harsher civil penalty, he is actually only really going to be responsible for $1,000, but the person traveling from Johnson City who comes to this meeting is going to have to spend $1,048.50, and I feel like that is contrary to the goal to which you all are trying to do it. It's actually more burdensome on the person who had the lower civil penalty. In fact, it was half the civil penalty, and actually they're still potentially having a more burdensome cost. And I think that's why I wanted to bring this to your attention. And I think there are a number of other reasons I could kind of get into, but I thought that was a pretty good example to see how you could, by having this policy across the board, you could end up with a kind of unintended consequences of making this much more burdensome on those who don't live in Nashville, live in the farther reaches of the state of Tennessee.
Ms. Hills from Upper East Tennessee.
It travels 550 miles. Mallory, can you refresh my memory from last month as to the explanation as to why you had recommended? I mean,
My explanation was pretty much identical to what Brian just
Okay.
shared.
Okay.
Ms. Franks.
Brian, you said that this was the position of the department. Is this something that's come down from the attorneys, or is it something that you have seen yourself? And in speaking with our attorneys, y'all come up with that?
I think this is me speaking from the administration side of the
Okay.
department. I'm speaking in support of the recommendation, but I wanted you all to know from a department perspective, we don't see this as a good tool.
Do you see any other kind of remedy that we could put in its place?
I think some of there are other options that folks they decide. I mean, I'm as you're thinking about this, I think you should think one of the things I would encourage your attorney is to look at, if you believe that there are ethic considerations you want them to do, you could potentially suggest them take online ethic courses. But even when in doing that, I would encourage you to look at them more specifically, because someone who has a $25,000 civil penalty, I'm just trying to do extremes, versus someone with a $250 civil penalty, probably what you're trying to get at is different. And so I think my thought would be that if you felt like ethics courses, which is some of our programs do that, they might require an additional course that they could do online, for instance, something that doesn't require travel to Nashville. I think those are the kind of things that I would encourage potentially looking at if you felt like it was important for them to gain some additional ethic knowledge, which I think is one of the primary things that you all include here.
And so would it be your advice that we do it across the board, like we've been doing with coming here then? Or the problem is we don't know where people live when we.
Sure. And I think that's one of the points. I think really it should be based on the violation. I think you should. I would suggest that legal has the opportunity to look through and make a recommendation based on what they see the violation being, what they know about your understanding of the desire for them to have some ethics consideration. I think that's why I would rely on their judgment. And I think you're getting good from what I've seen from the recommendations I've reviewed from legal, I think you're getting good recommendations. And if there is something from an ethics standpoint, I think you could kind of give some guidance that you think there's some value there. But I think you're probably getting pretty good advice from your counsel in relation to what they're recommending for penalties. And one of the advantages that legal have, and I think this is one of the advantages that we have as a division, is that we have multiple programs across that deal with very similar issues that you do. And our legal division, Mallory works for an attorney who kind of oversees all of these areas. So it has the perspective when he reviews her legal report, he's thinking about that in context of the other areas. So I think what you're seeing is something pretty equitable in terms of what the suggestions that are made are really given the benefit of a wide perspective.
Taylor.
Yes. I hear your recommendation, but it's kind of difficult for me to come to that point because, for instance, I'm from Memphis, and MAR represents 7 counties. Anybody that goes to MAR for a class or for their orientation or membership meeting or anything is going to have to travel. Where you live is a choice, and with your choices come hardships, or not. I feel very strongly that it's so important for people to come to this meeting and hear what comes before the meeting and how it's decided and the input of the committee members and how we try to really work for the consumer and the customer. And yes, it is harder on others. It's harder for me to come to the membership meeting than some other members here. But I just feel like that's something that we need to live with at this time.
And thank you, Ms. Taylor, for those comments. I would just respectfully disagree to say that where you choose is a hardship. I don't think we should be treating citizens in Johnson City differently than we treat citizens in Davidson County. I think that's a very, very. I mean, I feel like from an administration standpoint, we think every Tennessean should be celebrated, and I know the governor is fighting for from every citizen from Mountain City to Memphis to Lake County to to all across the state. And so to say for you all to take a position that that's a hardship, I think we want to celebrate where people live and not add an additional burden to say, well, actually we're going to treat people in Davidson County or Williamson County or Wilson County better than those, or more fairly than we treat those folks who live in other areas of the state.
So Mr. Giannini has decided to identify himself for the record and join the conversation.
Good morning, Board. Bill Giannini, Deputy Commissioner of Commerce and Insurance. I would like to say two things. First of all, you have got to always be absolutely certain that the discipline that you're imposing on licensees is equal and fair. You cannot impose, and that is exactly why your attorneys brought this to you. You have a great attorney who's given you great advice. You are spending your money. These guys here, their money is paying for great advice from your attorney. She has told you she thinks this would be very hard to defend. You are very, very likely risking having the board sued by a licensee from East Tennessee or West Tennessee who believes that they've been penalized inequitably. And when you do not take the recommendation, the legal advice of your board attorney, you are each individually potentially subjecting yourself to personal liability. She's given you great advice. We're asking you to analyze this, heed the advice of your attorney, and find alternative methods of discipline.
Commissioner Wood.
Okay, I'm going to chase this rabbit a different direction. Where does the money go that when people have fines, where does that go?
Civil penalties.
Civil penalties. Okay, thank you. Where do the civil penalties go?
The civil penalties are added into your overall revenue for the program.
Okay, so does that make sure that we have staff people?
No, we don't like to budget. We really steer clear of basing our financial decisions based on civil penalties. I think we're not interested in. We want you to make your decisions based on expenditures, based on revenue that comes in from licensing.
So if the revenue from civil penalties goes down, it's not going to impact the number of staff people we got.
We do not annually budget your operation based on a single dollar of civil penalty.
Okay. How about if we went a different direction? How about instead of we could have a civil penalty, but if you wanted to reduce your civil penalty, you could come to this meeting. Can you go that? And then if you're from Nashville and you want to come, and if you're from Johnson City and don't want to come, that's a choice.
I think you're.
But they could choose to come and choose to get continuing ed credit.
There are things you could look into that kind of match that. I think I'm thinking through that question. I mean, I think you have a lot of options in the consent order process in terms of how you suggest what you include in the consent order. I think the you're going to continue to run into the problem that. I don't know. I think there are challenges there that I can't quite articulate at this point, but I still kind of would suggest steering clear of really adding the meeting requirement in any capacity, really. I mean, because we're having to balance. If you're trying to make it equivalent as Deputy Commissioner Giannini was saying, that's going to be a very, very burdensome thing on your legal counsel.
And I would add that I would like to hear the board's observations on why they believe that someone attending these meetings for 2 days is actually beneficial.
Okay,
'Cause
we'll do that.
I
Commissioner
think,
Hills.
I think humanity would be better served, and certainly your licensees would be better served if you guys imposed some sort of 4-hour class that made them a better real estate agent, rather than having them come to Nashville and attend a meeting. I mean, that's just an option.
Commissioner Hills.
It's surprising to me, or it has been surprising to me, and I would come to these meetings not required over the years, and I would attend, and I would travel the 550 miles, and I would come here, not just when they were in our area, but that's me. I'm surprised that the people think we know who they are. So they come up to me and say, you had my case or something, and I said, I don't know that we had your case. I have no idea. So they think that's what the process is, and that I'm aware that they did something, and that I know who they are. So that's one thing. They don't understand the process, even once they've been offered a sanction. They don't understand the process. We've also been approached afterwards by people, licensees saying, "This is great. I didn't understand how it was," and so they do have a feeling. So that's been one of the surprises for me. I guess because I understood it, I thought everybody else understood it, even before I was a commissioner. So that was a surprise to me. I used to not always obey the speed limits. So when I would go to court in one county, Sullivan County, now I do better. Now I would, I would show up at court at 9 o'clock in the morning, and I never knew if I was going to be there all day or what, and it wasn't the place I wanted to be. I would have rather worked. What would happen in Sullivan County would be quite different from Putnam County. Putnam County doesn't offer the same thing. They don't offer driving school. It was very expensive. You have an option of being on probation or something. So the counties are different for the same speeding crime. And I was certainly not in control of it.
They're authorized, each county, though, is authorized by statute to impose its own civil penalties. You guys, and again, you make a great illustration exactly to your counsel's point, that you have got to make sure that the civil penalty, that if you were in Putnam County and the lady behind you was from a different county, and they said, well, we're going to give you a higher penalty because you're from Shelby County. Well, that wouldn't feel very good, and that's what's happening here. So thank you for that great illustration.
But now in Sullivan County, I didn't get this for the same speeding. It was different.
Right, I think and you can tell we feel fairly strongly about this point. I think the fact that Deputy Commissioner has decided to chime in on this subject, and I think what we're trying to illustrate is you represent the state as a whole. And so I hear where you're coming from on this subject, but there is an expectation that these licenses the part of the process is we treat them anonymously for the exact purpose so they can be treated equivalently. But what you're doing is specifically adding on a penalty that treats people inequitably. I mean, I just showed you an example. There's no doubt in my mind that you all are treating licensees differently based on where they live. And
I'll say further, I mean, I'm from Shelby County, and having previously held a real estate license, I can tell you that there are other realtors in Memphis who hold and evaluate, will it cost me more to go up there and defend it or just to pay it? Because it is a different cost. It's a significantly higher cost if you're from Memphis or you're from Johnson City to come up here, as Assistant Commissioner said, get a hotel room. I don't know if you guys have paid for a hotel room yourselves here, but the hotels in Nashville are getting more expensive by the day. And it is absolutely our highest responsibility to make certain that we are disciplining your licensees equitably. It's that simple. We have no other boards who impose this kind of penalty, you have lots of options with applying civil penalties and other types of discipline. You know, our position, and it's only an opinion, is that you find something that actually benefits your licensees and makes them a better realtor. That's what you guys are here to do, is to make them better realtors. We could argue all day long whether or not this is beneficial or not. I suspect for every one person who thinks it was great, there are probably 10 who walked out and said that was insufferable, because most people don't like to have to come to the state board office and sit through a meeting. It's just...
DeChara.
I understand that this is not what they had planned for the month of March and would probably rather not be here. However, our job is to protect the consumer. As realtors violate the law, they should be punished. I mean, when I was growing up, you do the crime, you do the time. The people who come to these meetings, a lot of them are grandfathered. They haven't had education in years. They learn something when they come to this meeting. There is never a meeting that goes by that somebody doesn't come up to me after the meeting and go, wow, I did not realize what you guys do. And when they hear the legal report, they understand that it's totally unbiased. We don't have a clue if what franchise they work for, if they're independent. We don't have a clue. We don't know if they live in Middle Tennessee or West Tennessee. None of that is taken into consideration because that's not something we know. But I think there's a great benefit to an agent who comes to a commission meeting. And I think that I have had the comment made too many times about civil penalties mean nothing. That's the cost of doing business. All they got to do is write a check and keep doing what they're doing. I have one agent who is a consistent law breaker that told me I have made a lot more money off that advertisement than y'all can ever find me. Doesn't care about the civil penalty. But if he's got to take 2 days off work and come up here and stay with us, makes a difference.
I wanted to just chime into one point, Mr. Chara. As you said, I think there was a statement about, and I think Ms. Hill said this, and I've heard this a little bit in conversation I've had with folks, is this idea that members come to you or real estate agents come to you and tell you how much they've learned. I can promise you, I hear the other side. I hear this isn't worth their time, this isn't, and I suspect the folks who are being licensed by the professional board are probably not going to come up to you who control their license and tell you they dislike this process. And I can just tell you, I suspect if we took an anonymous poll of this audience and they didn't think you all would see the results, I feel fairly confident what they would say. And one of the other points I just wanted to reiterate on that is that there is scrutiny that could come of this. I think, I don't want to bring in the legislature, but they're in session. And I most certainly think this is the kind of thing that, as they review you all, I think it's something that is the kind of thing that raises scrutiny because it is done so outside the norm of what any other program does. And if we were asked, that's exactly what I would say. I would say this is a program that does it completely different than any other program we have. And we regulate everything from, as you know, accountancy to cosmetology to, security guards. Of a wide range. And so it is definitely different. And I say that just to give you an idea that because it's different and because there are people that don't like this process, it's something that gets raised and it is often raised. I know that deputy commissioners heard it, our staff has heard it, I hear it. There are a lot of people that feel like this process is troublesome.
I want to make a couple of other points. And first of all, in no way are we. This board does a great job. You guys, and certainly we are not here to suggest that you are doing anything less than a fantastic job. We're actually here for your benefit and your protection. You have a fantastic counselor who's given you some great advice. I certainly understand there are differences of opinion on whether or not, and it's probably different depending on the licensee and depending on the reason they're here. There may be some licensees who are here and happen to get here in a month where nobody else had an issue and there wasn't a lot of business discussed, and they may not learn anything, and then the next month somebody else or somebody sitting in the same audience may have picked something up that was very beneficial. Again, that illustrates kind of the discrimination in the process. I think this board absolutely has the authority to give a licensee the option to say, would you like to come to a 2-day meeting, or would you rather take 8 hours of CE online? Those are things, when you give the licensee an option, rather than requiring that they drive up here and spend 2 nights, it is a significant different civil penalty for somebody on either side of the state. That's what your counselor is trying to tell you. That's what we're here to do. It's very, very important. And as Assistant Commissioner said, the legislature looks down very, very seriously at discriminatory civil penalties.
Commissioner Horn. Pull that microphone. Speak into the microphone.
Oh, you couldn't hear me?
I know you're a preacher, but you still have to be heard.
I'm having just a little bit of difficulty weighing the ends against the middle. And what this is we have to determine what we're doing. Is it a punishment or is it education? And it seems like it's leaning over to both. But to make a long story short, I got myself on academic probation one time. And I had to do all this work to get off. And I began to think, well, what am I doing? Am I certifying ACT Pro, or am I a better student? So I think we have the same thing here, is if we can come up with some type of compromise where they can become a better realtor. I think that's what we want them to be, is I get everybody on that. So anyway, I'm interested, and I think we should give it a good evaluation and make a fair determination.
Thank you, Commissioner Hills.
That was Commissioner Horn.
I'm calling on Commissioner Hills. I said, thank you, Commissioner Hills. Okay.
So correct me if I'm hearing this wrong. So it is from the public that this question has been brought to the attention and reviewed by council and given a recommendation, correct?
I would say that legal has made their recommendation based on, I don't want to speak for them. I think I'll let you answer that. I think I'll just say this. Legal isn't making this recommendation by polling the audience. I think they're making their recommendation based on what they think is the best piece of advice for you. And I wanted to just affirm what Deputy Commissioner Jeannie said. I really think you all are doing a great job. I love working with you all. It's been a pleasure over time. I'm only coming here because, in the same vein as I'm trying to look out for you, and that's what I told Chairman Grease when I said I wanted to bring this subject up, was that this is our concern, to look out for you all doing the thing that's in your best interest, and I know that's what your legal counsel is. It's not easy for me to come up here and tell you that this is a practice that you all have done for a while that we think you shouldn't do. I can tell you this is not something I want to do, but I think we're doing it because we see this as what's best for you all.
But I like here's my second part. So I appreciate it, and I really appreciate that you have both said to help realtors be a better realtor, because the things I hear in the public are that it's not fair for grandfathering to be done. You have I'm grandfathered, agent with the same ability to do their work. So I'm grandfathered, and this other licensee has to take these hours and pay this money and travel to Knoxville or Nashville to get this education to renew their license, where I, as a grandfathered person, I don't have to do that. And as you said, it's to be a better person. So I would hope then that would be in a direction that you would maybe consider not grandfathering.
I think, well, we don't do that. That's your business. And that's
not us.
That's the legislature's business. And I mean, grandfathering has been around since the Pharaoh days, and we could have conversations about grandfathering all day long, and boards take different positions on that. It is certainly a question, and I think in lots of ways it depends on the profession. There's some things that probably grandfathering makes sense for, and other things that don't. We don't want to get into that, and it's not discipline. It is, I do think there's an argument. We've had this conversation on lots of levels. There's an argument for people who have been in the business 60 years and are not as adept at managing technology as people who just got, my 4-year-old works the iPad better than I do. Okay, so I get that. But you've got to weigh that yourselves. That is not this.
But my point is, licensees do not think it's fair,
Well, and
no matter where you live.
that is a different thing, though, than imposing. This is no different than sentencing somebody to prison time or a fine for you can't give one person a speeding ticket for going the same speed over the speed limit and another person a different ticket for that. That's all we're trying to do. If you're in Murray County, you can set your ticket prices. If you're in Shelby County, you can set your ticket prices, but you can't have different ticket prices inside each county for different people for the same things. That's what's occurring here unintentionally. We understand it's unintentional, and I do think you guys could offer your licensees the option of either coming to a 2-day course or taking 8 hours of CE. You've got options, but you can't. What we're concerned about is the requirement to continue to operate as a real estate agent in the state of Tennessee. The requirement is that somebody has to come to Middle Tennessee to continue doing business when it costs them more than it costs somebody in a different part of the state.
Ms. Franks.
I agree that we need to be consistent. That runs in my mind every time we have a case. And I think, well, 3 cases ago, we did it this way. We have to do it like that one, and especially when it's in the same day. I am open, though, to, I like when you said 8 hours versus 4 hours. I live in Franklin. It took me an hour and 15 minutes to get here this morning. I would probably take that 8-hour class, which would probably take me 3 days with my other business to take a 8-hour class. I do like, if we're going to do it, that it be something. I have liked that we're doing consistent things on every single person they got the 180 days. If we're not doing that again, and I respect your opinions about it and that you're seeing it all the time, I just want this board to do what's right and fair. I do agree that someone who's paying $500 for hotel and gas, they are getting a stiffer penalty than me driving from Franklin if I was one of these people. So you have swayed me today to see. I do think it is a good thing for people to come here and learn about this. I've learned more. I've been a realtor for 28 years. I've learned more in the last 2 years as a real estate commissioner than I ever knew as a principal broker. So it is great for people to come, and especially principal brokers, to see what's entailed in this. But I am open to a different penalty, the 8 hours, and I like giving them the choice. And that could be something. I mean, we don't call these people and say, this is what you got, this is what's happening. That could be something that the attorneys could say, and now you have a choice of coming to the meeting or 8 hours. I would like to leave it open instead of it just being about ethics. If it's, depending on what the problem was. If it was a contract problem, that maybe it could be a contract class. So I'm open to us. I see how adamant they are, and there's got to be something.
Those are fantastic comments.
There.
Thank you.
So let's go to Ms. Taylor.
Well, I agree that it has opened a discussion, and there are 2 sides of everything, and we also know life is not fair. But I also want to pick up on the ticket prices. It just seems to bother me that because you get a ticket in one county, but you still have to go to court, sit all day and do that, and you might not live the furthest point of the county or the middle part of the county. I feel like this. I will also want to know, what do you think about formal hearings then? I mean, the people that have formal hearings have to come here. That certainly is the most expensive thing of all, is coming to a formal hearing.
I would agree with you in theory, but the number of formal hearings that you guys conduct a year is probably less than 10. The number of licensees that are required to come up here for meetings every month are probably more in the range of 30, 40. Is that a good number? Yeah. A lot more than that. I'm
About 10 a month.
about 10 a month. So it's not quite apples to apples. And again, I think, as Commissioner Frank said, and several others, that you want to make these, you want the realtors to come out of this on the backside better realtors. You can give them the option. I think it absolutely is beneficial to some folks to come here. I, for completely different reasons, think everybody should get involved and come to meetings of their boards. But when you impose it as a part of discipline and it is inequitable, that's where you run into a legal issue. That's what we're here to talk about today, is a potential legal issue for the board and the board members. Your counsel feels very strongly that we could not defend that if you were to be sued. And when we don't take the advice of our counsel, you each then become personally liable for anything that could come after that. Okay, is somebody going to take the real estate commission to court over a $1,000 civil penalty in 2-day meeting? I don't know. But somebody might take them to court over a $25,000 civil penalty if they were from West Tennessee, if they could see a path to that, because it's unfair imposition of civil discipline.
Commissioner Giannini, let me just say a couple things. First of all, I think already this commission has demonstrated that they take their job seriously. That we're not a rubber stamp for anybody. These people come out here to do it right. And that's what they're trying to express to you. We want to do it right. Okay.
And you guys have done a great job with leveling up your civil penalties over the past year.
Well, we don't think about that necessarily, but I just want to say, just globally, that this commission is here to do it right, not to do it any other way than that. Now, I want to challenge you a little bit on this notion that if we don't take counsel's recommendation, then we open ourselves up personally for liability. Is that in every case, or is that just the coming to the meeting portion of a civil penalty? For instance, it's not unlikely that Ms. Kirby, who, let me step out of this conversation and say, we agree with you also. We've got the greatest attorney and paralegal we could ever hope to have. We're thrilled to have them. Now back to my conversation. If she says, I recommend a $500 civil penalty, and this commission levies or comes back and says, how about $1,000? Take it to him and say, are we not following counsel's advice at that point?
At that point, that's a recommendation. It's a recommendation on a single issue. It's not an opinion. It's a recommendation to the board of here's what advice she's giving you that she thinks you should take. In this case, she's giving you her legal opinion that she might not be able to defend the discipline that you guys have imposed. And I can tell you that there's another department whose legal counsel advised a board to very specifically gave them a legal opinion, and that board did not take that, and that board ended up having to go out and hire independent counsel to defend them in a lawsuit. That's why we're here. We are not saying you cannot have people come to this meeting. If people think that it's beneficial to come to this meeting, that's great. We're saying what you've got to make certain that you do is give people the option, and that it's not an absolute requirement that is more harsh on somebody in one end of the state or the other. And it'd be no different in the month that you've got the meeting in Memphis. If somebody was from Knoxville and they've got to drive to Memphis, it's even then more of a burden to do that. We're saying give them an option. You certainly continue to allow people to come to the meeting, or come up with a schedule of CE for different things like Commissioner Frank said, subject matter specific to the violation. We work every day. We are working very hard every day to create an environment where a licensee never has to come to our building. We want to do business with them online. We're working every day, hopefully, where you guys don't have to come to our building to conduct a meeting eventually. We would like to see that. So we're looking forward. It's progressive, and it benefits your licensees, and we are in no way saying that they cannot come to a meeting. We're saying we do not believe you should impose on them discipline that is unfair, unequal, and keeps them from practicing their profession.
Okay, so I want to talk about this personal liability issue for a second. So let's say Ms. Kirby says, don't do it, recommends we don't do it, and we do it. And somebody goes to court, and they could start suing everybody who didn't follow Ms. Kirby's advice individually. Is that what you're saying?
They could absolutely do that.
And at that point, is the state defending us individually?
At that point, the Attorney General would make a decision on whether or not the board chose not to take the legal advice of their duly appointed legal counsel, and they would make that decision. And that has happened. It does happen. So again, that's why we're coming in and very early and saying, hey guys, this is something you need to think about. Take under advisement. She's given you good advice, and we are just here, the voice crying out in the wilderness.
I don't think you're in the wilderness, but I would say, finish my remarks, that I think this commission has caught the attention of licensees who have basically worked with immunity on certain advertising and other issues, and I don't want for this commission to give any of that back. We've got people, we've got new rules, which we need to see how they play, but I think they're going to play good. And I think we've got the attention of most licensees who are trying to, I think, to understand better, and it's clear now what they can and can't do. I'm sure there are people that come to you guys and complain, sometimes individually, sometimes as a group. And sometimes they're complaining because they don't like the fact that they're actually going to have to start following the rules. And I don't want to get away from that. We think that's part of our passion up here, is to protect the consumer by making sure that licensees know what to do.
In no way are we suggesting that people don't follow the rules.
I know that. I'm talking about the licensees who choose not to follow the rules. As Mr. Chara said, it's much easier to pay a couple $1,000, not show up for 2 weeks, and just start over again. And then pay $2,000 again in 2 or 3 months. And I don't think we have any leverage to increasingly offer civil penalties or 16 hours of continuing education instead of 8. I don't know.
Right, but if somebody keeps showing up on the legal report, because we put their disciplinary history on there. I mean, if you see somebody that's already had 3 consent orders for something, and I mean, suspend their license, revoke their license. I mean, you have that option.
That would be a recommendation from you, though, right? You would give us that recommendation.
If I thought it was warranted, I would. But then, I mean, but of course, as always, I mean, the commission's always welcome to suggest something else if you see the facts, differently or have a different opinion about it.
Okay, I got one more thing. I just remembered one more thing. So, Ms. Taylor asked you about formal hearings, and the fact we have maybe less than 10 of those a year. We also have informal applicants who show up on a regular basis, maybe 3 or 4 or 5 today, and they're from all over the state, and it's a statutory requirement that we review the situation before we allow them to go forward to get their license. Does the administration have an issue with that at this point?
And that's someone pre-licensure?
Yes.
Yeah, that would not fall into the same category as this, because the licensing office is here in Nashville. The difference is when you've imposed a civil penalty, again, and we've talked about what the speeding ticket is an example. You can't have a speeding ticket for the same offense that costs one person more than another person. It's that simple, and that is the concern that was raised by your licensee, or by your counsel.
Mr. Chara.
A comment I have, piggybacking off of where Commissioner Grease was going about the personal liability issue. Ms. Kirby presents a case to us, and she recommends we dismiss it. In our opinion, because we are practitioners of real estate, we are not attorneys, we hear something in that makes us go, oh, we don't like this. So one of the commissioners will be assigned that case to review, and will bring back a different recommendation than what Ms. Kirby recommended, because we saw something in there that we felt was a violation as a practitioner. We're not following her recommendation. So there again, that opens us up to a lawsuit personally.
Well, again, no, that would not, because that's a recommendation that your counselor is making to you. You can go into court and with an attorney, and your attorney can tell you you just need to take the 5th, and you can go in there and spill your guts and not do what your attorney said. But the court cannot sentence you to one thing and sentence somebody else to something else. In this case, you guys are the court. You are the court. Your counsel it's a recommendation. The difference between a recommendation and an opinion. She is giving you a broad legal opinion in a common practice of the board that she believes she can't defend. Giving you a recommendation that you all as subject matter experts on a specific complaint against a specific licensee is an entirely different thing. You are not required. The Attorney General is never going to say we're not defending you on that because you didn't take the recommendation on a discipline of your program attorney.
Well, we have been doing this for several years now.
Yes, ma'am.
So why has this just now become a legal opinion or just now come to light?
I mean, I can tell you from my perspective, and these two guys here may have different perspectives. I can tell you that there's a lot of attention by the legislature on what boards are doing. There was a decision by the Supreme Court last year regarding the North Carolina Dental Board, and some of you may be familiar with that. That's caused a lot of scrutiny into the practices of boards. What our job here is to continually go up to the legislature and defend the actions of the board when called. And this is probably not the only thing that they've talked about. They've talked about in very broad scale, not about the Real Estate Commission, but in boards and commissions in general, the general practices of these boards and commissions. They have an increased interest in what they're doing. We see a red flag here. That's what your counselor is telling you. We see a red flag. If you were to be put under scrutiny going forward, we think this is an area where we may be highly susceptible to being called on the carpet about, because it is discriminatory practice.
And I guess I could just chime in and say why I'm bringing it up now. It's basically, I think that's kind of what I tried to say in my opening remarks, is related to, as legal brought this conversation forward and there was a public conversation around it, I felt like the conversation had become public, and I felt like that was the appropriate time to address it. I mean, I've been aware of this practice for some time, even in my previous role, this was brought to my attention, and I had not heard of anything like this across state government. And so it was always something I had some concerns regarding. But I think when legal made their case to you all publicly, and watching that and kind of hearing the conversation, I felt like it's you all had a public conversation, and my understanding is you had not had a conversation about the subject for some time, and so I felt like that was a point in which I wanted to make sure you all knew from an administrative standpoint that we supported and felt, based on legal's recommendation, that it really is good advice that you all should be taking. And I don't believe this council, this commission with this makeup, there's a lot of new folks on here, had a thorough conversation about this particular subject, and we felt like it would be important for you to hear from us as you all are making that determination.
Commissioner Hills.
So what do you think will happen? So say there's a change going forward. What happens to the history that's behind us?
I think one of the things that why we're really wanting to start this now, I think I'm going to focus on going forward in this conversation. I think just for purposes of kind of a public conversation, I think what your counsel has given you advice, and you now have an opportunity to act upon it, and that's what I would focus on. I think in terms of you have now been advised, you have an opportunity to change course. I think if you do that, you're really appropriately doing what you need to do here.
And also, so I have 3 questions. So should we even ask for, on the cases, the however many cases we have today, after the case is read into the record, should we not want that opinion on that case, and we make our own opinion every case?
So let me address that.
Okay.
Okay, so here's where I think we're going. So we've got counsel's opinion, we've got the department's opinion. We have several legal cases to hear today, in none of those cases does counsel recommend attendance at a meeting. So I think this afternoon will be the first time this commission has a chance to talk this over on a particular case and say, well, we still want to do it, or we want to do what Commissioner Wood said and offer something, money or attendance or online course or whatever. I think we'll have a chance this afternoon to try to get it focused on a particular topic.
But anything, even the $500 sanction or
No, ma'am,
$1,000 sanction, should we even ask for that?
We are not saying that at all. The recommendations that she's making to you on your consent orders on discipline should absolutely continue the way they've been going. The only thing we're saying is, in addition to what you guys have been doing, in addition to a $500 civil penalty or a $1,000 civil penalty, somebody's required to come to a 2-day meeting. As Commissioner Wood said, I think very well, give the licensee the option and give your attorney the authority to offer in the consent order. You may either come to a 2-day meeting or take 8 hours of continuing education on a topic related to the violation. Give them that authority. It makes it easy. It doesn't disrupt the process that you currently have in place. You've given the licensee the option to come to the meeting. The folks, some people, as you all have said very well, very much enjoy coming to the meetings. I think you should not take that opportunity away from them, but for the ones who can't, just expanding and giving them an option, that's going to go a long way toward soothing any legislative inquiry that we might get. If we can go up there and say, hey, these guys, their attorney brought it to them, said they got some concerns about it, and they acted promptly and took care of it.
So will the state and our amount of staffing and the way the system is, will the state be able to handle that? Say we sanction somebody and it needs to be done on this topic in this amount of time. Can the state handle keeping up with that?
You didn't say it very loud.
Sorry, I don't speak very loud on the microphone. Yes.
Okay, just want to make sure.
So we could designate the class that we wanted them to take, not just ethics.
And I was just throwing that. What I was doing is throwing that as an option. I think you can most certainly make the options wide sweeping in terms of what you want to include. And I mean, I think you could say you can select from a series of courses. I mean, I think those are. We were just getting at I think what I was trying to get at, and just to kind of. It was say broadly some options that you could do, and I think if you don't want to make it so specific to ethics, I just know one board does that. That's why I mentioned it.
And what about the people who have already gotten the 180 days and they've not been here yet? Would it be a matter of they would have to call them and say you now have a choice, or?
Let's be a kinder, gentler board. Sure.
I would think that we would just do this going forward if you were going to make any changes, and then because the consent orders have already been executed, it's a binding agreement, and so that would still go forward with those that are already in existence.
Educators will be very happy.
Commissioner DeChara.
Specifically to, let's say that we offer them either come to a commission meeting or take 8 hours of additional continuing education. That is not going to count. We can specify that it's an additional 8 hours of continuing education and not a part of their 16 hours for licensure.
Yes, you can.
All right, commissioners, I think we've got your message. We'll see what we do with it this afternoon.
Thank you very much for your time.
We're always honored here when at least 2 senior members of staff from the Department of Commerce and Insurance show up, and they have people behind them that are probably much more important than the faces we're looking at right now.
I haven't turned around yet, so.
Thank you, gentlemen. Thanks.
Thank you all.
Thank you.
So, Ms. Grissom, is she on a schedule this morning?
Here.
I know she's here, but does she have to be somewhere else anytime soon?
You'd have to ask Ms. Grisham.
Cindy, do you have another appointment this morning? Is there a fixed time? Okay. All right. Let's take a 10-minute break, and we'll be right back and hear from you. All right, we're ready to get started again. Cindy, would you rather stand or sit? Do you have a preference? Well, as long as we can hear you, so whatever you're comfortable with. That's great.
I would prefer to sit
Okay,
probably,
thank
if y'all can't hear me, tell me and I'll get up.
Okay. About to give a report to the commission is Cindy Rice Grissom, who is a principal with Rice Insurance. Many of you buy your errors and omissions insurance through Rice Insurance. And Rice Insurance at this point is a state-approved E&O carrier. And Ms. Grissom has kindly agreed to come down and give us a report of some nature, which we're anxious to hear. All right, Cindy, you've got the floor.
Thank you, Chairman Grease. Rice Insurance Services Company is an agency that was formed by our family exclusively to administer real estate errors and omissions programs. The Rice family and the employees of Rice have been involved in the establishment and administration of mandated programs for many years, beginning in 1989. We are the current group provider in 11 of the 13 states that offer a group program and require that all active real estate licensees maintain insurance. We write in Tennessee, Kentucky, Colorado, Idaho, Iowa, Louisiana, Nebraska, North Dakota, New Mexico, South Dakota, and Rhode Island. We also write a program in Mississippi because we wrote their state program for 16 years, and after we were not the selected provider because we were not the low bidder, we maintained about 40% of our original share of the market because a lot of people did not want to change carriers. That sometimes happens in the insurance industry. People get comfortable with who they're with. We are located in Louisville, Kentucky, so we're just right up the road. We've been administering group programs for mandatory E&O states as our only business since our formation. We do not write any other insurance programs. Another important factor that sets us apart from other insurance agencies is that we also handle the claims in-house for the group programs that we provide. We are staffed with 7 in-house claims specialists who are also attorneys, along with an experienced claims supervisor to adjust and oversee the claims that are submitted under the Tennessee program. These in-house claims specialists offer Rice to allow us to have specialized knowledge in claims handling, as well as a higher level of service when an insured is faced with a claim. When an insured calls Rice with a question about coverage, they'll speak directly with one of our on-site claims specialists. These are the very same individuals that receive the claims and are involved in the initial coverage determination. When a covered claim needs defense counsel, we assign the matter to a Tennessee attorney. We have established relationships with experienced outside counsel throughout Tennessee and other states. Unlike other agencies, we work with only one insurance carrier in the mandated programs. Our partner for the mandated programs is Continental Casualty Company, one of the CNA companies. CNA is the #1 provider of real estate liability insurance in the United States. Its nationwide data helps us to identify trends in business and provide expert claims support on a broad number of real estate liability issues. We partnered with CNA since 2001. We have also been the administrator for the Tennessee Group Program since 2001, but before the Rice Agency was formed, our family worked for previous companies which also administered the Tennessee program, every year except for 2 since 1991. We are honored to have a long-term relationship with the Tennessee Commission and its licensees. I'm here today to provide an update on the program and to answer any questions. At the end of 2016, we had 22,128 licensees enrolled in the Tennessee Group Program. We've been pleased that the number of licensees that are enrolled in the group program has been consistent over the past 5 years. Over $21.5 million in defense costs and damages have been incurred as of March 4th, 2016, since Rice began administering the Tennessee Group Program in 2001. Executive Director Malcolm Young asked me if there were any hot issues in our recent claims experience that we could report to the Tennessee licensees. So we ran some claims to see if we could find any recurring issues. Each of you were provided with a claims analysis for the period from January 1, 2011 to March 2, 2016. If you look at these reports, the first section is the number of claims. This report shows the breakout of claims, listing the number of claims for this approximately 5-year policy period. There were 320 claims that were closed with no payment, 257 that were closed with payment, 172 that were closed with legal expense payment only, 18 that were closed with only damage expenses paid. There were 67 that were closed with both damage and legal paid. There were 210 where coverage was disclaimed because the coverage was not applicable to the type of claim that was submitted. And there are 157 that are still currently open. So for a total of 945 claims in that approximately 5-year period. The next category breaks out the total dollar amount in categories, including the closed claims, the damages incurred were $1,696,000. For the closed claims, the legal expense incurred was $2,408,000. For the closed claim, the damage expenses recovered, this would be subrogation claims, where somebody else was responsible for making that payment, was $4,500. For the legal expenses recovered for subrogation was $19,508. And there is no legal deductible in Tennessee, so none of that would be attributable to the $1,000 per claim deductible if, that's on damages. So none of those are included in those subrogation numbers I'm showing you. The closed claims for the total incurred amount for that period of time was $4,080,000. For the open claims, the ones that are still open, the incurred amount for damages is $935,663. For the legal expenses incurred on those open claims, $2,131,268. And for the total incurred on the open claims for that period of time is $3,066,458. The total incurred for closed and open claims for that period is $7,147,389. The next category shows the payment information for closed claims with the average damage payment per claim. For all closed claims that had any kind of payment at all, that was $6,599. If you look at the average damage payment per claim for closed damages in which damages were actually paid on the claim, it was $19,953. Then if you look at the average legal expense payment per claim for all closed claims with payments, it was $9,371 for that period. And the average legal expense payment per claim closed in which legal expenses were paid was $10,077. The next category shows the most common allegations. Most claims include more than one allegation of wrongdoing. We've noted the most common allegations that we've recently seen in Tennessee without regard to whether or not the particular allegation may or may not be covered under the terms of the group policy. The next report that I have on here, if you flip your page over, shows a little more detail about the most common allegations in recent years. It also shows the most common allegations in claims with incurred amounts over $50,000, because these are the biggest claims, and I think they're the ones that get most people's attentions. You will see that the most common allegation in the big dollar claims in the last 5 years has been non-disclosure or misrepresentation of mold. There were 38 claims in Tennessee alleging misrepresentation or non-disclosure of mold in that 5-year period. 6 of those involved incurred amounts of over $50,000. In 2013, we were able to add environmental coverage to the Tennessee group policy. The current policy offers $100,000 per licensee per claim with a $300,000 annual aggregate of damages, and there's no limit on the defense cost for a covered environmental claim, which is defined as a claim alleging the insured's failure to detect, report, assess the effects of, or advise of the existence of pollutants, fungi, or microbes. 3 of the big dollar claims that we saw involved residential property management, and 2 of those involved commercial leasing. 3 of them involved auctions. 1 was residential, 1 commercial, and 1 farm. And 3 of those big dollar claims involved vacant land. I asked our claims department for some input regarding the Tennessee claims experience. Alleged nondisclosure of a material adverse condition about the property is something definitely we see over and over again. The alleged adverse fact or condition is often water intrusion in some form or mold allegations. We have also had some significant square footage cases and property size cases, including a large contentious case that went all the way to the Tennessee Supreme Court regarding our insured's representation of square footage of a commercial office building in an auction. The Tennessee Supreme Court declined to hear the case, and the appellate court upheld the dismissal of our insured by summary judgment since the insured had inadvertently misrepresented the square footage, he had obtained the square footage numbers from a prior appraisal, and because the purchaser signed a contract stating he agreed that the property was being sold as is, where is, and that his bidding on and purchase of the property was based solely upon his own inspection. Plaintiffs' counsel had argued that because there was such a material misrepresentation of size of the building, there was approximately a 19% difference, which is significant. They said that the exculpatory language should not bar the plaintiff's claim. Our counsel that was appointed for the insured was allowed to address this issue briefly and explained that Tennessee courts have long held that exculpatory language is enforceable and a complete bar to the plaintiff's claim of negligent misrepresentation. It found that there was no material misrepresentation exception to this rule. We have another similar auction case involving square footage of a residential building that is set for trial. In that case, the information was collected from previous tax records. We also have a motion pending for summary judgment in that case. Our best practices recommendation for real estate licensees when they're dealing with size of property issues is that they should explain the source of the information anytime square footage or acreage information is provided, and they should also put it in writing that if the size of the property is important to the buyer, then the buyer should have that information independently verified. The next report that I've given you shows data for each policy since 2003. That's when CNA started writing the program in Tennessee with us. This report shows the number of claims reported each year and the number currently open and closed. It also shows the total incurred amount per year on this report. This report shows each group policy number and lists the closed claims count, the total paid for closed claims, which breaks out the lost payments and the legal payments, the open claims count, the total incurred for open claims, which also breaks out loss and legal payments, the total claims count, and the total incurred amounts. Since real estate E&O claims typically take years to close, for example, we still have open claims from every single policy period on that report since 2003. The true cost of the claim cannot be determined until the claim has actually been closed and all related expenses have been paid. As a general rule, the claims that take longer to close tend to be the claims that are the most expensive because the legal fees, for one, will continue to incur until the claim is actually closed. On this report, please keep in mind that it is a 2-year policy, so the number of claims for the 2015 policy only reflects the first year of claims. It's still unclear if the amounts paid out for the most recent years will be more or less than in the prior years. Our actuary, well actually CNA's actuary, will review the loss history and apply factors for continued development in order to calculate the premium that is needed anytime that there's a future year calculation. As the claims mature, the loss data becomes more reliable, so then we'll know more about the current periods as time goes on as we look back. You will note that we spend more on legal fees than we do on loss payments. This is typical in our experience for this line of business. One of the most valuable features of a real estate E&O policy is the defense cost coverage. There's no limit on the amount of defense cost under the group policy, and these amounts are paid in addition to the limits that are stated on the group policy. Also, please note that the loss reports do not include any IBNR, which is an insurance term meaning incurred but not reported, and loss development, which is a factor that's used by actuaries to determine the ultimate loss on that claim. The numbers that you see are the numbers that are actually set by the in-house claims adjusters at our office, and then the insurance company will look at that and say, as these claims mature, we know there's going to be additional costs, and they factor that in their determinations. Other administrative costs that aren't reflected in these reports are the cost of the insurer to provide the program, including their staffing costs and expense allocations, the administration of the program, the marketing and claims adjustment costs. All these factors are considered for any insurance provider in the premium calculations for their programs. Overall, the amounts paid out for the Tennessee program from January 1, 2013 to December 31, 2015 for closed claims is $17,777,726. The incurred amounts paid in reserve for open claims is $3,653,908, and the total incurred amount for the 2,808 open and closed claims in Tennessee since 2003 is $21,431,535. This shows the dollar impact of the insurance program for its purpose of public protection relating to Tennessee real estate transactions since 2003. We're happy to be able to offer this group program, which offers affordable coverage and valuable protection to the majority of licensees in Tennessee. Unfortunately, a licensee can do sometimes everything by the book, but they still find themselves faced with a claim when something goes amiss with the transaction. Our society is becoming more litigious, and this trend creates increased likelihood of a claim even when the licensee has done nothing wrong. A claim can be disastrous from a financial, mental, and professional standpoint, and having adequate insurance available is invaluable to the licensees. In some states, real estate licensees are unable to find affordable coverage. Some licensees, particularly those who have had prior claims, may not even be able to find a company willing to provide them with a quote for E&O coverage. Since the group program in Tennessee must accept all licensees at the same fixed premium for the base policy, the mandated program assures that E&O insurance is available and affordable to all Tennessee licensees. We are very pleased to partner with the Tennessee Real Estate Commission in providing this valuable program for its licensees, and we take our responsibility for providing this program very seriously. If there are ever any questions, concerns, or even praise you'd like to share, please contact one of us at Rice Insurance Services to share your thoughts. At this time, I'd like to open the door to any questions that anyone would like for us to address.
Thank you. If if a claim is submitted or reported to you, if you get a report that there's a possibility of a claim, does the premium go up for that licensee?
It does not. The only time it would be impacted is for the higher limits. So every licensee under the group program pays the same amount of premium as every other licensee for the $100,000. There is a slight difference in the price for the tier if they buy up the 250 limits or the 500 limits, if you've had a claim in the last 5 years, or if you're involved in what are considered higher risk activities such as appraisal activity, property management, heavy commercial. So if you're 75% residential or more, you would pay the same amount in the buy-up. But for the $100,000, the base policy, everyone pays the same amount. It doesn't matter how many claims that person has had. We cannot cancel them, and we cannot charge them more for the base program.
Commissioner Horn.
Had a substantial amount on fraud. And, I know what fraud is, but what does that mean to me looking at this?
All right, that's a really good question, because one of the things that everyone knows is that fraud is not a covered allegation. One thing that most people don't realize is whenever there's a lawsuit brought, they always allege fraud, and they, if it's a claim that also alleges negligence, which probably 99% do, because it's easier for the attorney to prove negligence than it is to prove fraud. Fraud is much harder to prove. Even if they think it's fraud, they're probably going to allege negligence. So if you have a case that you turn into us and there are allegations that you negligently misrepresented that the roof was new, in fact, it leaks and has problems with it, all right? They also allege that you knew that it had not been replaced and you fraudulently fooled them into thinking it was a new roof. So what we're going to do, we're going to look at that claim and we're going to say, well, there's an allegation of fraud and there's an allegation of negligence. So we're going to provide a defense, and the negligence claims will be covered, but we're going to reserve rights to disclaim that claim later in the event that the judge or jury finds that the fraud allegation was substantiated. So if there's a finding of fraud and there are damages awarded for fraud, the insurance company would not be responsible to pay that portion of the judgment. However, what we see as a practical matter is almost every allegation that we see, every lawsuit particularly, will say that there was negligence, and they will also allege that there was fraud. And what happens is there's a defense provided, and most of the time it's resolved based on the negligence claims.
Ms. Franks.
How do we kind of rank amongst other states? Are we having more claims? Are our dollar values more, or?
I can tell you that Tennessee, out of the states where all the mandated states that have programs, has this is the second lowest premium on the market, and that's the way that we determine the premium is based on the loss experience. The only state that has a less expensive premium which is also a 2-year premium, is Rhode Island. And Rhode Island literally is so small, and we probably only have about half of the licensees there because most of the people that are licensed in Rhode Island actually live in surrounding states. They're not residents of Rhode Island, so they'll buy insurance in their home state because it's going to apply for them everywhere. If they buy our Rhode Island program, it only covers their Rhode Island transaction. So we have about half the licensees, and they've only got a few thousand licensees. So it's really, we don't consider it as, it's not a real profitable program for our company, but it's a not, I should say, for the insurance company, because it doesn't really make a big difference for us as the agency. But as far as the viable, considerable size programs, Tennessee has the least expensive premium. Tennessee and Kentucky are right there, very close.
So are you
So-
projecting any increases coming up?
It's a bid year, so I cannot comment on that.
Okay.
Mr. Young?
Thank you. Thank you, Cindy, for this report. I can tell you, as we go forward, protecting the consumer as a commission, your breakdown of where we need to concentrate on education activities as far as helping the licensees understand is very, very helpful. So we do appreciate you being here today.
So it's like Malcolm thinks we're done. I have a question for you. Okay?
Certainly.
So you gave us a list of the 20 most common allegations, most common claims. So I'm just going to read a few of them. If you'll just say yes or no, it's covered, okay? Fraud,
Not covered?
just say yes or no.
Yes. Oh, no.
Okay,
No.
bodily injury or property damage.
No, but can I make an, yeah, okay, go ahead. It's so hard for me because there's so many.
You're our guest. You volunteered to come in here. Go ahead, tell me what.
Okay, bodily injury and property damage is not something that's typically covered under professional liability coverage. It is typically covered under a general liability coverage. So general liability is designed to cover claims such as bodily injury, property damage, advertising injury, libel, slander, that type of risk. E&O is really geared traditionally to only cover professional liability risk, meaning damages suffered because of something that you have done as a licensee in your professional services representing me as my real estate agent.
So do you think most real estate licensees carry general liability insurance?
We don't currently have a product to sell. Like I said, we only do real estate E&O. I think probably they don't because a lot of them call me asking me for it.
But if it's the second most frequent claim, it might be something to think about.
I agree, and let me also state on that again, we typically defend them because usually they say property damage caused by something that's covered. So it typically provides a defense. They just technically don't pay damages supposedly that are related to those.
Okay, negligence.
Yes.
Okay, Consumer Protection Act.
We have a lot of claims under the Consumer Protection Act, and we've seen a lot in Tennessee, and I know that we've covered them. I don't know, I have a copy of the policy, I'm going to double check. I don't
That's
think.
okay, that's a good
Yeah.
answer.
Okay.
If you don't know, we should find out, okay? What is conversion?
Conversion means that you had funds that you have converted over to your own use. So if I have an escrow amount that I've taken and instead of putting it in the escrow account, I put it into my personal account, that would be considered conversion of that money.
That covered?
No, there is an exclusion for that, but there is some coverage for escrow claims under the policy. Excuse me. It's a small amount, but it helps for a lot of the issues. It's $5,000 per claim, with a $10,000 annual aggregate for damages with no limit on the defense costs.
Okay, so I got it. Deal fell through, no closing occurred. You cover that?
Typically, in that situation, it would be a negligence claim that caused that, so we see those a lot.
It's likely
Yes.
covered.
If there's no exclusion.
It's not a yes or no.
It's hard to get a yes or no out of someone in the insurance business.
Well, to the audience and my edification, we don't get to choose who carries this insurance. This is state procurement office or somebody you deal with, right?
That's correct.
So I'm just trying to, if I'm talking to licensees, like 3 out of the first 5 are not covered. most common claims are not covered by E&O.
That's true, but keep in mind that there are numerous allegations in every complaint. Those are just the ones that are frequently seen repeatedly in the claims that we see in Tennessee. And really, it's the same ones everywhere.
I'm sure.
Yeah,
Earnest
yeah.
money. Earnest money. What about it?
Escrow and earnest money, $5,000 per claim, $10,000 annual aggregate, no limit defense costs.
Okay. Mold, you mentioned mold. It's one of the top ones. That's covered.
There is $100,000 that was added in 2003, so it is covered under the environmental hazards claim coverage. It's sublimits of $100,000 per claim, and also $100,000 on the aggregate for covered claims alleging an environmental
But
claim.
that's when they take the rider. That's
No, it's
that's
automatically
already in.
Oh, wait.
The environmental's not a rider.
Hang on a minute.
I'm just trying to think
You
myself.
know what? I may have misspoken on that. No, I haven't. Okay. It scared me because I looked down at my little cheat sheet here and it's talking about the excess. The excess also has $100,000. It is covered under the basic policy in Tennessee. Everybody has it. I knew I checked that before I came, but for some reason my cheat sheet was down here.
Just a couple more. Ethics complaints. Is that something you all cover?
There is an endorsement that you can purchase that would cover regulatory complaints and complaints at the association. And that would be, do you mean an ethics complaint typically at the commission is what those typically would be?
In your list of 20 most
Right.
common
Yes.
allegations, there's ethics down near the bottom of that
Right.
list. I'd be surprised if you covered that. I was just curious.
There's an endorsement that you can purchase for regulatory complaints, or wait a minute, I take it back. I do apologize. It's a little bit different in every single state, and I don't handle the claims on a daily basis, so some of my people can answer them off. The regulatory complaints, we do have automatic coverage for that in Tennessee. Most states, it is by separate endorsement. It's $2,500 per regulatory claim and $5,000 annual aggregate.
So I didn't mean to throw you a curveball. I think my point is most people have no idea. They pay their premium, but they have no idea what they get for it.
Including us.
Yes.
And so the one thing I know, which I just recently learned, was that if some of these people right here have a complaint filed against them, they can call you guys, and you will assign an attorney to handle the complaint process with the state.
That is correct.
That's a shocker. When I heard that, I couldn't believe that. But apparently it's beneficial to our staff because you get to deal with professionals dealing between each other instead of a licensee, which is a pretty neat benefit to the people who have that policy. Although I don't think many people know it. All right. I'm sorry if I did. But I think it's...
I have my cheat sheet. I'm just not good at reading it.
Well, I noticed that about 20% of the complaints that are filed, you guys don't cover. So I was just curious which of those complaints...
Right. And keep in mind, too, the numbers of the claims that we don't cover. We get some claims that are pretty odd. Like we'll get sometimes claims that have nothing to do with someone's professional services as a real estate licensee, but they just basically will send it to anybody they have insurance with. You know, they may not even know. So sometimes we get claims that aren't even somewhat related, or sometimes we'll get a letter from somebody. Somebody will get a complaint letter, and it's really not even related to their real estate business. So the number of claims that are disclaimed aren't always because it's something that's in the exclusions. It might be something that's completely unrelated to the real estate practice.
Other questions or comments? Well, we really do, as Malcolm tried to end this conversation earlier, said, I appreciate you coming down. We appreciate the information, and we'll use it to the benefit of licensees and the public. Thank you, Cindy.
Thank you very much.
Thanks, Cindy.
Thank
Good
you.
seeing you.
Good to see all of you. I appreciate the opportunity to be here. And if anybody back here has questions,
Mr. Chairman,
ask me after the meeting.
I would like to add that Cindy, on her trip here today, is going to be one of our first vendors that will actually be working with CORE and our electronic transfers of errors and omissions insurance to upload to records of the licensees. So we're excited that we have her participation and cooperation to be the guinea pig.
She's an IT person, isn't she? I mean, it should be a problem.
Yeah, outside of my expertise, but I'll work on that.
I was going to say, you brought Linda.
I have a team.
Thank you.
Thanks.
Thank you.
All right, we're to the point in the agenda where we're going to have informal applicants, and that's not correctly stated so much, but there are people who have some history that might cause them not to get a license unless they come with their broker to this commission, give us their story, let us ask questions, and at the end of that period decide whether or not we think it's okay for them to go forward and get their real estate license. So sometimes we hear some unbelievable things, and sometimes we hear some very emotional things, but we at least get to give the applicant the right to come up here and plead his or her case. So in a moment, I'm going to call the applicant's name and that applicant's principal broker. If the two of you would come up, take two seats right here. The law director, before you sit down, will ask you to swear that you'll tell the truth. You can agree or not to, but we expect you'll swear to tell the truth. At which point she'll read a short narrative into the record, and then we'll let the applicant fill in the blanks as much as he or she wishes to do so. All right, with that said, the first one up today, I have Robin Lane Baker and principal broker John Griffin. I don't see neither one.
This is her broker.
So are you Robin Lane Baker? Okay, come right up, and please tell us your name. Let's see, what's your last name? Hargis. Don't sit down yet. Don't sit down. Law director.
You raise your right hand and repeat after me. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
All right, do you have anything for the record you want to read into the record? Malcolm, thank you.
I'll be reading this. The summary disciplinary sanctions, the Ms. Baker has been cited with a felony, which was a burglary of a building. She was arrested in March 2007, convicted September 2009, 5 years probation. Also, a misdemeanor, a tampering of government records, arrested January 2008, convicted September 2009, 5 years probation, $8,000 fine. Ms. Baker, her letters and recommendations can also be found in the iPads, which is provided with your information.
Thank you, Malcolm. So, Ms. Baker,
Yes, sir.
you can tell us anything you want to tell us about those events, what you've been doing since those events, or anything you think might be important for us to know. You have the floor.
Thank you. Thank you all for having me to, come and share my story. I was a 17-year-old pregnant dropout, high school dropout. Got married to thought was my high school sweetheart. Had by the age of 23, I had 4 kids. He wasn't so sweetheart, and we were married for 17 years. The last 3 years of the marriage were very abusive. It was domestic. There was physical, emotional violence, and through all that, I ignored my upbringing, which was Christ, and didn't call on him and try to take it on all myself. So didn't have an education, and the felonies that I do have on my record, they were, I'm not going to say that I didn't have any take or partake in a lifestyle that wasn't right, but those actually were my ex-husband now. The burglary of a building was actually a storage unit. It was 2 of them storage units. They were his mom's, my ex-mother-in-law. Me and my son, my husband actually ran and was arrested later, but me and my son at 14 years old, were both arrested at the time. So he went to juvenile, and I, of course, went to the adult. So that was for the burglary of the building. The tampering with the government documents or records, that was actually food stamp cards that my husband had, ex-husband had bought, and I knew that they were bought and used for, I don't know what they used the money for, but we bought food stamp cards, and that was discovered at a grocery store after doing some shopping. And like I said, I know that this was wrong. This was a bad history, my history is a mess, but through all that, I have a message, and that is I've changed my life. I've actually now I have my I went and got my GED in 2012. First of all, I moved 4 states away, and got a divorce, and brought 2 of my children with me to Kentucky. Then we moved to Nashville, Tennessee. We've lived here for 5 years, and newly remarried 2 years, and I have changed my entire life over and given it to God, and as well as that, I have been allowed to get my GED 2012, my associate's degree in 2013. I'm in 19 hours into my bachelor's, and I do a lot of work with my community, my church, and I work for UPS. Started out as loading the brown trucks. Now I'm an OMS, which is a full-time specialist at UPS, and that consists of high-value freight. It's not the brown trucks anymore. I take care of all internationals. I have my TSA license, which helps me with working with high-value and customers that have high-value freight that we ship. So all this to say, this new career move that I decided to make is not only for myself, but it's for my family and my boys. And I definitely have moved on from a lifestyle of living paycheck behind paycheck, and a lifestyle I'm not so proud of. But like I said, this is my mess, and now my message and my testimony. And so I'm actively working with women that have gone through domestic violence, and kids that have gone through domestic violence with them, and along with adult education, because it's never too late to start that, because not having my GED never allowed me to have a career. So it's always been waiting tables, throwing the Dallas Morning News out of a minivan, and this is a huge change for me. So, and like I said, divorced 9 years ago now, 8 years ago from the ex-husband. No, they're all in Texas except for my kids. So, I'm sorry, any questions?
We will, I suspect.
Thank you.
Yes.
The
Ms.
commission only needs to consider the burglary felony. The other one is not pertinent to the commission.
Are the questions for Ms. Baker?
I have a question for the theft of property is not,
It wasn't theft of property. It was tampering with government
okay, tampering with
records,
records.
which was a misdemeanor.
Okay,
So
all right.
Ms. Taylor?
You said you had 2 of your 4 children. Where are the other 2?
They were grown, and they stayed in Texas. One is married, and the other one is not married yet, but they actually stayed in Texas with my parents, but they were 17 and 19 at the time that I moved.
So, Mr. Wood?
Are you currently licensed right now?
I have taken my national and state exam.
I guess I'm just reading her form wrong because it had a former brokerage that she was with.
It was okay. I'm sorry. I thought you said. I was with Benchmark with John Giffen, and when we got a message from Kimberly Smith, I didn't have the opportunity to. He would not come here. They said Benchmark doesn't go before the commission board, nor would he accept a new licensee at that time. So I reached out to other resources in Misty as well.
So this is just a piece of paper. It's a void. You've never had a license at
No, ma'am.
Benchmark.
No, ma'am.
So this really doesn't, if she's not ever been licensed, this.
No, I haven't.
Well,
That's
I'm
just a
just
piece of
I'm just
paper,
reading
okay.
the form, I guess, where she went and got her picture made when she passed, and on it has current broker Benchmark, and her new broker is going to be Exit Realty Elite, and I'm just trying to follow. So, but you've never ever signed up with Benchmark?
No, I did not. No, sir.
Okay.
So
They
this
were-
is incorrect.
And I submitted the new paperwork with Misty on that. I don't know. I have it if you need it.
We have a copy of that too, Robin.
So, here's what I'm curious about. It sounds to me like you've got a great job now. Why would you like to take the security of that great job now and go get a real estate license and take a chance?
I feel so confident about my outlook on the real estate, and I'm blessed, highly favored now, and have always been, but blessed and highly favored, and recognize it now. And it's a passion. I want to. My why is my children, an inheritance to leave for them. My whole family, I'm excited about even getting them involved. My boys are now interested in taking real estate and the courses and going under me, and I guess making it a freedom. UPS is a 14-hour-a-day job. And
What do you think real estate is?
They know.
Absolutely, absolutely.
You're comfortable with that decision?
Absolutely, absolutely.
All right, other questions for Ms. Baker? Commissioner Horn. Make sure you speak in that microphone. One of those two. By the way, you're all being recorded on YouTube, and that's why we insist on getting these voices as loud as we can.
I wasn't quite clear on your felony, but it seemed like you've taken care of it, taken care of yourself. Did you take care of all your fines and?
Absolutely, yes, sir.
So there's no warrants out?
Oh, no, no, sir, none at all. And the probation is everything was cleared. It was actually in Texas, and we transferred it to Tennessee, and just to close it out. Everything is complete, yes, sir.
So the burglary of the building is the felony, and you said that was your ex-mother-in-law's,
Storage unit, yes.
okay, so were y'all caught by the police, or did your mother-in-law?
My husband got away, and me and my son and my son's friend, the police did come, yes, they came. And the storage unit that was next to it, I never got out of the car, I was in the car, but I was there. And like I said, my son was there and his friend. My son's friend, and my ex-husband were in my mother-in-law's storage unit, which was his mother. They got the TV, a microwave, because they were arguing. She said she was going to sell it for some money that he didn't pay back. And so I drove over there, and we were taking back our stuff. My husband was either in the storage unit next to them or not. I'm not for sure, but the police, when they came, they said because the doors were open on a couple of the, yes.
Okay.
But now he got away that night, was arrested that same night.
I just don't know that was your stuff that was in there.
Oh, yeah, the microwave and the TV.
It was her stuff.
It was our
She didn't tell
stuff.
anybody else's. It was her stuff she was moving.
All right, Ms. Hargis, since you've indicated willingness to speak, tell us why you'd be interested in having this lady as licensee affiliated with your firm.
Well, I've spoken extensively with Robin over the last month. You know, I believe, and I think it's in my company's philosophy, to give people a chance to better themselves. And, you know, we all have stuff in our past that, you know, that we've had, and especially in an abusive situation, the mental stress that can cause, it does cause a lot of people to do a lot of different things. You know, we've talked about the storage unit thing. That was her stuff that she was moving. Unfortunately, the ex-husband and his mom were in a fight, and in that haste, the mom called the police. So that occurred. From what my understanding of talking with Robin, you know, she had no, she had no really ill will, or was not really, I think, the person that committed the crime. She just happened to be in the wrong relationship and the wrong place at the wrong time. So I'm a firm believer in giving people the opportunity. And from talking to Robin, I mean, I think she will do an excellent job in real estate. She has a willingness to help people, and I think that's one of the most important things as a realtor, that we do help people get into homes and help people. Sometimes even people that are getting into homes, they may have filed bankruptcy 3 or 4 years ago. Does that mean they never can deserve to get a house? No, it means that they need to work on their credit, and we can eventually get them there. So,
Questions for Ms. Hargis?
I'd like to know, how long have you known her?
I've known her for about a month, and one of my agents brought her into the office, and he has known her. Y'all worked at UPS several years?
2 years.
Yeah. So I've known her for about a month, and during that time, I mean, with any agent that comes in, I'm going to have very extensive conversation with them, ask them about their background and why, why they're wanting to get into real estate. Because, I mean, any broker should, want to understand why somebody wants to come and not just let them come because they have a license.
Okay, and could you tell me a little bit? I see that you've been a broker for just 3 months. Is that correct? I mean, a principal broker?
Yes, I have been with Exit for 8.5 years, and for about a year, I've owned my own office. I bought a franchise and opened my own office. At that time, I had a friend that came over to be my broker, and she had been a past broker at another office. She decided to move to Florida. And so in her decision to move to Florida, at that time I went ahead and got my broker license. So I am the owner and the broker there at the office.
Could you tell us a little bit about your training program?
Oh, we have a very extensive training program. I mean, we have coaching that is done by corporate coaching that's every other week. That's through like live interactive where they can actually talk to the coach over the web. We have a weekly sales meeting that's extensive training on different topics. We have actually, like, once a quarter we'll hire an outside trainer to come in and do different topics. So we are a firm believer in training, because I mean, I think that's the thing. You have to educate, agents as well as agents. We have to educate the public on how the process is supposed to be carried out.
And tell me a little bit about your escrow account. Are you the one that is personally taking care of your escrow account?
Actually, I have an office administrator that takes care of that, and but I do go behind and check. So yes, I do check it. I don't handle the deposits and so forth.
Do you sign the checks?
Yes, ma'am.
Okay, that's all I have.
Okay, other questions? If not, is there a motion?
I'll make the motion to allow her to be licensed.
And I'll second it.
Okay.
Okay, I have a motion by Commissioner Wood, seconded by Commissioner Franks, that Ms. Baker be allowed to continue on in her goal to become a successful real estate licensee. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Good luck.
I will make y'all all proud, promise.
Make her proud. She's
I
the one
will.
that's put
I
her
will.
neck out for you.
Because we're going to come after her first. Thanks very much. Okay.
Good luck to you.
Next up, Joseph Allen Qualls. Are you here, sir? If you'll come up with the principal broker, Carrie Mays, correct? Make sure I got that right. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Very good.
All right, Mr. Young.
Okay, we have before us Joseph Allen Qualls, principal broker Carrie Mays. Carrie Mays is the broker. She became principal broker of the firm effective 10/11/2013. Ms. Mays is responsible for supervising 71 affiliate brokers and 5 brokers. We have in record that there have been no complaints filed previously. In Mr. Quell's disciplinary actions, misdemeanor, petty theft, shoplifting, arrested February 1993, probation 36 months. Misdemeanor, petty shoplifting, arrested March 1994, probation 12 months. misdemeanor theft, arrested April 1994, 5 days in jail. And he is applying as an affiliate broker.
Thank you, Mr. Young. Mr. Qualls, you've seen how this goes. You've got the floor, and you can give us all or as little information as you'd like. Then and since then.
Okay.
Okay?
There was a time in my life at 18, 19 years old that I ended up living on the streets, living in my car, trying to better myself. The shoplifting was for clothes, to go to work and to make something better. At that time, I paid those consequences, ended up with a great job, fulfilled all my duties with that job. The last incident was in the wrong place at the wrong time, hanging out with the wrong people. There were a case of those years that I was not hanging out with the right people, and I knew that. Not at the time, but afterwards. That was a very big wake-up call when you're arrested and thrown into jail, and nobody will bail you out. At that point, that's when I decided that something needed to change. Ended up getting into the hotel industry, traveled around the hotel industry quite a bit, enjoyed my time quite a lot. Got into the restaurant industry after that because my goal was to get into the hotel industry with a restaurant. Since then, a lot of things have changed. Was married, have kids, relocated to Knoxville, Tennessee for my ex-wife's PhD, and decided to stay and raise my children there. 2003, I started my own business. I have a corporate health and wellness company. I also have a few other things. I dabble in small businesses as far as candles, antiques, a coffee shop. Have looked at real estate quite often. My mother was in real estate back in California when we lived there. Enjoyed watching that and never really got the passion for it. Finally started looking at it a lot more, got more into the passion, and decided that that's what I wanted to do. At that point, I started looking around and talking to different people. One of my friends that I work with at the community club and the fair board meetings and the business association there in Knoxville, she's a realtor with Keller Williams and works with Carrie. She said, you know, you really need to look at this company and figure out what you want to do because I think you would be good at it. At that point in talking with her, actually almost a year I talked with her about it. I finally made the decision to go ahead and do that. After I made that decision, I went in and talked to the office manager, Kim, discussed options of the company, wanted to know what their training programs were, wanted to know what their communication was. One of the issues that I had heard with new agents was lack of communication or lack of training, and I didn't want that at all. And so I've had email communications with Carrie to make sure that I have that contact. I've also talked with Alyssa and making sure that I have responsibilities with her, even though she's not with me, but I at least have a fallback person to go to if I have questions. And then again, with the trainings and getting the schedules and everything that we have at the Keller Williams office.
All right, questions for Mr. Qualls? Ms. Franks?
I'm a little confused. We have on the iPad, it says 3 misdemeanors. Is the third one the one that was a felony, the theft?
It was charged as a felony, but it was dropped to a misdemeanor.
So why would
So
we
why
even have to hear
was he
it?
here?
Probably because it showed on the TBI report felony.
Even though it was reduced?
All right, so what's the law on that?
Yeah, based on what we know, Ms. Kirby?
The ones listed on the iPad that I'm looking at are the 3 theft misdemeanors.
Uh-huh.
Right, so they're all theft, so we require them to come
Oh,
their misdemeanors for
That's
theft.
right, theft of property. Okay.
Okay, other questions for Mr. Qualls? Mr. Horn?
Yes, sir. You said that you You and your ex-wife was going to raise your 3 children. How did you phrase that?
I'm sorry?
Your ex-wife, she's, I'm sure she had partnered with you to have the children. Is she anyway in their life now?
She is in their life now. When we actually divorced in 2008, she actually moved across country and left me my children.
Left you with the children?
Yes, sir.
And you still have them?
Yes, I have them full-time.
The age?
I have a 12-year-old and a 17-year-old about to graduate high school. With my new merger, I have another 6 children.
Well, you said that.
Merger, is that what you said?
That's what I call it. My new merger.
So how many kids is that? 8, 9?
8 kids.
Yeah, you crazy.
Yeah. 12 to 30.
Real estate must be a piece of cake.
He'll fit in well, won't he?
Mr. Holman, you saw the floor.
With the shoplifting, you said you were shoplifting for clothing that you was wearing to work.
Yes.
You didn't never think about if you're working paying for the clothes.
That was for a new job, and so it was a requirement of the dress code that they had. So white shirt, black pants, and I did not have that.
In a restaurant.
Yes.
Yeah.
So you helped yourself to some, and it didn't quite work out, I guess.
It did not.
And so you were, I guess, jailed for a while, is that right?
Not on either one of those.
No.
Those 2 were just probation, and they left it at that. The other misdemeanor that was the last misdemeanor where I learned my full lesson was waiting for somebody else to bring some rims and tires. I knew what we went to pick up. As they were bringing those, the sheriff's department showed up and said these were stolen off of a car. And so I was arrested on that. He ran and got ate up by the dog, and then I ended up staying in jail.
Okay, so all of your fines and forfeits is all taken care of?
Everything's been taken care of since '95, yes, sir.
Did you ever think about getting this misdemeanors expunged?
I haven't, I mean, somebody actually talked to me about that today, that it could be. I haven't. It is in my past. I wouldn't say I'm ashamed of it. I regret doing things, but it's still my past.
If you're ashamed of it, I think you would want to get it off your record, so you wouldn't have to visit it again.
Right.
If they ask you, have you been arrested, you could actually put down no, because they don't have a public record of it. However, the police will keep a record of it in case you want to go back in business again. They'll know, you know. But the idea again, that's no sense in carrying something around with you that you can take care of. Okay, thank you.
Thank you, Commissioner. Ms. Taylor.
You say it's always been a dream of yours to open a hotel with a restaurant. Is that still out there, or is this just a fill-in thing to do, or you've changed paths?
Over the course of my life now, I've learned that brick and mortars are not the way to go. I just am not, even my little coffee shop, it's been very slow on business, and I literally open it from 8 a.m. to 10 a.m. Just so it doesn't limit my time to be able to do the other things that I want to do. And so I like the flexibility of being able to schedule things and being able to have the mobility to go where I need to be.
So am I hearing this is a full-time job or a part-time job?
If you call it a job.
I mean
The
real estate.
Oh, real estate?
Right.
No, it'll be full-time. It will intermingle with everything else that I do.
All right, Ms. Franks.
I'd like to make a motion.
Can we hear from the principal broker just for a
Oh,
second?
yes, we haven't done that.
Ms.
Sorry.
Mays, tell us what you know about this guy and why you're interested in having him affiliated with your company.
Yes, I met him.
You have to talk closer to the mic.
Come up to the microphone.
Close. I met him about a couple months ago through, like he said, Alyssa Pruitt, which is one of our owner agents in our office. And just through talking with her, later ended up meeting him face to face, and he's been great, been very forthright with his past and just anxious to get started. And some of the training, he's already started to attend some of the training and events there at the office.
All right, Ms. Franks.
And if correct me if I'm wrong, but Keller Williams does have an extensive program where he could even view education online at his own. If he has a problem about negotiation, he can pull up something on negotiation. Is that correct?
Absolutely. We have what's called the Keller Williams University, and you can go online and literally thousands of videos on different ranging of topics, and can get that information as well as PowerPoint presentations and things like that he can take to his appointments.
I'd like to make a motion that we approve Joseph Qualls to get an affiliate license.
Motion by Commissioner Franks, second by Commissioner Horn, that Mr. Qualls' application be allowed to proceed. I have a question for you, Ms. Mays, after we vote. All right. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. Congratulations. Keep doing the good thing. Now, Ms. Mays, have you found this meeting informative and helpful so far?
I'm here actually with my sister, and I made her take a picture of me outside and everything. I was like, it's great just to be here, because I've been in this industry 13 years, and I've never been here. And so I considered it a great opportunity to come and see what I talk to on, a weekly basis. So to me, it kind of brought it home. So yes.
You will agree, no one asked you or prompted you to give that answer, correct?
I agree, yes, no.
You guys have a safe trip back to
All right,
Knoxville.
thank
Good luck to you.
Okay.
Oh, Commissioner Grease, does that mean we're up 1-0? Is that what it is now?
All right, next up, Summer Harmon and Jennifer Montgomery. Who's Summer? Okay.
You solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Very good. Thanks.
Mr. Young.
Yes, Summerbrook Harmon is applying to be approved since she's passed the affiliate broker test. Her principal broker is Jennifer Montgomery. Ms. Montgomery is a licensed broker since 2003, became principal broker of Trotta Montgomery in November of 2007. Ms. Montgomery is responsible for supervising 7 affiliate brokers and 1 broker. There have been no complaints filed. They reside in Knoxville, Tennessee. The summary of disciplinary sanctions is a felony, which was vandalism of $1,000 to $10,000, arrested in November 2009, convicted in March of 2010, sentenced 4 years probation.
The other 2 convictions are not a part of this. So Mr. Young gave us 1 conviction, right? There are 2 other convictions?
Right, but only the felony was reported.
Okay, so that's all we're dealing with.
I haven't seen any of this paperwork. This is Mr. Young's process, so I'm not sure what you're looking at.
Look at his paperwork just for a second.
It's just a theft.
The theft is...
Theft under $500. Not trespassing or possession.
Yeah, so we should only be looking at felonies, or if any of the misdemeanors are theft. But doesn't sound like any of the misdemeanors are theft here. So just the felony.
The second was theft under $500.
Oh, then yes. If it's theft, anything with theft, the commission has asked to review, and then any felony.
Simple possession, nothing we care about.
Unless it's a felony, but it sounds like it's not.
Yeah. All right, Ms. Hartman, I'm just trying to get straight on what I need for you to talk to us about. So, in my opinion, based on what I've heard, the vandalism charge coupled with the trespassing and the theft under $500, can you tell us about that, and then anything else you'd like for us to know?
Yes, sir.
Thank you.
Thank you all for being here and allowing me to be in front of all of you. I had a fine Christian upbringing here in Middle Tennessee, Columbia, Tennessee. In my teen years, I had death occur around me, divorce, mental illness in my family. I hadn't developed coping skills at that point in time. So what we're looking at are the years of my life between the ages of 18 and 23. I didn't have coping skills. I turned to drugs pretty much every day of those years. I was under some influence of a chemical that was affecting, my decision making. And, with all due respect, I'll do my best to answer any questions, but a lot of it's a blur. And even if I tell you what I do remember, it's probably not exactly what happened because I wasn't in my right state of mind at that point in time. The last felony that I did receive, or I guess the only felony, the last time that I got in trouble was the felony. I believed that my life was in danger. There was someone after me, and I ran into a house that I saw that in my mind I thought was vacant. I had knocked on the door, no one came to it. So I broke out the window and went inside the home to hide. And that's where they found me, was hiding in the attic. And that was my really big wake-up call that how I was acting over those years and what I was doing to my body and to my brain was not okay. And I'm very fortunate for where I am today that I can make decisions, that I can learn, and that I can make it through school and pass tests. I am 24 hours into a bachelor's degree. I have held down really good employment. I had a job as an event coordinator with a home improvement company for 4 years. I have gone through rehabilitation, rehabs. I've gone back and shared my story there. I've gone to different drug courts to share my story with the people there, to kind of give hope, because I was in a very bad spot in my life. It was my own doing. I didn't know how to cope and live life on a daily basis. And I do believe that I do pretty well at that today. And the next step in my life, I'm very interested in real estate. One of my good friends is actually the administrator at Trotter Montgomery, and I would always see her posting, videos on Facebook and, real estate related things, and got very interested in real estate. My grandmother was in real estate, and something that I wanted to do to further myself. Obviously, I do have an extensive background. It is hard for me with a felony to get a job at a corporation or other places. They're not as kind as you, and they're not going to say, hey, come tell us your story and we might give you a chance. They're just kind of going to nip it in the bud. But real estate is something that I am passionate into growing into, and I've been very fortunate to find a company like Trotter Montgomery to work for, and that's all.
You'll take some questions.
Sure.
Okay, commissioners, Ms. Franks.
I always have lots of questions, I'm sorry. So this all was centered around your drug abuse, is that correct?
Yes, ma'am.
Okay, and so tell us what you've been doing. Last arrest was in 2008, is that correct?
I believe it was 2009.
Okay. So what kind of jobs have you been doing since then?
I got really fortunate. I've been I was a telemarketer. I moved to Knoxville from Middle Tennessee. I moved to Knoxville. That's where I went into rehab. I got a job as a telemarketer where I was at for 6 months, and after that, I got offered a really good position as a marketing manager at a home improvement company. I was marketing manager for 2 years, and then I was event coordinator for 2 years. I had a company credit card. I had access to, a lot of information there. Had a company vehicle. I actually traveled for the company through different states, which is something that my probation officer at the time allowed me to do. She had trust in me, and so did the company. But pretty much home improvement background.
And are you still doing that? Is that where you're currently employed?
No, ma'am. I'm currently employed as a trivia game show host. And I just went through, well, in order to do the schooling, it takes up about 3 weeks of, your time. So I was laid off from home improvement from my company. 11 of the highest paid management members were laid off November 4th, 2014. And after that, I got employed with another home improvement company. And it was kind of the same old thing that I really didn't want a lot of longevity in. And so I was looking at different paths. So I did go back to school, got some credit hours, but then decided that I think real estate would be the way.
I also saw on here that one of the things that you've done is taken an anger management class.
Yes, ma'am.
Is that something that was mandated by a court, or?
It was an option that we had whenever I was in rehab. After I went to a 4-month rehab facility, they only suggested a 1 month, a 28-day program, and I actually asked for the 4-month program, and then after that I went into a halfway house. And in that, we had different things that we could do. You know, we could go to church and join these different groups at the church. We could take the anger management classes. We could take the grieving classes, and those are different things that I did voluntarily.
Commissioner Horn, you've got questions.
I have a little bit of a problem with you. The drugs, I can see where the situations could cause you to go into depression and this type of thing. And drugs might have given you a temporary out. But it seemed like that you came through it all right, and you had some pretty good job. And you didn't really explain why you walked away from them. I know you said one that they went out of business or something like that. But the idea, again, what I'm saying is you were good at that type of work, evidently you was, then why didn't you look for something else along that line?
I don't want to speak poorly of anything in that business, in the home improvement business. They employed me. I got a lot of experience. I got a lot of training and management. But it's just not for me. The home improvement industry is just not for me.
How did you change?
I found God. I found myself, which was, I think, the main thing that was hiding from me. I know how to live a life of integrity and character now, whereas before I didn't. I didn't have morals and values, and now I have morals, values, goals. And I think that's the main thing that's changed for me.
But if you have something that's dramatic happen to you, you think you'll be have tendencies to go back that way again?
I do not believe so. I do have coping skills today, whereas whenever I was a teenager, I didn't have the coping skills that I've developed today. I've had dramatic things happen, and I realized that me, just like the other millions of Americans, you know, I can handle things just as well as the next person today.
How old were you when you left home?
My parents, 14.
You were 14 when you left your parents. And what did you do then? Live with others, live in the street?
I lived with other friends, families. They kind of took me in, took care of me for a little while, and then I'd, you know, go somewhere else.
Same thing to you, to ask the other person. You ever thought about expungement for your record?
Well, whenever y'all were debating on what, you know, charge we were actually wanting to talk about today, I do have more charges that are still on my record. I have had some of them expunged. The ones that are still on my record are the ones that I pled guilty to. And once you plead guilty to a record or a charge, they will not allow you to expunge it. But the ones that I pled not guilty to, I did have expunged. At the time in my life, my biggest thing was get out of jail, so plead guilty and get out. And so I pled guilty to some charges where I wish in hindsight that I would have done things differently. But the ones that can be expunged have been expunged. I worked with a lawyer about 1.5 years ago to have that done.
I think you need to research that again. Just because you pleaded guilty is not the magic trigger on that. And see if you can get your record cleaned up what it should be.
I will. I'll definitely do that because it sounded. I contacted a lawyer, and the lawyer did what he could, and that's the final result was the ones that I pled guilty to couldn't be expunged. But I will look into it more because obviously I don't want this on my record. But.
Thank you, Commissioner. Let's turn to Broker Montgomery. You basically have a niche real estate company, don't you?
I have a small office.
Would you talk about that?
Sure. I came from a larger office with my business partner. We had a lot of experience in the time that we started with our previous company. It started as a smaller company and grew to a larger company. It's the small office environment. We have, Susie Trotta and I have some what we think are really good ideas about training agents with regard to marketing and negotiation, and we wanted to put the show on the road and see how good those ideas were, and it's worked out pretty good. I think we have a pretty happy office.
So would you tell us what's attractive to you as far as Summer? I mean, she's carrying a lot of baggage. She's checking in your office. Why are you interested?
I've been an acquaintance with Summer for several years. She is very good friends with my administrative office manager, who is fantastic. Summer, I've gotten closer to Summer over the last 6 months. Because she comes and participates. We were in the Christmas parade. We put everybody in the back of my truck. We're funny, you know? And so Summer has shown up and participated in those things. She's also given me a business plan, and I'm very impressed with her marketing talent. And so to the question that was before, in my mind, she is staying in marketing. It just may not be home improvement. And she certainly has talent. On a personal level, I too struggled with coping skills, and I've managed to get to this place, and I'm very grateful for it. So anytime that I meet somebody who I can empathize with and maybe sympathize on some level, I like to extend my hand.
And
What kind of training program do you have or will you be doing with Summer?
So we do a lot of mentoring. We have Marketing Monday and Workshop Wednesday. Marketing Monday is obviously where we come in and talk about marketing. We recently, as an office, took Strength Finders test to talk about what are our strengths and how can we leverage those to help each other. Workshop Wednesday, we talk about negotiation. I'm getting ready to introduce some material that I got from Harvard Business Review that I think will be helpful and interesting things for the agents to talk about. As a small office, we're able to disseminate a lot of information and really discuss it. So I would say that a lot of our marketing is, while some of it may be on the fly, not regimented or outsourced, it's really nice what we try to do. We try to provide quality, and I do a lot of research trying to see what's useful to my agents.
Other questions? Yes, Commissioner Horn.
It seems like you're doing a great job bringing her under your wing, so to speak. But when things doesn't go well, she's having a hard time. You seem as though you came that same route. Are y'all gonna be able to work together? You're gonna work it out?
I feel very confident about my ability and about Summer's ability. I've worked really, really hard to be a good real estate agent. And before this, I went to graduate school. I did a lot of things that I didn't think I was ever going to be able to do. And that is because I've garnered some coping skills and I have good resources and I have really good support in my life now. And so I think Summer has the same kinds of support and resources that I have. And so to answer your question, I feel very confident about our ability to move forward professionally.
Okay, I've got a motion by Commissioner Horn, seconded by Commissioner Hills, that you be allowed Summer to continue on to get your license. Before we vote, I just want to tell you one thing. So I got a call, very rarely happens, from a gentleman in Knoxville who knows both of you. And he said you're both good people. I know about the company. I followed it. But Summer, I'm impressed today that I think you can do it. And that gentleman was Ed Mays, and some people don't call him a gentleman, but he spoke highly of both of you. So I just wanted to let you know that his influence is a factor, but your presentation today and your commitment to make sure this works is what's going to cause me to vote yes.
Thank you, sir.
Okay. All right, is there anyone who wants to speak? If not,
I would just like to say one thing.
Yes.
That I'm also very impressed, and I can just see it in your face that probably what you've needed all along was self-confidence, and this looks like the place that you're going to get it. And just keep going. You've come a long way, baby, and just keep going and listen to her and let her teach you and mentor you, and you're going to both be fine when that happens.
Okay, before I tear up too much more, which is okay, by the way. Let's vote on the motion offered by Commissioner Horn. That is to approve this license request. All in favor of the motion, vote aye. Aye. Those opposed, no. That motion passes unanimously. Good luck, ladies.
Thank you so much.
Thank you, guys.
Good luck.
Thanks.
11:35.
Sometimes people clap when these people, when they walk. All right, we have one more before we break for lunch. Broker Sue Acey and an applicant named Sarah Morris. Ladies, you've seen the routine.
I don't know why this lady keeps coming back.
I don't know why you gave my parking space.
Please swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Very good.
All right, Mr. Young.
Okay, the applicant before us is Sarah Ann Morse. Ms. Morse is a timeshare salesperson. Her principal broker is Sue Akey. Was first licensed as a broker in April 2005 and became principal broker of Wyndham Vacations in June of 2014. Ms. Acey is responsible for supervising 9 affiliate brokers and 127 timeshare salespeople. The firm is Wyndham Vacation Resorts in Smoky Mountains. The summary of disciplinary sanctions of Ms. Morris is a felony Schedule 1 drugs. Arrested January 2003, convicted July 2003, suspended jail sentence and probation for 2 years.
Thank you, Mr. Young. Ms. Morris, give us the details.
Yes, sir. Thank you guys for your time, first and foremost. I'm usually really good at speaking in front of crowds, but my hands are sweating uncontrollably right now.
Would you like to stand up instead? You
No,
can stand
that's
up
okay.
if you don't.
No, because then my knees might get weak.
Okay.
I will talk about this briefly. In 2003, when I was charged, you'll see the charges itself were very, very high, but they dropped them down to only 2 years of probation. Everybody that was there got charged because nobody would claim it. At the time of my arrest, I submitted several drug tests, just showing that I was not a drug user or anything like that. I was in college at the time. I've learned from my mistake hanging out with the wrong crowds. I'm sorry for who I was hanging out with, and that was 13 years ago. Since then, I've been with Wyndham. It's going on my 9th year. I'm very, very proud of what I do. I bleed Wyndham blue, Sue will tell you that. I've been promoted several times. Last year, I got one of the highest honored awards that you can get with my company, winning the Pinnacle as the highest grossing manager with that company. Right now, I do have about 9 employees that are underneath me, and we're talking about military folks, single mothers, students who are dependent upon me. This experience coming from Washington, D.C. in the last 2 months has been a very, very humbling and embarrassing experience. And like I said, I am sorry for it, and I want to work.
I just want to say that when she says that she's been working with Wyndham, she's been working with Wyndham at different locations.
In Washington, D.C. Apologize. Yeah. I just transferred from Washington, D.C., like I said, my 9th year in the company, and trying to get my license.
So the event you were arrested, was it a big pot party or what was it? What was going on?
Oh, no. I was actually in school and was in Myrtle Beach at the time, and yeah, it was a big party. And at this situation, like I said, nobody would claim that, and so several people got in trouble for it.
So I still don't, what did the event look like? Was it at a house?
Oh, yeah. Yes, sir.
And the police were called?
Yeah, I mean, bonfire, all that good stuff.
But you weren't in possession, according to your testimony.
I was there, yes, sir. Yes.
I got that part, but it's okay. I'm pretty cool with it. I've probably been at a few of those parties myself at one point. But
I'm sorry, maybe I'm not understanding the question. I apologize.
All right, questions, Ms. Hills.
So I'm familiar with Alexandria, Virginia, and I'm familiar with Great Smoky Mountains. So why did you move?
Got a promotion.
Okay.
Yeah.
Is it subject to you getting a real estate license?
Yes, ma'am.
Okay, and so what exactly was the felony charge?
Cocaine.
Okay.
All right, other questions? Yes, Mr. Horn.
He asked you, was it in a house, and you said yes, the bonfire and everything. You had a bonfire in the house, did you?
No, no.
all your fines and forfeitures been taken care of?
Absolutely.
You looked at the possibility of expungement.
In the state of South Carolina, you cannot have it expunged if it's a felony. I tried to do that several years ago, and actually, when this took place, I tried again, but they won't do it in the state of South Carolina. Believe me, I want that off my record. It's embarrassing.
Reason I'm concerned about this, I have a program in our church where we help people get expunged if they want to get it. And it can be done, let's put it that way. I don't want to teach or preach expungement, but if you want to get it done, it can be done, okay? This is the only time that you had any dealings with drugs?
Yes, sir.
And one time it went bad on you?
Yes, sir.
Okay. And what happened afterward?
Well, if I can give you an example, my hobbies, I'm really big in the health and fitness. So that's just not with my lifestyle. And you asked what happened afterwards? I did 2 years of probation. I did community service for the firehouse. I paid all my fines and continued on with my life, and I never looked back.
So how did you did you meet your broker?
Through my promotion.
Promotion?
Yes, sir.
In the company?
Yes, sir.
Okay. She a nice lady?
Sue?
Yes.
That's Mama.
Thank you. Other questions for the applicant? All right, Ms. Acey, we will let you talk, but so, I've tried to understand timeshare and different positions. There are people out on the street, and there are people that once you get them inside, and then there are people, where will this lady fit in? What does she do?
Working with
Come up here where we can get this recorded.
She will be working with people that actually already own timeshare. They just don't own with Wyndham. So we're trying to convince them to move into the Wyndham atmosphere.
So, to go back to the people that are on her team, or the retired military, are they in Gatlinburg too, or where are those people?
They're in Smoky Mountains.
Okay. So, you want to give us a good reason why we ought to let this thing slide and let this lady get licensed in Tennessee?
Okay. First of all, it was like 13 years ago when she was in college. She's grown up a lot. She now has a daughter that she supports. She's a single mother. She's worked with Wyndham for 9 years, doing the same thing with Wyndham, basically. She's been in sales the whole time. She was in sales, and then they promoted her to manager, and she moved up to a senior manager with us down here as soon as she gets licensed. She's had a very, very good record with Wyndham. And my good nephew knows her and has known her for about 5 years. I have some nephews that are not so good, but she knows the good one, and he speaks very highly of her. He worked with her in Myrtle Beach, and he's done some work we're in the same business unit, and he's done some work with her up there, up in the north.
Okay, so how's timeshare business in Gatlinburg?
Well, it's slow right now, but it's picking up. It'll pick up probably about the 15th or so, and then we'll be busy all the way through to December.
Other questions? Mr. Chara?
Yes, I have a motion that we allow Sarah Ann to get her license and move forward.
Call me Sarah Ann.
Sarah Ann.
Sarah Ann.
All right.
It's a nice southern name,
I have a
right?
motion by Commissioner Chara. Did you second that, Diane?
I think Frank said.
Marcia did. Okay, seconded by Commissioner Franks. Discussion on the motion. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Good luck, ladies.
Thank you guys so much.
Thank you for your time.
We're glad you're in East Tennessee, Sarah.
Thank
It's
you.
a good place. It's a great place to be. All right, we can, if you'd like, and I think we would like, to go ahead and take care of the education report before we break for lunch. So, without objection, let's go to the education report. And Mr. White, if you will.
Mr.
Chairman, let us
Members of
know.
the commission, thank you for your time this morning. I'd like to submit the Tennessee Real Estate Commission Education Agenda and report all the courses, the instructors and providers, and submit that M1 through M19 be submitted for your approval this morning.
Motion to approve.
I have a motion by Commissioner Franks, seconded by Commissioner Taylor, that courses M1 through.
That was me that made the motion.
Did you not say? Oh, I'm sorry. Motion by Commissioner DeChara, seconded by Commissioner Taylor, that courses M1 through M19 be approved per the recommendation of our education director. Any discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. White.
Thank you, Mr. Chairman, members of the commission. I would submit also the instructors I have reviewed in the same report, M1 through M19. Those previously approved, but several need approval from the commission.
Is there a motion?
Move to approve.
Motion by Commissioner Franks.
Second.
Seconded by Commissioner Wood, that those instructors recommended by Mr. Ross White be approved. Discussion? All right, let's vote. Those in favor of that motion vote aye. Those opposed, no. That motion passes unanimously. Does that conclude your report, Mr. White, or do you have more for us?
I don't have any more for us this morning. I appreciate the commission and its attention to the report this morning.
Thank you. We have a question for you from Ms. Hills.
So how difficult will it be for you to provide the commissioners with a list of courses, the hours that have been approved for, and their titles?
As far as a listing on the internet, or just?
That we would be able to reference?
I've been working with IT this week, and of course during the last several months, and we've made some inroads. There's a prototype that would have all the providers, all the courses, and all, well, providers and courses, and those provider numbers and the course numbers and so forth on our website. So that would be available hopefully shortly. I'm working with IT on that right now.
Could we have that so that it stays on our page?
Well, there's hundreds and hundreds of courses. What we'll have to do, I think, is just say, okay, this is a property management issue. I think they need a course in property management, and it'll be up to them to find that course.
Ross, can you come up with a list of like the general categories of courses?
Yeah, that would be.
Like we have courses on contracts, on ethics, like just general topics that they can pick from if they choose to put it in the consent order.
Certainly, I can work with you on that, Mallory, and we can make that happen.
Thank you.
You could work with us on that too,
I can
right?
work with the commission on those.
So when we go down that road, if we go down, Mallory, if we go down that road, what we talked about this morning, I'm seeing, we're gonna need to be specific as to what class. And there's lots of contract with different names, and there's lots of negotiation with different names, lots of property management with different names, so.
Or you could reference core courses.
Yeah, that's just going to be hard to do
I
on
mean,
the
are
fly
they
with
gonna take core
each
class
different,
twice? Yeah.
with each consent order.
When we talk about that this afternoon, that might be something we need to discuss.
Other questions or comments for Mr. White? All right, we're going to take a break for lunch. We're going to come back at 10 after 1 o'clock. All right, we have 2 more informal applicants, then we'll get the legal report. So please be prompt. And I think you're supposed to initial on the way out, right? Make sure you're in the Department of Commerce and Insurance. You will see, I assume, 2 litigators tomorrow because we have 2 cases to hear.
Just one, I think.
1 case?
One case or one litigator?
Both.
What
Oh,
happened to
one
the
of our
second?
cases got canceled.
Well, there were 2 that were same facts, two different respondents. One was represented, one wasn't, so they were going to be two separate ones. Well, one of them got continued, so I believe the other one also got continued with it, and so there's just the one.
It's in the morning?
Yes.
How was that originally scheduled? One in the morning, one in the afternoon, or how'd that work?
I actually think they were both scheduled for the morning so they could go back to back if necessary. So there wasn't like a big gap if the other one had gotten continued or something like that at the last minute. I think that's why they were scheduled both in the morning.
All right, Ms. Ryan, I don't hear anybody objecting to you talking.
I'm
So
glad to hear nobody's objecting.
it's unusual, but you go ahead.
What I have before you today is an agreed order that I'd like your insight or comments and your approval. I don't want to go into too many details because it is a litigation matter before you at some time this year. So I don't want to prejudice you all for hearing in case you don't agree. But what we have is a very different, the issue was unlicensed practice, and we have a very different opinion that is not outlined in the law the way we'd like it to be about when a license is needed. So the original consent order provided for a civil penalty of $2,000, and that, and of course that they didn't do anything in the future without getting a license. And that is what has been accepted, except that the language of the agreed order says that the parties are in disagreement about the laws, and it doesn't call the $2,000 a civil penalty, but just provides it as a payment. I can tell you, I think that this, like many other cases before you, involves an issue of LLCs, and I can tell you there's not just a difference of opinion between us, but with judges as well. My opinion is, it is what you asked for, and my opinion is that you should agree to accept it, and then we can have it put on, and then you don't have to have the hearing on that matter.
I'm pretty confused. So is this something that's going to come before us regardless of what we do today?
No.
This takes care of the issue.
If you do it today, it will not come before you.
They've agreed to those terms?
Mm-hmm. They have.
And so why did we make those terms instead of what we normally do?
Why did I agree to it? Well, because there is a disagreement about this particular law. It is not black and white at all. And because it's unclear, it is, in my opinion, it's to the benefit of everyone because they're agreeing to pay and because they're agreeing not to do anything in the future that requires a license and not get a license, that this is not a question of the public being hurt or anything, that the interests of the commission and licensees are protected, and that's why.
When I first came on the commission, something came up about the LLCs. And having several LLCs in my family business, I asked for an attorney general's opinion on it, and they gave that to me, and it was pretty black and white and absolute.
No, it is not. Unfortunately, it is not as black and white and absolute as what you'd like.
According to who?
Well, in reading it, in all of it. In this particular issue, I will tell you, a judge has found that the law does not apply. I'll also tell you that in this particular issue, this is something that the legislature could or somebody else could clarify, but that's how it's being viewed. So I can tell you that it's not black and white.
So what's the benefit to the respondent to get his way or her way regarding the language?
Well, he has a very expensive attorney, and in this particular instance, there is an agreement that if there were any future sales, that there would be a license involved. So the benefit to him is not having to spend more money on an attorney, and the benefit to him is he's already agreeing to do this in the future. The benefit to him is not having to, which I expect would happen if this were heard and he lost. I expect it would be appealed, so there's a huge benefit in saving money there. And he is agreeing to do what we've asked him to do, which is be sure there is a license, and he is paying the civil penalty as requested, in addition to $200, which is the court cost of this matter. Can you tell us how much the civil penalty is? $2,000. It's exactly what was requested.
What do you need from us?
Motion?
Yeah.
I make a motion that we accept the agreed order as presented by Ms. Ryan.
A motion by Mr. Char, a second by Mr. Horn, that the motion as presented by Ms. Ryan be accepted and ratified. Does it set a precedent at all?
I don't think it does, because it applies to the circumstances of this case. The facts are pretty clear about this case. I had Ms. Kirby review it as well, if you want to ask her opinion, but I had her review it as well before we went forward with it.
I would like to ask your opinion, Ms. Kirby.
In terms of substance, I think that it's still one of those gray areas, like Robin was saying, because we do have the Attorney General's opinion on one hand, but we also have this judge's ruling that's going the other direction. So I think it is a little bit of a gray area. However, I think in terms of like the best use of our resources, because of what they're agreeing to is what was initially authorized by the commission. The agreed order really is just changing some of the language to say we disagree, but we're going to pay it to make it go away. So in that case, I think it probably is the best use of the resources to go ahead and approve it.
So,
and back to the question of precedent, because it's a gray area and because the facts are specific, I don't think it necessarily sets a precedent, because another issue can come by with different types of facts, and they could look at it and say here, and we can say, well, the facts aren't the same.
It also doesn't say we're agreeing with the other party.
No.
It just basically says we agree to disagree, but we're paying the money.
Right.
That's it. There's nothing they can hang their hat on.
No.
Next time.
Because we're not saying we accept their vision of the law.
I mean, if you wanted to know exactly what the language is, I'm sure Robin could read it to you.
Do you want to hear?
No, not necessarily, especially if we don't get a positive vote.
Well, okay.
I'm just concerned.
The next person is who I'm concerned about.
Yeah, that's it. And the home builders, realtors.
Here's what the state asserts that the respondent's actions are in violation of the code, but acknowledges that the parties disagree as to the application of the law regarding the acts of this respondent. However, respondent is agreeable to complying with this order in the future as set forth. That's why I don't think it sets. It is specific to this set of facts. Now, mind you, you know me. If you want to go forward with the hearing, I don't have any problem with that. None.
But if they're going to appeal it again, so.
Well, I would expect that. I can't say absolutely that would happen, to be honest with you, but this is a very well-known attorney that I would expect that because of one hand, we've got the judge saying absolutely no, it doesn't, and I would expect she would appeal. Now, mind you, maybe that's a good thing.
Clear it up.
Yeah, at our expense, but it might. A better thing would get the law changed somehow.
Tell us what level of judge we're talking about.
I prefer not.
Okay. Not like Court of Appeals or anything. I know, you can't tell.
Not yet.
All right, you've heard the motion. Any other questions before we vote? The motion.
I would like to
Yes,
ask one
I'm sorry,
question.
Ms. Taylor.
Just to make clear that I understand that both of the attorneys are suggesting that this is the way to go. Is that correct?
The facts of this case were before I got here. So as far as like this specific case, I can't really speak to that. But as far as whether I think it's the best choice to accept this order or to go forward with the hearing, I think based on what they're stipulating in the facts and the fact that they're agreeing to pay the money that was authorized by the commission, I think it's probably the best choice.
Okay, other questions? Are you ready to vote?
Yes, sir.
Let's do it. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Your request has been granted.
Thank you. I'll see you again sometime.
Not if you keep working these deals out, so we don't get to watch you work.
Sorry. I'll try to not do that again in the future.
Okay. All right, we're back to the agenda, and I'm looking for Mr. Rory and Principal Broker Kurt Steckel. Are you here? Gentlemen, please come forward.
Which case is this? I'm not seeing.
You will stand for a second, raise your right hand, and answer this lady's question.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Very good.
All right, gentlemen, if you'll both have a seat. Mr. Young is going to give us a quick synopsis of the issue, and then we'll ask you some questions. Mr. Young.
Okay, let me give you background on the applicant Martinez v. Rory. Mr. Rory has passed the affiliate broker test. The principal broker is Kurt Stayer. He was first licensed as broker in November 1992, became principal broker at Keller Williams Franklin in June of 2009. Mr. Stayer is responsible for supervising 259 affiliate brokers and 20 brokers. We show that no complaints have been filed. The firm is Keller Williams Franklin. The summary of disciplinary sanctions is the license has been revoked for lack of having errors and omissions insurance, in which he needs to appear before you today. And the letters of statement and letters of recommendation can be found in your iPads.
Let me just clarify one point. The license that was revoked because of the E&O. So just to refresh your memory, the statute says that once you've been suspended for E&O for a year, your license is revoked. So that license was a timeshare salesperson license. Mr. Rory is now applying for an affiliate broker license, if I'm correct. That's correct? Okay. Yeah.
Does that make any difference to us?
It's still a prior disciplinary action by a state agency. It's just a different license, so that part doesn't matter. But it's because he's been disciplined on his previous license.
All right, Mr. Rory, would you like to tell us how come errors and omissions insurance was not renewed?
When I was at Wyndham,
Please speak into the microphone.
Right here?
Yes, sir.
Okay. Yes, sir. When I was at Wyndham, I was there for about approximately 6 months. I was laid off. I wasn't aware that I had to maintain errors and omissions insurance, and when I was laid off, I figured that was it, as far as my responsibility there.
Did Wyndham provide the errors and omissions insurance?
Yes, sir.
So when you weren't affiliated, that insurance didn't follow you?
That's correct. I believe that's correct.
All right, questions for Mr. Rory?
So were you working for a different timeshare company when you were laid off from Wyndham, or were you just not doing anything in the real estate industry, or what was going on?
Latter, I wasn't doing anything in the real estate industry. I was not working for anyone.
What is it that we have here that you have signed from the state of Tennessee about a party? What,
Apologize?
about a party in 1986? What is this?
That was,
Hang on a second, let me. Do you have that? Mm-hmm. I didn't know what was relevant about this. It may have nothing to do with this. That's not relevant then, right? Okay.
How did, may I ask a question?
Sure, absolutely.
How did you become aware that your E&O insurance had not been enforced?
when I applied for an affiliate broker's license, that's how I became aware of it.
So your E&O insurance was in force as long as you were with Wyndham, or it expired while you were with Wyndham?
It was in force while I was still there. So when I left Wyndham, expired.
But your real estate license was in effect during that time?
Yes, ma'am. I didn't retire it, if that's what you're asking.
Yeah.
Ms. Kirby, should we make a difference between a timeshare license and an affiliate broker's license?
They're both under the Broker Act with very similar requirements in most areas, including the E&O and the retiring of the license and all of that.
Yes, Mr. Horn.
Sir, I'm a little bit disturbed. Of course, I have a airline pilot's license. Now, the limit of my license is up to me. I'm the one that needs to know those limits, and when they are good, when they expire, when they might be expired, etc. And I have a little bit of doubt is why you didn't take the time to research the limits of your license. Could you shed some light on that for me?
Only thing I could say to that is, you know, I was employed by Wyndham. They required us to have a real estate license, a timeshare license. That's what they required us to do, and I followed that. I did everything they asked me to do. They laid me off. I was not aware that I was supposed to maintain errors and mission insurance. Again, when I was laid off, I was looking for new work, new opportunity, and that's all I can say about that, sir.
When does your driving license expire?
One more time?
When does your driving license expire?
I don't know.
You might be driving. Could you look at it and see if you're driving on an expired license?
I'm pretty sure I'm not.
Okay.
But,
All right. You see, I'm not trying to make fun of you.
Sure.
What I am saying is you have a responsibility to know the limits of your license. You have a responsibility to know what your insurance binder will tell you can do and what you can't do. So just that, I didn't check to see what somebody else said. That doesn't get it for me. You have obligation to know these things yourself.
Thank you. I appreciate it.
Other comments? Yes, Ms. Franks.
Did you pay your E&O yourself, or did Wyndham pay it for you?
They paid it, ma'am.
That's the problem.
Bobby?
And then I guess my question, when you left Wyndham, does the timeshare license work just like, I'm going to call it regular residential sales license? I mean, if I were to dismiss an agent, I would sign their license, give it to them. Is timeshare the same way, or?
Yes.
So if they're laid off,
They get their license back.
they actually give them their license back? Or do they send in a release?
They should. I mean,
Do they send in a release to you when they lay?
They should.
they have all the same requirements as.
Okay.
The only license that has a slightly different requirements, like acquisition agents aren't required to have E&O. So that's a little bit different there. But as far as the timeshare sales people, they fall under the broker requirement, affiliate broker and broker requirements.
I was just this would have been a broker release at the time with the state. We got notice from Wyndham that he was broker released.
I assume so.
Or not. They could have given
I
him
mean-
did they give you your license when you left?
Ma'am, they did not.
That's a problem.
That's
If
what
I may.
That's what I was gonna say,
Yeah.
is that they are required to give him his license, and he has to do something with it within a time frame, or it
Also
goes away.
expires.
If I may, I would suspect that if there were other Wyndham timeshare brokers or excuse me, agents that desire to become an affiliate broker, you probably run through the same thing because they don't have an exit interview that walks you through anything as far as what your requirements are for your real estate license and insurance. So
How long were you with Wyndham?
yes, ma'am, I was there for approximately 6 months.
So what do you know about the insurance policy now?
I know I need to have it in order to sell real estate, and and as far I'm responsible for it. So with that,
Mr. Steckel, what's your company's policy about insurance? Do you keep track of your agents? Would you just talk to the microphone for us, please?
Every one of our girls one of the girls takes care of following up on the license, E&O insurance. It's reviewed every 30 days within her office to make sure everybody's enforced.
Use the state's insurance, or do you have your own,
No,
policy?
Rice Insurance.
Okay.
Every state's.
So on the surface, this sounds like a good fit. Mr. Rory hasn't been keeping up with his errors and omissions insurance, and you will keep up with his errors and omissions. Is that?
Correct. That's correct.
I think there's more to this than to me meets the eye here. If he's never been released from Wyndham, that's an issue.
But just
Mr. Steckel?
When was it released from Wyndham? What year was this?
2012.
Well, that's why his file is flagged, because if nothing happens, they flag the files.
Right. So if the license doesn't get retired, then it's still in our system that the E&O needs to be updated. And then when it's not updated, it goes into suspension once it's expired. And then after a year, it gets revoked.
So it's as if Mr. Rory is starting over.
Right.
Except there's that little flag that says, one time in the past, he wasn't current.
One time in the past, he had his license revoked, which is technically a disciplinary action, which is why this is before you now.
Is revoked based on the calendar, not on the action his commission took.
Correct. It's just an automatic revocation with the E&O expiration.
So if his license would have expired prior to the E&O expiring, then there would not be this issue, correct? His license would have just expired.
No, because a license that's expired doesn't automatically go into revocation.
That's what I'm saying. So if his license had have expired before the lapse in the insurance policy,
It would have just say
it would have
expired.
just say expired. It wouldn't have been revoked.
It
or
wouldn't be
anything.
flagged.
It would just
No,
be
it
an
still
expired.
would, because when it came for the E&O to expire, it would have then gone to automatic suspension.
Even though it was an expired license? That's
Where
not
we are
right.
with the dates not matching.
Expired license don't go
Ms.
into
Kirby,
revocation, do they, Malcolm?
No, expired
That's what I'm-
licenses
That's
don't.
what I'm saying. If his license would have expired, say in July, and then the insurance would have lapsed at the end of the year, he would have just had an expired license. It would have not.
I think it would change from expired to suspended at that point. Because even if he has an expired license, he could, up into a year, pay the fee and get an active license again. But then he still would have expired E&O, which would put him into suspension.
I'd like to know what real estate school that you went to. How did you get your license? What school did you go to?
Yes, ma'am. CLI, Continuing Learning Institute, located in Green Hills.
Commissioner Horn?
Yes, I'd like to ask a question to Ms. Kirby, if I could.
Yeah.
When somebody is in limbo with their license like that, is it customary for the state to send them a notice or something of that nature?
Yeah, so the statute for the E&O, the statute requires a letter to be sent when it's suspended, as well as when it's revoked.
I don't recall.
The broker would have, for sure, but he wasn't working there anymore.
Yeah, it may have usually notices get sent to the last known business address, because that's what they're responsible by statute to update with us. So that's probably where it got sent. Now, those letters are just notifying you what has happened, not saying, here, you have such and such amount of time to do this. It just says this is an automatic thing that's happened, and just notifying.
Ms. Taylor?
So the letter is just sent to his business or to him also?
I believe that it's only sent to the business address, because by statute, the licensees are required to update us with their last known business address. And so we send everything to that address, which would be the firm. So if he wasn't released properly from the firm, then it may not have, or if he didn't update his new address with us when he left the firm, then it may have gotten sent there. And we wouldn't have known that it didn't get to him unless it got returned to us, which we don't have record of in the file that it got returned to us. So.
And how long you said you worked for them for 6 months, but had you worked at any other place before them? So your license was only 6 months old then when you left them, correct?
Hadn't worked anywhere else, no, ma'am.
So your license was just
Right.
6 months old?
Yes, ma'am.
Had you gotten your continued education and everything that was called for in that 6-month period?
At Wyndham?
To keep your license?
Yes, ma'am.
You had?
I did everything that I was required to do to maintain that license appropriately.
New license usually requires additional education within a time frame, so.
I'd like to move this thing along. I'd like to make a motion, we allow this gentleman to be licensed.
I'll second that.
All right, we have a motion and a second. Any questions for the principal broker to be?
I want to know how you manage 259 affiliate brokers.
I have a staff of 7 people in the office.
7?
7, just office staff, just to help me monitor licenses, checks and balances in system. And those are reports they give to me, and I review them periodically on that part, every month. I do, yeah.
And I will say this, because I'm from Franklin also, that his company has a very good reputation, and I've not seen people coming in here from his office.
It amazes me he has that.
No,
many.
I couldn't do it either, but
I'm amazed by that.
Let's vote. I'm sorry, Commissioner.
Sir, what do you do if you find somebody's license is in jeopardy?
Or
Yeah, whatever.
I personally get involved in that.
Money?
Once it's brought to my attention, I am personally involved with that, and where that agent will come to my office that day or the next day, and we'll sit down and find out what's going on. Yeah, I'm personally involved in that.
Have many involved much?
Problems?
Yeah.
Not that many. I'm hands-on. I'm hands-on.
All right, let's vote. If you're in favor of the motion to let Mr. Rory continue on with his licensing, you'll vote yes. If you're opposed, you'll vote no. All those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Congratulations, sir. Good luck. Mr. Steckel, can I ask you an unrelated question?
Thank you.
You're familiar with the new rules of the Real Estate Commission, correct? What's your opinion in general about them?
I'm excited about it. I like change. We are very thorough and organized at our office for training and presentations. My question might be to the commission to say, who polices the follow-up for the new changes? And my comment was from somebody before, says, it's up to us to police our peers. And we're observing a lot of that going on out there, but we are very strict in what we try to do in our office, to do everything per the new rules, and we pride ourselves on that very much.
But you think the rules help you in your management of your agents?
Yes.
Okay.
Very much so.
Perfect.
Yes, very much so.
All right, sir. Thanks for coming.
All right,
Good
thank you
luck,
very
sir.
much.
Thank you for your time.
Jenica and I just looked up the E&O expiration thing just to clarify. So if the license expires before the E&O expires, I don't think it would get automatically suspended, but as soon as they wanted to go back active, they would have to pay their,
Okay,
like they
that's-
wouldn't be able to go back active until they paid their
That's
premium.
what I thought, and I just wanted to confirm that.
Yeah.
Okay, thank you.
Because it's required for active licensees, so.
So once an attorney starts talking and you've got your vote, I would leave. I wouldn't stay around.
Have to tell me twice.
Don't stick around to say.
All right, next up, Ricardo Page and Principal Broker. I've got a duplicate name.
He's
Yes.
applying for a principal broker license, so or a
Oh.
broker license, so he won't have a principal
not a
broker with
mistake.
him.
Okay, so
Sir, may I ask permission? My name is John Page, and I'm brother.
Would you talk into the microphone, sir, please?
Excuse me. I'm asking for permission to sit up here with my brother. My name is John Page, and I just recently became licensed as an affiliate broker. My brother's applying to be a broker in Tennessee, and I would like to work for my brother, so that's why I'm here today, if that's okay with the commission.
So it's fine with me if you sit up there. I'm not sure that we need your input, but you may have something to add. All right, Mr. Young.
Oh, I need to.
Oh, yeah.
Swear them in.
Mr. Ricardo Page, if you'll raise your right hand, listen to this lady.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I affirm.
Very good.
All right, Mr. Young.
Okay. Applicant Ricardo Page. Mr. Page has passed the broker exam and is applying to be a principal broker. He is actively licensed in Illinois as a managing broker. According to the Illinois Department of Financial Professional Regulation website, Mr. Page's license has never been disciplined. The firm is Mr. Page has applied for a new firm license for Page's Star International, which is pending with Mr. Page's broker application. Summary convictions: Mr. Page was arrested on November 26, 2004 for retail theft, a misdemeanor in Cook County, Illinois. He pleaded guilty on February the 10th, 2005. Mr. Page was sentenced to 1 year of supervised probation and was discharged on February the 9th, 2006. And you have information on your iPads on the applicant.
All right, Mr. Page, so you want to open up a brokerage firm in Tennessee, or you are living in Illinois?
Say it again?
Where do you want to open your company?
Why do I want to open it?
Where?
Where? We've got an address now, but we're going to probably get a formal office if and when I am approved to get a managing broker's license. We have a corporation already in place.
Without being specific about the address, what city or town? Where do you expect to have your office?
Right now, it is at my house, and I live
I
at
need to be
536
testifying.
Madison, Tennessee, and that's where we have the address officially notified.
So
that's where it is right now until such time my brother becomes licensed in Tennessee, and at that time we may get a freestanding office. But for right now, we're working out of my home.
just logistically, were you sworn in?
No, it wasn't. But
Okay, would you, if he's going to testify, we need your name and address for the record, and please answer this question.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, so I'm going to go back to Mr. Page. Madison, Tennessee, is that where your office will be?
For now, correct.
Yes.
I'm a little bit confused.
Go ahead,
about-
Ms. Franks. I'm not making very much headway.
Okay, so do you have an affiliate license in the state of Tennessee now?
No, I've done everything, fulfilled all the requirements, but I'm having this hearing for the commission to ascertain whether or not to go ahead and process my application. I've done all of the educational requirements. I am a managing broker in Illinois and in Indiana. I'm before you today because my brother, who has been an executive with Centerstone, which is a non-for-profit, is retired now, and really wants to get into investment real estate, and that's something I've been doing for a very long time, and I want to teach him all of the aspects of practicing and of investment-grade real estate, the sale of investment-grade real estate.
And where will you do that?
Well, he will be here. I will go back and forth when needed. Now, I have a lot of clients that are right here now in the state of Tennessee. They own properties in Illinois and the other places that I do business.
Where's your residence?
My residence is in Maywood, Illinois. Right.
Where
And
is
I'm
that?
applying
Where's
for an
that?
out-of-state managing broker's license. I mean, I've done all of the proper applications.
Where is Maywood in Illinois? Northern?
Next River
southern?
Forest, Oak Park,
So what
12
are
miles from downtown Chicago.
what are the requirements for someone who's from out of state who wants to be a? First of all, we don't have a managing broker's license to begin with. So what are the requirements that he says that he has met?
When I received his file, he had already passed the broker exam. So
Okay.
staff has to approve the education and stuff before they can be able to take the broker exam. So I assume that he's met all those requirements in order, because he was able to sit for the exam. I don't review those, so I'm not sure. Maybe Ross did.
So what's that process?
You review the education requirements. Staff does that, so they'll have to answer that.
Yes, I did look at the education requirements
Ross,
as
would-
far as.
He's got this one. He's got this one.
Got it going. So it's covered under the current rules as far as for the commission's benefit. You can look and see what types of courses would have to be included in that laundry list.
So he's here because of his offense that he did then, is that correct?
Right, that's the only thing the
That's the only
commission
thing
that's
we're
in front of
here
the commission right now. It's just that he had a conviction that came up on his FBI report.
What state was that conviction in?
Illinois.
Is in Illinois.
Okay, and what were you, did you plead guilty or what?
Well, what happened was I was at a retail outfit, Menards, and I was dealing with a lot of tile boxes, and I had a, what do you call it, a tile snip in the package, and I couldn't manipulate with both hands. I put it in my back pocket. I kept on filling my float with the stuff I was getting. Got up to the counter, and then I had been talking to some other people and just forgot I had it. So when I went out I had paid for all my stuff, got past the counter, the guy stops me, said, "What's the matter?" And he says, what's in your back pocket? Oh, I tried to explain to him. He didn't want to hear nothing about it. I mean, he just didn't want to hear nothing. So after the process was done, and my lawyer said, well, and another thing, in Illinois, I don't know about this state, but Illinois, when you get a supervision and it's terminated satisfactorily, it is not a conviction. Now, you don't have to take my word from that. You can call the state's attorney's office in Cook County, and they'll tell you that. But
This was Chicago?
Yeah, in Cook County. And so rather than go to trial, my attorney said, well, I mean, I didn't want to take the chance of being found guilty, and then wind up getting some time. So I did what the attorney said. I pled guilty, and I got supervision. And it was completed satisfactorily. And I'm one of the biggest customers today, Menards. I have a Menards and even the manager knew me, said, I'm sorry that happened. This guy was a flake, the security, not even a Menards employee, that's a, what do you call it, a contract security outfit. But anyway, that's what happened. And I'm standing here before you. I've had a lot of things happen in my life. I have a past. Everybody's got a past. But one of the biggest things that has changed my life is that I got saved and I gave my life to Jesus. And I have been living for him for 30 years. I've been witnessing and winning souls for the kingdom. I'm very successful in my business. I've got some of the most reputable companies in the world that are doing business with me. I could have got you 100 references, but really, and I've sold a lot of property. I would say close to $350, $400 million. I have impeccable references. I have never violated one ethical, anything ethically in the profession of my business. Never.
And that is what is before us at this time. The only thing that I would like to say is some red flags have gone off in my mind. I'm a principal broker. It's a principal broker, not a managing broker in the state of Tennessee. I want you to be very careful about your office. And if you're going to be the managing broker for anyone, how, you're going to have to come up with a plan of how you can manage someone in another state.
Oh, we will.
Okay.
We will. And
But before us today is just whether we're going to let you get your broker's license because of this offense that you did.
right.
Okay.
That's,
Ms. Hills.
but in your response, I have a question. So does your brother have a license now?
And he's got it. He got it, but it's retired right at the moment because he has to be under a principal broker.
Well, I
said
understand that.
managing broker.
Right.
Principal broker is what I meant.
I understand that.
And
so,
I would be the principal broker.
So your brother has an active license right now?
If I may answer, yes. I have a license, and I put it into retirement as I've been waiting for my brother to finish this process to get his principal broker's license. So, yes, it is. I do have a license. It's in retirement right now. And for your information, it expires August 30 of 2017. But that's what it says on the license itself. But it's in retirement status right now. Yes. Does that answer your question?
Yes, so you were with another company and you put it in retirement?
No, ma'am. I have not worked for anybody. I got licensed in August.
How did you get an active license if you've never been under a broker?
Let me explain. Let me explain. I went through all the,
Retirement for 6 months.
I went through all the classes. I took the test. I finished all that work by August. That's when I got my license. But I was waiting for my brother to get his license. And after a couple months, it seemed like, this was going to be a protracted process. So I went ahead, someone in the office with TREC advised me, why don't you just go ahead and put it in retirement status while you're waiting, because we don't know how long it's going to take.
Start over.
So that's what I've done. So I've not worked for anybody, and I don't plan on working for anybody. I'm planning on working for my brother if he gets this broker's license. Otherwise, I don't plan on going into the field. I'm doing this because I want to work with my brother. I hope that answers your question.
You live in a commercial zoned home? Is your home?
No, ma'am. I live in a residential section.
So
but I
you would
got
have
it-
to get a building in proper zoning.
And I've already got that. I've completed all that with Metro government, and I have the certificate and all of
They're going
that.
to get it until we're actually ready to go.
Commissioner Horn.
Sir, I was very interested in your testimony, and I praise the Lord for it. But what I need to know is, there's a thing you know that from abstaining from the appearance of evil. You know that, and when you put this object in your pocket, did you know it's a chance, especially when you get old as I am, you can forget in a minute.
Say it again.
When you get old as I am, you can forget in a minute that you have something in your pocket. And so that's why we try to say, hey, don't put that in my pocket. I'm going to forget it. So you hold it in your hand or something like this.
Well,
yeah,
typically you're right.
Yeah.
But having both hands all moving the stuff around and putting it on my float, and then I got to talking to some people.
Yeah.
I forgot it was in my pocket.
Yeah, I can understand that. The only problem I have is with this person who interviewed you at the exit, that he would not give you a chance to pay for.
I asked him. I think he was just looking to make himself look good that he got somebody. That's all I can think of. But I asked him. I explained to him what happened. I said, well, let me pay. I don't want to hear it. I hear this kind of stuff all the time. You're just a story. And that was it.
Were you off the store property?
No, I was right in the store. Right after I paid for the stuff that I had, I was just leaving the counter when he stopped me in the store.
Yeah, I would. I always ride the expungement piece, and I think you need to really try to get your record cleaned up on that.
Well, like I said,
I know, okay. But what I am saying to you again, though, is you said that you're one of the the merchant's best customer, and that'd be hard for me to do if he was unreasonable for me to fold and say, well, you know, I'm gonna still buy from him and that type of thing. So I have to give you credit there. So anyway, those was the things that I had problem in my mind about. I think you cleared them up. Thank you.
Well, I can assure you that it was definitely a mistake, and and by the way, I've had a brain operation about May of 2014. Had a very large tumor. That's kind of hampered my memory to a degree, but I'm okay. I'm almost 100% now. But things happen, and it wasn't but about a few weeks later that I saw the manager at Denny's, and I sat down and had lunch, and I explained the whole. He said, "Don't worry about it. You've done it. You've already got it straightened out. You're going to go to court. It's all right. I hold not. You know, I'm not hurt." He even said the guy was wrong, but they don't have any say-so. They are, if I'm making sense, because a private contracting security company,
All right,
they're going to do what they're going to do.
All right, Ms. Page, I think we've got the full picture. Don't want to cut you off, but if we can get this done, let's see if we can. Is there a motion?
I'd like to make a motion that we approve Mr. Page's request.
Second.
Motion by Commissioner Frank, second by Commissioner Chara. Is there discussion on the motion?
I have a question.
Mr. Wood.
And my problem is not with the act that you're really here for. I'm trying to figure out, as I look through the law and it says there's two things, if I'm reading the licensing part right, to be a broker, you have to be at least 18 and you have to be a resident of Tennessee for 45 days. Am I looking at the wrong part?
It's right here in this book, the new book.
Maybe, is there something special if you don't live in the state? Is there another licensing area for that? And I'm looking at 6213-303.
If y'all want to go ahead and vote on the criminal act thing, we can postpone approving the license until we look into that further, if you'd like.
I'm fine with that, if y'all want to.
So what does that mean?
Yeah, but I'm not fine with voting on it for someone to have a broker's license if they're not.
Well, the vote is on these informal appearances is not usually to give them a license, it's to allow them to move forward with the licensing process.
So if he didn't
So if he's not lived here for 45 days, that's his next hurdle.
Well, I have to look into that. I think because he had already taken the exam and was approved for everything before that, I didn't look into that issue, and I can. I mean, I need to, since you brought it up. But there may be some other provisions that provide some exceptions for non-residents. That's what I want to look for and make sure we have that first. I think there is, but I don't even know exactly where they are right now. I just want to look into it.
Mr. Page.
Yes. I can give some clarification. When I was dealing with Mr. Oh my gosh, he's gone now. He retired. What's his name?
Which department? We got so many new
We're all
people.
new.
Anyway, he took me down the road, and I had every qualification of education and all the other things that are required for an out-of-state resident to be a principal broker. Now, you will find that in the act. I saw it, I read it, I know it's there.
6213-313.
And that's why he took my application and let me move forward, because I qualified.
Which one under 13? What letters? Well, this is about non-residents, so I'm reading the whole thing. Hang on.
It's currently 314. The old manual may have it. It may be different in the old green manual.
Service of process of non-residents.
Yeah. A non-resident of the state who is a licensed broker, affiliate broker, timeshare salesperson, or equivalent real estate license in another state may apply for a license as a broker or affiliate broker in this state by submitting appropriate application to the commission. And then part 3, the commission may issue the appropriate license to the non-resident if the applicant is qualified for the license held in the applicant's state of residence by written examination. The applicant meets or exceeds each of the qualifications for licensure in the state. The applicant certifies that the applicant has read this chapter and the rules and regulations promulgated under this chapter, and the applicant's state of residence permit the issuance of license without written examination to brokers, affiliate brokers, and timeshare salespersons.
So your broker's exam took place in the state of Tennessee?
No, it was by a company that's
PSI?
PSI. They do for and they did it specifically for Tennessee. The broker's test that I took in Chicago.
And did you go to a building where there was
Right,
a proctor and computers?
Yeah, they have their office and their whole testing center there. Correct.
To Ms. Kirby's point, what's before us is, does this commission think this gentleman is fit to proceed to get his broker's license? We're not issuing it today, based on this one incident in his past, and if there are other issues about the broker's license, staff will handle them. Today, we're just trying to get past this hurdle, as I understand it.
My understanding is that staff evaluates all of these things before they authorize the person to take the exam. So he's already taken the exam. He was authorized to take the exam. So unless there's a specific reason that the commission would like us to look into it further, staff has determined that he's met the other requirements.
This the last issue before he can get his out-of-state.
In this case, because he's taken the exam. And now
Got
some
it.
of the people that come haven't done that yet, so they haven't gotten to that point. But
So, let's see, who made the motion?
I did.
Was that your intent to allow this
Yes.
gentleman to go forward?
Yes.
Okay, that's your second. Okay, so that's what's in front of us. Is this guy fit to go forward and get a broker's license, or do you want to stop him in his tracks? If you want to let him go on, you'll vote yes. If you want to stop him, you vote no. Any discussion or clarification needed? All right, then, yes, Mr. Horn. Roll call vote, please. Mr. Young, will you roll call this vote?
So we'll. Bobby Wood.
No.
Marsha Franks.
Yes.
Janet DeChera.
Yes.
Bill Grease. I guess we have John. I'm sorry.
Yes.
Diane Hills.
Yes.
Fontaine Taylor.
Yes.
Johnny Horn. All right. The yeses have it.
Got a six yes, one no
Yes.
vote. All right, sir. You've gone through it. You've got a
So now I just have to get my license, get my office, and get going.
You just do whatever the staff tells you to do.
There you go.
All right?
Say it again.
Just do what the staff tells you to do. Fill out the right forms,
Thank
write
you.
the big checks.
I really appreciate your compassion and interest in, it's all about my brother. I really want to help him learn the business.
All
And I
right.
want
Good luck.
to do some business for this great state of Tennessee.
All right, sir.
Thank you.
Yeah.
Governor next.
So let me just understand, now I just have to get the paperwork done and pay for my license, is that it? Thank you.
Thank you very much.
Thank you very much.
Now, Mr. Page, you heard my advice to the last people not to hang around too long, right? Don't.
Exit stage left.
All right, thank you. God bless everybody. Have a
You
wonderful
also.
day.
All right, let's have a little discussion on the revision of the rules that we need to talk about related to core.
That is a Mallory thing, and I will tell you that in reviewing the report that's on your iPad, she has done a outstanding job to get us moving in that direction.
okay, so these proposed rules, as you can see on your iPads, I don't know if any of you got a chance to look at them before, but there are 3 rule sections that I'm proposing changes to. This, just as a reminder, this is to make our rules line up with the online submission process that's being implemented by the department this summer. And I think I mentioned before that there was a bill that was passed a couple of years ago that allows for the department to go ahead and do electronic processing. So that law like supersedes any rules that we have to the contrary. But we want to make sure and get our rules that are up to, be compliant with that, regardless of whether the law lets us or not. So that's what these are. If you'd like, I can read them into the record. If not, that's fine too. I also have included the regulatory flexibility analysis that's required to go along with the proposed rules. Again, I can read that into the record if you'd like or not. And if anybody has questions, feel free to ask me, or if you have any suggested changes or revisions or anything like that. They're fairly straightforward. I would like to be able to do these if possible, if the commission wills it, and we don't have any pushback from outside, forces. I would like to do this through proposed rules and not have to go through rulemaking hearing, because I don't think that it warrants a rulemaking hearing, but of course that'll be up to the commission. So if we do it by proposed rules, there's no rulemaking hearing. There's a window of time where you have to have 45 objections 45 days for someone to object, and then it goes to rulemaking hearing.
So in your opinion, what's the simplest way to do this? Do we have to read, for instance, do we have to answer the questions of the Regulatory Flexibility Act, or can you just plug in the answers?
I have plugged them in for you. So if you would like to look at them and see if you agree with them, if you want them changed, we can do that, and I can bring them back next time. Or if you're satisfied with them, you can go ahead and vote. Same with the rules. If you need if you want to take them home and look at them more this month and vote next time, that's up to y'all.
So why didn't the commission take a few minutes and look at these rules and the answers that have been plugged in by council, and see if you're okay with the proposed rules and the proposed answers to the Regulatory Flexibility Act?
And I've included the suggested rules in the red line form so that it's a little bit easier for you to read what actually is changing. Of course, the blue is what's being added, and the red strike through is what's being taken out.
So do they get confirmations? I mean, if it's given online, will there be a confirmation that comes back that it was complete?
So
that it could be something that's stuck in the file, not that we thought it was done and it was missing.
So currently, they can, I believe, just renew online, but they get a confirmation right now for that. Because I asked Jamaica to send me an example of something they get when I was drafting these, because I wanted to be able to see, if I go online and renew my license, like, what do I get saying that? And right now they have something that says what you've changed or renewed, and then how much you paid. So I assume with court it would generate something similar to that.
Signatures and things. So if I'm a broker and I'm releasing an agent, and I'm deciding, I haven't seen them for a month, and I've decided, so I do it online. And if I've fulfilled all my part, I'll get something saying it's done. And I met all the requirements.
You should. I mean, I can't say how exactly the IT people are going to set it up to function that way, but my understanding is that's the idea.
On the credit card transactions, you would definitely you have to get a confirmation back that it's actually been a transaction, and that would be part of your confirmation.
I would suggest to commission. Go ahead.
But now, but there are times that we do something with a license, like bring a new license here to open a company. Our money is taken, deposited, but that doesn't mean our license have been complete. I guess in my mind, I would just want to know it's complete, besides just a receipt of the money.
Well, the rules are very general and just basically say we can establish a method of online submission. So I think that like those specific details about when something's actually effective and actually goes into practice, I think those would have to be set up with whatever the online submission is. Like these rules aren't that specific as to like, because I think in order to figure all those details out, we'll have to know more specifically about how the program is set up to generate things. Automatic, like whether it's going to do it automatically through core or whether it's still going to take a staff member to look and see what's been done and then manually do it. So the rules are mainly just to allow for the commission to have the option of coming up with an online submission program in addition to using like the paper forms.
And to follow up with what Mallory just said, we have meetings about 3 times a week on all the transmissions, and the concerns that you have, Diane, we can certainly communicate that with IT to make sure those confirmations are put into place.
And the TREC 1 section on here, the TREC 1 section currently in our rules is pretty specific. So I kind of went off of that to revise them. And so we already had a section in there that says, you know, when you're transferring firms online, it's automatic, you know, as long as it's complete. So we still have that, and complete being it has to have an electronic signature and it has to be like the form has to be completed. So those are the couple of specific things that were pretty much already in our rules. They've just been tweaked to include an online.
So renewals are the only 2 things you can do on there right now, correct?
I believe so, yeah.
Are we going to get other things like when an office moves?
That's
Their goal is that
Change of address for a firm, not
They're-
a licensee. It's just for licensees.
The
Yeah.
goal of this administration is to have everything electronic. And either through electronic signature or, I mean, every single phase is to be totally electronic. In the initial phases of application, renewal, E&O, it's the intent to have all of that online by June the 22nd. And then there are other things that will be following suit afterwards.
Yeah, there are like 3 phases, I think, of the online implementation.
So do you need a motion here?
Yes.
Yeah, and I'll just bring also to your attention the timeshare section. I suggested taking out the notary requirement. I don't believe any of our other application sections require that, and that would be kind of a hindrance to being able to do it online. Because we could have, you know, a statement affirming that they attest to everything that's in the application instead of the notarization.
I'd like to make a motion that we approve the proposed rule changes as submitted to us by staff.
All right, the motion is to approve as submitted the proposed rule changes related to electronic filing in the core.
Second?
Yeah, we have Diane,
Diane.
second. All right. Discussion on that motion. All right, then let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
Aye.
That motion passes unanimously. Now, Ms. Franks, regarding the Regulatory Flexibility Act, would you like to make a similar motion? Or would you like a discussion of what that is before we do it?
I'll make that motion.
I have a motion by Commissioner DeChara. Basically, the Regulatory Flexibility Act basically speaks to the impact of these rules on small business.
Correct.
And I think your answers are that it's negligible or it might help.
Right. It doesn't really affect anything they do other than help them expedite their changes they want to make online.
So,
Did you get a second?
I did, I think. I had a second from Ms. Taylor. Mr. DeChara made the motion. Ms. Taylor seconded it, and that's to approve the responses proposed by council to the Regulatory Flexibility Act requirements. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you very much for.
We probably also need to vote on whether the commission wants to try to do these through proposed rules instead of rulemaking hearing.
I heard Mr. Charos make a motion that we do this through proposed rules. And then I think I heard Ms. Hills say she seconded that. So the motion on the floor is to do this through the proposed rules process as opposed to a formal rules hearing. debacle. All right, you've heard the motion. Let's vote. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously as well. Other items to come before us regarding that issue, Ms. Kirby? Thank you very much for your hard work on it.
Hopefully that'll be all we have on rules this year.
It's only
Don't
March.
count on it.
Okay, we're gonna start a legal report. We've got a substantial number of these to go through. We're gonna take a 10-minute break before we do that. So let's be back at 1:30.
1:30. How about 2:30?
2:30, whatever. How many? All right, before we get to legal report, Mr. Young.
Yes, sir.
Executive Director's report, and you can feel free to keep it as short as you need to.
I get the drift.
All right, thank you.
But I will make it short. Well, on the core update, I'm referring to item 11 in your iPad if you want to follow along. But Mallory, I think, has accomplished a lot of the core update. One of the last things I would like to state is one of the things that we're real excited about that we discussed under core last week was the potential of licensees being able to print their license after they have done their transaction online, and that could be the future, but we're looking at probably 8 to 10 months down the line once we get some of these other things processed, but that's something that we're moving forward on. Also included under iPad is in the communications area, we have a newsletter that actually will be, it will probably be distributed to the licensees tomorrow. You're getting an advanced copy in your materials today. Also in front of you, we have prepared an overview of the TREC website, which obviously needs to badly be revised, updated. We've already started on those revisions as far as putting those together. In front of you, if you will just take a look at a glance, this could be your homework assignment tonight, would be looking at the different categories because we are reformatting it. And if you have any suggestions on that, we would certainly appreciate that as well. In the customer service area, we have received the secret shopper results back. I wish I could report to you that our ratings were all 10s, but they were not. That's probably the purpose of why we are doing frequent staff meetings to improve the customer service area. In turning to the next page, as far as your financials, your total expenditures for January for TREC totaled $64,643, with a payroll of $46,155, with a cumulative expense for the year of $574,100. I also wanted to note, and I think this is important for you to note in this, that a portion of the expenses in TREC is the share of the call center, in which the majority of the calls coming to the call center currently are TREC calls. Revenue for the month of January was $3,560 with a cumulative revenue of $27,880. In getting into the February statistical reports, I want to go back to an inquiry in inquisition from Commissioner Wood last month. He questioned the as far as the number of licensees that had been collected. We are looking into this, and I will tell you that in looking at several resources, working with accounting, working with IT, we are coming back to you to confirm that Mr. Wood and his suspicions were correct. We're probably looking at a 10% increase of licensees instead of 20%. We are still looking at that, but let me explain to you. The historical data is the area that we are concerned with. However, the current statistical information that we are giving you as far as the number of licensees and firms is correct because it is coming off the core system. But the historical data is what we want to make sure that we're able to come back and give you with accurate information in the future. So currently you have 28,941 licensees, and that's all accounted for licensees, that you're looking at. And with firms, you're looking at 4,227. Retirements, as you knew last month, Betsy Bowman has left the building. She did have her surgery a week ago, and by doctor's orders, she will not be back before her April the 28th retirement. We also have another retiree, which is Ken Spurlock. Believe it or not, Ken has been with the state for over 44 years, and he handled your errors and omissions insurance area. I have completed the staff assessment. We will be making some staff reassignments in the coming weeks, especially with the people that are exiting and retiring, and reassigning some of those duties. And commissioners, that completes my report.
Questions for Executive Director Young? I'd like to compliment you on the brevity of your report and yet the thorough information you provided.
I aim to please.
Thank you, sir. All right, we're ready to go to legal report. To the audience, people file complaints against licensees all the time. Many of them are anonymous. They're sent eventually to the legal department, where the legal department researches the complaint and at some point writes a narrative that is about to be presented to us that does a great effort, great job of presenting the facts without telling us who or where. And as you heard this morning, council will give us a recommendation. We'll discuss the recommendation, either accept it, change it, or throw it totally out. It's up to us, despite those two commissioners that were up here this morning telling us what we can do and not do. We might not be around long, but it's up to us while we do it. So, Ms. Kirby is charged with reading all of these into the record. A few of these we've handled before. And I would encourage individual commissioners, if they see an opportunity or an opening to try to just get to the bottom line on one of these first two or three, it would be okay from my perspective. So, with that said, Ms. Kirby, you've got the floor for the next hour and a half, whatever it takes us, okay?
Before I start on the first complaint, I just wanted to clarify a little bit. It seemed like there was a little bit of confusion about my recommendations versus what they were addressing earlier. The statutes and rules give the commission authority to do certain things, and within that is you can issue civil penalties, you can revoke, you can suspend, and then you're given like a range of the civil penalties that are allowed. So as long as you are within the statutory or rule civil penalties, that you're welcome to, reject my recommendation, and that's fine, because that's the authorities like set out in the statutes and rules. So what they were addressing was not that. Does that make sense at all?
Yeah.
Okay.
You have a question about it?
So how are we handling this today?
Well, let's see what happens when we
and have the discussion when it happens?
Let's see what happens.
I would encourage you to look at it from a case-by-case basis instead of maybe deciding one blanket thing to attach to each one, at least maybe at first, just to kind of evaluate each of them. But that's just a suggestion. Okay. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. 2014-006332. The following is presented at the August 2014 meeting. Complainant states that Respondent 2 listed complainant's home after the parties discussed the properties and items which needed cleaning and repairing. Complainant alleges that Respondent 2 assured complainant that Respondent 2 would video record evidence of damage done by previous...
Ms. Kirby,
yes.
I would like to recommend that we just go to the update on this one.
Okay.
Any objection? Okay.
Okay. Let's see, the March update.
Why don't you give us the original, let's start with the original recommendation.
Okay.
So we can see what we did.
The original recommendation was a consent order for $4,000, plus a meeting. And the decision was a consider for $8,000 plus a meeting. There was an update given last month, and the commission decided to authorize a consent order for voluntary surrender of the respondent's license. This respondent had suggested that he would be willing to voluntarily surrender the license in lieu of paying the $8,000 civil penalty. And then this month, it was determined that the respondent's license was revoked as of January 2016 due to E&O expired for more than 1 year pursuant to TCA section 6213-312L1. Thus, there's no license with which to discipline, so we are recommending closing and flagging if respondent should ever apply for another license.
Motion to approve council's recommendation.
Second.
Okay, we have a motion by Commissioner Char, second by Commissioner Taylor, that council's recommendation be adopted, and this file be closed and flagged, which means if the guy or girl ever shows back up, what happens?
If this person were to ever apply for another license, they would have to come before the commission, just like Mr. Rory with the E&O, and go through that process, and then the commission would determine whether they wanted
The
to.
commission would be aware of what the events.
Yes.
That wouldn't be closed. Okay.
Yes, I mean, it probably wouldn't even require the flag because it would say revoked, and we would look up and see why they were revoked. But we would, we'll flag it anyway.
All right, discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 2. Let's try the same process with this one.
2014-003861. The original recommendation was a consent order with a $3,000 penalty and an order to cease and desist. This was unlicensed activity. The authorization was for a $4,000 civil penalty and a cease and desist. The update is the respondent's license expired in October 2014 and was not renewed. No properties are advertised as being offered or managed by a respondent. There has been no report of any further activity, and all mail to the addresses in the file has been returned. Email has also failed. Respondent resigned from the local association last spring, and there's been no further communication from the respondent. The recommendation is to close and flag to be reopened should respondent attempt to secure a new license.
Motion to approve council's recommendation.
Motion by Commissioner Char, second by Commissioner Taylor, that council's recommendation be adopted and this file be closed.
I just have a question.
Yes,
So
ma'am.
if their license expired in October 2014, but the last sentence said they resigned from the local association last spring?
Mm-hmm.
It expired in 13, and the E&O expired in 15.
Respondent's license expired October 2014.
Yeah, I don't know anything about the E&O here.
No, that's an MLS issue, not ours.
All right, you've heard the discussion. Is any other discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. And let's try this one as well.
2015-02-15381. The original recommendation was consent order for $1,500, and the vote was for $1,500 consent order plus attendance at a meeting. The update is that respondent states that upon receiving the complaint, respondent contacted TREC to find out how to advertise her company and to be in compliance. Respondent states that respondent spoke to Alan Waddell, who stated her company's LLC's size could not be larger than the firm name, but the boldness and size did not matter as far as he knew. Respondent states that respondent had just joined her current firm and used the firm phone number given to her by the principal broker. Respondent states that the number given to respondent by the principal broker is the one listed in the Yellow Pages and the MLS for the firm, and respondent had no way of knowing that the principal broker had registered his cell number instead. Respondent states there was no injury or harm to anyone, and a warning would be more appropriate since respondent has been in real estate 30 years with no complaints until now. The new recommendation is consent order in the amount of $500 for the initial advertising violation in the complaint of Rule 1260-02-.122B, which is the old rule would apply here, which is that all advertising shall list the firm name and telephone number.
Clarification. Is it not correct that the only way a cell phone number can be registered with TREC as the main firm phone number? Is that if that's the only person in the firm?
Well, we don't have a specific rule saying that. They are supposed to have the firm number registered with us. This affiliate broker is just saying that she had no way of knowing that the principal broker had not registered the actual physical firm number with TREC, which was the one that she was advertising.
She was given a number, and that was the office number, and that's what she used. But what the broker had on file here was her cell phone number.
So should we go back and file a
To the
complaint
broker?
against the broker?
There is a complaint against the
Okay.
broker has already been got a consent order last time when we presented them together. And I didn't think that any of the new information really applied to the principal broker, so that's why I didn't include
Was
that in
that
the
what they were
representation.
given?
They were given, I believe it was failure to supervise. And was it advertising as well? I believe it was a $2,000 consent order, so there had to have been 2 violations. I can't remember what the
I
other one
certainly
was.
feel like that broker needs to understand they need to register the firm phone number, not their cell phone number.
Right, and my understanding is that it's been changed since then because they called and spoke with me, and I was very firm with them that that was their responsibility to make sure that that was correct.
Then I move to approve council's recommendation.
Motion by Commissioner Frank, seconded by Commissioner Wood, the council's recommendation be adopted. Before we vote, so why wasn't this information provided at the time of the original response?
Well, I think part of it is because the original complaint was just based on the fact that she was advertising without the firm name and the phone number. So that was the complaint that was sent to this person. Then she responded based on that. Well, when we were reviewing the response, we went and checked the website to see if those things were fixed because her response had said, "I've fixed them." So we went to check and saw that there were other things that were incorrect. And so since those weren't brought up in the original complaint, those weren't addressed at that point.
Has this, I'm sorry, John.
One quick question about that. So back to the principal broker and the phone number, did you discover that in the original complaint or in the subsequent discovery?
I think it was after we reviewed the response, right?
I think it was after the consent order. He called and said that's his cell phone.
But we knew when we wrote the consent order that it was the wrong number because that was part of the original presentation. So the same situation with the principal broker. They were just given the original complaint, which said that the firm number and the firm name were not on the advertisement at all.
So my question is, so it sounds to me like this cell phone was discovered later, and has the broker ever signed a consent order acknowledging that he was using the wrong phone number?
That was included in the consent order that's been sent out. He hasn't signed it yet. I don't know what his choice is going to be on that, whether it's going to be signed or... I spoke to him on the phone. He called me, and as far as I know, has taken care of changing it or has already done that. So it is included in the facts on the consent order.
Okay, now I have I don't know if it's a question or a comment as much as anything. This was one of my original concerns about people answering the phones and giving out legal advice. Has this been addressed with Mr. Waddell? I'm sorry.
I specifically have not. I'm not really his supervisor, so I don't know that I can do that.
We have talked about general guidelines in giving legal advice in staff meetings, but it's not only been there, it's also been in the call center.
Well, this one specifically named him as being the person who gave them the wrong advice and advising them on how they need to advertise. So
yeah, it concerns me as well.
I mean, I kind of think that needs to be addressed specifically if that's continuing to be an issue.
I will take care of that.
Okay, we have a motion on the floor, and that's to accept council's recommendation. Is there further discussion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 4.
201-502-17231. Complainant and complainant's sister hired respondent to assist in finding a home for their mother. Complainant found a house of interest and respondent showed complainant the house. Complainant states that respondent told the seller complainants would be paying their own closing costs without complainant's permission. Complainant states respondent did this to get the seller to agree to pay her fee. Complainant states respondent told complainants they should be concerned with how much the seller would net when making their offer. After that point, complainant states complainant was uncertain if respondent was complainant's agent or a neutral facilitator since she was helping the seller. Complainant states the respondent revealed confidential financial information by telling the seller complainant would pay closing costs without permission and compromised their negotiating position by revealing this new information. Complainant submitted an offer and seller agreed to accept the purchase price but not all closing costs or the home warranty. Complainant states that the seller agreed to pay part of the closing costs and respondent agreed to pay the remaining out of respondent's commission. Complainant states respondent typed up a counter offer on the seller's behalf, including the amount of closing costs the seller had agreed to pay, but not including the remaining amount respondent agreed to pay, and sent it to the complainant with the accepted box checked. Complainant states that respondent was representing the seller without clearly disclosing what she was doing and without written consent of all parties respondent represents. Complainant states respondent insisted complainant accepted the counter offer and let respondent proposed an amendment later stating respondent would pay the remainder of the closing costs once respondent could meet with the seller in person in order to ensure the seller would accept the terms of the amendment. Complainant states respondent stated the agreement for respondent to pay the remainder of the closing costs was between them and really didn't involve the seller. Complainant states the property disclosure was received 4 days after it was required to be sent, and respondent did not provide any written extension or addendum to extend the contract deadline for receipt of the property disclosure. Complainant states extensive roof damage was discovered during inspection, which the seller was not going to fix, so seller opted to let the house go to auction. Complainant states the seller was taking a long time to sign the termination papers and earnest money release form, and respondent defended the seller, saying the seller was at the end of her rope. Complainant went under contract with a different house that had a contingency requiring receipts and records of work done on the house, followed by a 48-hour approval period by the buyer. Complainant states respondent did not provide the fully executed contract until 2 days after it was signed by the seller, with the exception of the counteroffer. Complainant states complainant attempted multiple times to contact respondent regarding the 48-hour approval period, but did not get a response until 8 a.m. the morning of the deadline. Complainant states that when respondent sent the notification form over, it mistakenly had the property address of the first house and date of 2 days after the contract of the current house. Complainant states respondent told complainant that the seller of the first house had asked respondent to help her seller sell her house after complainant's contract fell through, but respondent wanted to talk to complainant about it first. Complainant then found out that the first house was already under contract when respondent first mentioned it to complainant. Complainant states complainant lost all trust in respondent after this untruthfulness. Complainant states that when complainant first started working for respondent in July of 2015, prior to either of these two contracts, complainant had put in an offer on a house that complainant later found out had a high crime rate. Complainant states that complainant was very distressed about this and that the respondent did not inform them that they had the option of withdrawing the offer, something complainant didn't know was an option. Complainant states respondent did not inform complainant that withdrawing the offer was an option until a subsequent conversation with complainant's sister an hour later. Respondent states that in regard to the closing cost disclosure issue, respondent was presenting the complainant as a strong buyer that had been pre-approved and could pay their own closing costs. Respondent states that respondent and the seller were not talking about offers at the time and were discussing the seller's situation, the house layout, and whether it fit complainant's criteria to get an appointment to see the house. Respondent states that a buyer's ability to pay closing costs does not make a representation that closing costs would not be requested in an offer. Respondent states that it had not been stated that complainant's ability to pay closing costs was confidential information. Respondent states respondent was not representing the seller. Respondent states that respondent did not insist complainant accept the seller's counteroffer even though it was marked in dot-loop as accepted. Respondent states respondent discussed the pros and cons in writing an additional counteroffer. Respondent states that there was someone else coming to see the house that day, so if complainant wrote up another counteroffer, it would end up being a multiple offer situation. Respondent discussed with complainant that it was better to sign off on the counter and have a contract then add an amendment to lower the commission to reflect the closing costs than to write up a counteroffer that may lose out to another offer. Respondent states seller had printer issues, so seller asked for the property disclosure documents to be faxed to her. This was done and documents were returned to respondent. Respondent states that later the following day, it was discovered that there were things missing from the disclosure that it must have not printed out when faxed to the seller. Respondent dropped off a hard copy to the seller, which was returned the following day and sent to the complainant. It was discovered that there were 2 questions unanswered to respondent, so respondent got those answers and sent the third disclosure to complainants. In response to the documents being provided to the complainant for the second house, respondent states that complainant had access to the documents on dot-loop and that they were also sent in PDF format once respondent had all of the completed documents. Respondent states that respondent sent the completed documents as soon as they were received from the listing agent. Respondent states respondent told complainant that the seller of the first house had been in contact with respondent about working to get her old house sold, and that was it. No questions or discussions, just a statement regarding the very first house with the crime concerns, July 2015. Respondent states the complainant told respondent in the initial phone call the complainant was concerned about the crime rate and needed to talk about it with the family, but did not say complainant did not want the house. On the second call, respondent was told the house was not wanted, so the offer was withdrawn. Regarding the first property, a confirmation of agency status form indicates the seller in the first transaction was unrepresented. The initial property disclosure form had a timestamp from a fax machine for August 10th, 2015, the date on which it was supposed to be received, and complainant acknowledges this in an email. A transcript of a voicemail from respondent to complainant provided by complainant seems to indicate that respondent admitted to telling the seller that the complainant would pay closing costs without complainant's permission. Counteroffer 2 for this property appears to reflect this because commission is reduced and closing costs are increased. It is legal counsel's opinion that it is improper for an agent to convey terms of a contract without permission from the client. Regarding the second property, email communications indicate the seller sent the executed transaction documents to the respondent the morning of the 11th and forwarded to complainant around noon the same day. In an email from respondent to complainant in the early morning of September 11th, the respondent tells complainant that the respondent does not believe the 48-hour approval period begins until that day. The 48-hour period is contracted to start when the receipts for prior work done to the house are received. About an hour later, complainant emails respondent still unsure and concerned about what will trigger the 48-hour period and inquiring as to whether or not complainant needs to provide a notification form to the seller. This email appears to go unanswered. The next morning, complainant emails respondent again inquiring about the 48-hour deadline with seemingly no response. That evening, complainant texts respondent twice expressing the need for an urgent response as complainant believes they are reaching the end of the 48-hour approval period. There appears to be no response. The following morning, the day of the 48-hour deadline, complainant sends a text to respondent and an email to respondent's broker expressing concern that they do not know what time the 48 hours is up and do not know what to do to proceed. Respondent responds shortly after stating they are good on time. While all this communication happens within a short period of time, it does appear that respondent should have been more responsive or at least provided clear information to the client since they were on a very tight deadline pursuant to the terms of the contract. Also, the exclusive buyer's representation agreement appears to have expired on 8/31/15 with no extension, and respondent is listed as the designated agent for the buyer on the confirmation of agency status for the second property on September 9th, 2015. The buyer's representation agreement lists respondent's team as the broker firm, which is problematic because respondent's team is not a firm or the name of the broker. The recommendation is $500 for violation of TCA Section 62-13-4031, reasonable skill and care for telling the seller complainant would pay closing costs without permission and lack of communication regarding the 48-hour deadline. $500 for violation of TCA Section 62-13-403, advising clients as to whatever forms, procedures, and steps are needed after the execution of the purchase and sale agreement for a successful closing, and $250 for violation of TCA Section 62-13-401, an agency shall not be assumed, implied, or created without a bilateral written agreement, and $250 for violation of TCA Section 62-13-312B20, improper dealing, and TCA Section 62-13-312B14.
Okay, I find this one real problematic. In the case of reasonable skill and care, I have major issues with that, and I certainly would think that needs to be increased, but there seems to be some bad miscommunication problems here. And are they using a TAR purchase and sales agreement?
I believe so. Mm-hmm.
Timelines are outlined pretty specifically in the TAR purchase and sales agreement. And the agent not communicating that 48 hours seems to be a real...
Yeah, it was a little tricky here because the 48 hours was supposed to begin when they had received all the receipts of the work done. But then there was some confusion about, well, are we still waiting for another receipt or is this all of them? So they weren't sure when it was actually supposed to start. And it doesn't seem like they got anything real clear from the agent about when it was supposed to start.
Well, they had all that written in there instead of what we normally have on the TAR form, excuse me, is so many days.
Yeah, I believe this was
An
in the
exact number.
I think this was in the stipulations.
So as the buyer, so they were, the respondent was a buyer's rep, even though it doesn't have the company name correctly. Who represented the seller?
Well, there's a few different transactions here, but The first one
Was
was
unrepresented
unrepresented.
seller.
Mhm. The second one, I think they were represented, I believe, in the second transaction.
But in the first one is the one where the complainant felt like the respondent was actually working for the seller.
Complainant thought that. I didn't really find anything to substantiate that. I mean, the confirmation of agency form, that was when the expiration date was still within the expiration date of the agreement, buyer's representation agreement, and the confirmation of agency status for that property said, seller unrepresented, buyer represented by this person.
How was this commission disclosed about the agent paying commission for this buyer?
Oh, I don't know. We'd have to look at the documents for that.
I mean, that's like not legal for an agent to pay the closing cost.
Oh, for the closing costs.
Yeah, I said commission. I'm sorry, closing cost.
I'm trying to remember exactly what it said. I think that it said it just lowered the purchase price
By the amount of the commission
by the
that
amount
they
of
did not take.
Yeah.
But it still has to correspond that the seller's the one giving the money to the
And it has to correspond with the HUD.
Yes.
And did all that correspond through?
The HUD. I don't know that we had the HUD. It didn't even go to closing, so we don't. That was the one that fell through.
Oh.
All right, so there are a lot of questions on this. Council's recommendation includes 4 different civil penalties. So let's just take a look at each one of them for a second. Mr. Horn. Sure.
Is there a difference between a seller's rep and a buyer rep? Can they be the same person, or?
It can be the same. They just have to be it has to be disclosed that
As a
they're
facilitator, not a.
Or a dual agent.
Or dual agent.
Got it, thank you.
Okay. All right, so the first recommendation has to do violation of 6213-4031, failure to exercise reasonable skill and care. And council's recommendation is a $500 fine for that. Anybody is everybody okay with that recommendation?
Is 1,000 the max on that?
Yes.
I would like for that to be 1,000.
Okay, I'm just going to keep it running total for a second. Then a second 6213-403, advising the client as to which forms to use, which is that similar to the unauthorized practice of law? Is that what you're saying there?
No, that's basically advising the client as to whatever they need to do to get to closing, which I applied to the part about the 48 hours, not being very clear about when that started and what they needed to do to approve the receipts once they got them.
Is that different than not exercising reasonable skill and care?
It could fall under reasonable skill and care too. I just thought this one was a little bit more specific. That's why I used it. But if you want to lump it in with reasonable skill and care, that would be fine too.
I'm good with leaving that at 500 for
Okay.
that violation.
Okay, then $250 for acting as an agent when you didn't have a written agency agreement.
I'm not good with that.
Well, what would you suggest?
At least 500.
Okay, so we're at 1,000, 500, and 500 if you, you'll make a motion in a minute, okay?
Mhm. No, we
Right,
ain't
we
got
haven't
there
the
yet.
last one. And then finally, violation of TCA 13312B20, improper dealing. Would you explain that? A little?
Sure, that's what I put for listing the team name as the broker slash, because on the TAR form it says on the listing agreement it says broker slash firm, and it said
I wonder how they could have ever gotten that confused.
Yeah.
And so they maybe put the Marshall Franks team
Right.
instead of Franklin Realtors.
Exactly.
So everybody okay with 250?
No.
No,
I'm
at all.
asking a question, all right? Somebody make a suggestion. What's the number that would make you all happy?
The last one what's the max?
$1,000.
That's what I would do.
All right, so I'm gonna attempt to make, to state a motion that I think Commissioner DeChara.
Well, hang on, we're not done.
All right, excuse me.
We're not done.
I'm just trying
Okay,
to get us current,
and this
but-
is where we're going with the education part. They can either choose to attend a commission meeting or take 8 hours in additional continuing education with 4 hours in agency and 4 hours in contract writing.
Second. At least 4 hours.
Yeah.
Yeah.
Do they offer classes on like specific on agencies?
Yes.
Okay.
So
All right,
that's
now,
for a total of $3,000.
We need to put a time frame on that.
180 days.
180 days, and how do you?
The state said this morning that they could keep up with that.
Ross will have to,
With proof,
it has to go to the state.
It goes to us, actually. Any of the things that are to fulfill a consent order, we keep track of in legal.
In the consent order language, we're very familiar with offering courses. You've actually authorized several, so it is and to provide successful proof of successful completion to our office within the 180-day timeline.
And I also think that it should be 8 hours above and beyond any other requirements by the state or their board.
Or national.
yeah, right.
Because WCAR has some education requirements that people in Nashville are not required. So over and above any other requirements.
I think that whatever we do, that should be a tag on.
And the wording's important, so you're saying.
Well, I said additional education hours.
Okay.
So it would have to be in addition to TREC's requirements. We can't
You can't govern.
we can't add anything
classes.
to like the local association
Right.
requirements, just
Maybe
to
word
TREC
like
ones.
Exclusive to the section.
Exclusive to what, Malcolm?
Exclusive to the sanction.
I don't understand.
What do you mean by that?
That means just
Just
this and never
specific
to be used for something else.
Right.
Oh, okay.
All right,
That may not be the proper word, but
let's see if I can summarize the motion as I understand it. And I'm going to say that Commissioner DeChara made this motion and Commissioner Taylor seconded it. If you don't like it when I'm done, you tell me. Okay. The motion is to accept council's recommendation with the following modifications. The civil penalties be increased from 500 to 1,000 for the first violation. The 500 stays the same on the second. Third violation increases from $250 to $500, and the fourth increases from $250 to $1,000 for a total of $3,000 in civil penalty. In addition, if the licensee agrees, accepts the consent offer, the licensee will have to either attend one of our meetings, full meetings of the commission within 180 days, or take 8 hours of continuing education with 4 hours specific to agency and 4 hours to contract writing. And those 8 hours, as a special stipulation, will not apply to any continuing education requirements of the state of Tennessee.
I think you forgot to me to clarify.
Or complete the
That's the
education.
Education.
That's the intent.
Good job, John.
But I have a question.
Yes, Ms. Hills.
So.
Don't mess me up now.
I know. So they receive 8 hours when they attend this meeting. Would those 8 hours count towards their continuing ed 16 hours?
No,
Because as in the past, it has.
no.
So we need to be sure that is stated then that way. Yeah. You see what I'm saying?
I don't like that we're changing it now, these new education that people are taking. I mean, how are you going to keep up with, you've got some education that counts toward your CE, but you're going to have to keep up with other education that don't count toward CE. And now, I mean, like these people that came here today, if they came and they sign in, they got credit but this person could come to the same meeting and not get credit. I just think we're going down a
Oh, they're
slippery
getting
path.
credit.
They're signing in and they get credit.
Yeah, they're getting credit, but you're saying in this particular situation, this person could come to the meeting and they would not get to use that 8 hours toward their 16 hours of continuing ed.
Right.
This is something in addition to the 16.
Yes.
Which makes me want to go with just the 4 hours agency, 4 hours contract, and not offer the attend the meeting, but stipulate that those 8 hours could not be used.
I think they should have the option if they want to come to a commission meeting. I mean, these people have had so much fun today. Well, and the state told us that was doable. They were the one that suggested it. I'm not going to worry about how it gets done. I'm going to look to them to make sure it gets done.
All right, so, Ms. Hills, do you want to offer an amendment, or Mr. Wood, do you want to offer an amendment to the motion?
My amendment would be that the education, if they were to choose to do the education, either come to this meeting or to go to either one of those classes, whatever the way, they still got CE credit for it that counted toward their continuing education requirement.
All right, let's vote on that amendment. The amendment, as I understand it, says that regardless of whether they take online courses or come to this meeting within 180 days, they get 8 hours of continuing education credit.
But it can, you're not saying that they have to have 16 hours and that could mean 8 of it?
Yep.
Or are you saying it's 16 hours plus 8? Because, I mean,
No. It could be part of it. I mean,
See, I
Okay,
disagree
so,
with that.
okay, that's good, that's what we vote.
Okay.
So the motion is an amendment that says that 8 hours, regardless of whether it's taken online in class or attendance at this meeting, that 8 hours will count toward their continuing education requirements. If you're in favor of that motion, you'll vote yes when Mr. Young calls the roll in a second. If you're not in favor of it, you'll vote no. Mr. Young?
Bobby Wood,
yes.
Marsha Franks,
No.
Janet DeChera,
No.
John Grease,
Yes.
Diane Hills,
No.
Fontaine Taylor,
No.
Johnny Horn,
No.
All right, that motion fails on a vote of 5 noes and 2 yeses. So we're back to the original motion, which is they can still come to the meeting within 180 days. They don't get any credit for coming to it other than to satisfy the consent agreement. Or they can take it online or in a classroom, 4 hours of agency, 4 hours of contract, and those 8 hours do not apply to their continuing education requirements. That's what's in front of us at this point. Are you ready to vote on the whole motion? Since you are, if you're in favor of that motion, vote aye. If you're opposed, vote no.
No.
All right, the chair rules that that motion passes on a 5 aye, 2 no vote. So we have handled number 4. Now, yes, sir.
Has come under this attack this morning.
You're not lit up, Johnny.
Can you hear me now? We just crossed that bridge this morning, whether we should require them to come here or to add on additional training. We have not had an official meet on that exactly. We look like we're doing it as we go.
We don't have a choice about that.
That was what was recommended by our council.
We can't have a separate meeting about that specifically.
You can't.
To
Sunshine
do it
Law.
in our actions.
I mean, we could have a discussion about it now, but we're in the middle of that's why I wondered why were we not doing it before the legal issues, but we were advised to do it on a per-case basis.
Per case basis, but
That's what Mallory
Raise your hand,
recommended.
Mallory.
Jump in.
I did say that. You're, of course, I mean, you're welcome to discuss it whenever you'd like.
All right, understand your point, but we're done with number 4, let's go to number 5, which has to do with the supervising broker or the principal broker of the case we just heard.
20150217251. TREC opened a complaint against respondent for failure to supervise the affiliate broker in 2015-021723 above. Respondent states complainant really wanted the first property and had previously lost out in a multiple offer situation, so the affiliate broker was trying to make complainant as attractive to the seller as possible. Respondent states that the affiliate broker was trying to figure out how to best stop foreclosure and stop the seller from attempting a short sale, and thus was working in the best interest of complainant to get the home. Respondent states complainant knew about the crime in the area of the July house because the affiliate broker sent complainant the crime map via email before the offer was made and withdrew the offer within an hour of the request. Respondent states respondent met with complainant about complainant's concerns and then met with the affiliate broker. Respondent spoke to complainant again and felt that a termination agreement should be signed to make complainant comfortable with moving forward to purchase another home. This was executed on September 24th, 2015. Respondent states that everything throughout the process was done correctly. Recommendation is $500 for violation of TCA Section 6213, 312B14, and 15, failure to supervise.
Well, I have a problem with the fact the broker thought everything was done correctly. Yeah. So I'm going to raise that violation to $1,000. And either attendance at a commission meeting or the core course.
That's a 6-hour core course.
That's a 6-hour core course.
All right, is there a second to Mr. Char's motion that the civil penalty offer be $1,000, not $500, and that the principal broker either attend a full meeting of the Tennessee Real Estate Commission within 180 days or take a 6-hour core class?
Within 180 days.
Within 180 days.
And I second that.
I have a comment here.
Yes, ma'am.
I mean,
Ms. Taylor.
it's because Ms. DeCharo teaches classes, she's aware.
Speak louder for me here.
Because Mrs. DeCharo teaches classes, she's aware of the classes available. I am at a disadvantage. I do not know of the classes. I certainly know some scenarios of classes, but I don't know the specific ones, and I think we all are at a disadvantage today because we don't know the specific classes. So I would say, just as a comment, I'm leaning on you, since you're the teacher, to tell us the proper classes.
Core class, and one of the reasons for that is this broker is a grandfathered broker.
Oh, that.
Because the date of their license is on here, and they were licensed in 1987. The core class is going to cover the new laws as well as contract, agency, fair housing, and the whole gamut, which I think as a broker you really need to have that information.
And there's really only one broker management class unless we required them to take some of the CRB classes.
All right, thank you.
Okay, so in this case, based on Mr. Charles' representation, this broker doesn't have to take classes, so it doesn't matter whether he gets credit or not for them, right?
That's correct.
Okay, so the motion is to accept council's recommendation with the amendment that the civil penalty offer be $1,000 and that the principal broker attend either a full meeting of the Tennessee Real Estate Commission within 180 days or complete a 6-hour core class within that same 180-day period. Is there discussion? All right, then let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
Abstain.
And so I've got 6 ayes, one abstention. All right, number 6. Motion passes. Number 6.
20150217441. Complainant states complainant purchased a points timeshare from a respondent in April of 2015. Complainant states complainant contacted the points reservation company and was told that complainant's timeshare was not for points but only a week at the timeshare resort. Complainant states that points had been canceled for the complainant's timeshare 6 months prior to complainant's purchase, but complainant was told it was a points timeshare. Complainant states that complainant talked to someone at respondent's office who contacted the resort to see if it could be switched to a points timeshare, but has not heard back since. Respondent states respondent was unaware that the previous owners had changed the property from points to a week, and respondent was never notified by the resort that this had taken place. Respondent states respondent's office told complainant that respondent would deed the current property out of complainant's name and give complainant a different property with points. At the time of the response, respondent states respondent had deeded the timeshare out of respondent's name and was in the process of deeding a new one with points. Respondent provided a copy of the quitclaim deed releasing the property from complainant's ownership dated August 18, 2015. Office of Legal Counsel followed up with the complainants on February 29, 2016. Complainant states that respondent has not deeded complainant any property and complainant paid the maintenance fee for this year on the property that was deeded last year. Complainant states respondent will not return complainant's phone calls. The recommendation is $500 for violation of TCA section 6632 121 F2F. Makes any willful or negligent misrepresentation or omission of material fact about a timeshare, and $1,000 for violation of TCA section 6632 121 F2H, improper, fraudulent, or dishonest dealing.
Okay, this is the respondent is a firm, right?
Correct.
It's
Yes.
a firm license we're talking about.
Right.
So the history, is there something still under review in history with this firm?
Yes, this may be one. I can't recall if this one's on this report or not, but it's another complaint that's open that hasn't been presented to you all yet.
Then I'd like to make a motion that we accept council's recommendation, but change the $500 for violation 6632 121 F2 to $1,000, and that they attend a meeting, an 8-hour meeting of the Real Estate Commission for within 180 days, or
Let me, could I interrupt? Since
Yes.
it is a firm, I don't think
it's a
we.
firm.
so-
I know. That's what I'm
Okay,
sitting
we
there
can't,
thinking, wait.
we don't
I
want to,
can only give them a monetary.
Yeah.
Okay, so
or you could take their license if you wanted to. I'm not recommending it, but you
I'm
have
not-
that option.
Yeah, I just say increase it. Council's recommendation with the exception of increasing the 500 to 1,000 for $2,000 total.
I ask a question, and of course, we don't know who this is, but council does know who this is. And when we hear these reports, and you say there's another one under review, is this a firm that has a history of having complaints consistent? I don't know what consistently would mean, but are they that have have had several complaints or a number of complaints?
Well, I don't list them on the history unless it actually resulted in a discipline, because a firm could have a lot of complaints filed against them and none of them have any merit to them.
Okay.
So but anything that's resulted in any type of disciplinary action is listed here. So other than the one that hasn't been presented to you yet, the other one, they haven't had any.
Right.
And that's why I leaned more to the $1,000, since we don't know what that is, but we do know that something's under review. There
Okay.
seems to be at least two occurrences.
Can we have a second to Ms. Frank's motion? Motion seconded by Ms. Taylor. Is there discussion on the motion? All right, the motion is to accept council's recommendation with the exception of increasing the $500 violation to $1,000 first mentioned in the recommendation. All right, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Next, number 7.
201502176001. Complainant states that the management agreement between complainant and respondents LLC is invalid because respondent terminated respondent's affiliation with his firm toward the end of 2013 and started respondent's own management company and did not disclose that the new company would be taking over the management agreement and did not give complainant the option of staying with the old firm. Complainant states that it was not disclosed to the commission that another agent who is affiliated with respondent's new firm is also the HOA representative for the property owned by the complainant. Complainant states that as soon as complainant gave notice of termination of the agreement to respondent, the other agent, HOA representative, contacted complainant on behalf of the HOA, stating the rental property was in need of attention and it was never disclosed that the HOA representative also worked for the new management firm. Later that month, complainant got an email from respondent using the other agent HOA rep's firm email address, stating that the HOA had notified them of repairs needed on the property. Complainant states that respondent is refusing to release the tenant's security deposit without cause and is requesting management fees almost 2 months after complainant's termination letter. Respondent states that the management contract is enforceable between respondent and the new firm because the contract states the agreement shall be binding upon the successors and assigns of agent. Agent is designated in the agreement as respondent/respondent's old firm. Respondent states that all of the management agreements obtained by respondent while an agent at the old firm were assigned to the new firm. Respondent states complainant was made aware of the transition via phone calls and letters and could have terminated the agreement with proper notice, but elected not to. Respondent states complainant called and emailed the new firm and signed an authorization giving the new firm authority to direct deposit in and out of complainant's bank account. Respondent states that the commission obligations stated in the agreement are still owed by complainant. Complainant states that respondent was informed of how to give proper notice to terminate the agreement in order to not pay fees or penalties, but it was never communicated to complainant that commission's obligations would be waived. Respondent states that the other agent, HOA representative, was already a representative of the HOA before joining respondent's new firm, and that she did not have authority to assess fines for the homeowners association unless instructed by the board. Respondent states that the HOA and the management company have no agreements or affiliations other than they manage several homes in the neighborhood. Respondent states that in order to protect the tenant from the management company's contractual obligations, respondent needed written authorization from the tenant in order to release the security deposit to the complainant. Respondent states that after some back and forth, respondent received a signed security deposit release from the complainant signed by the tenant. However, the signature on the form and the lease did not look similar at all, so respondent needed to verify it with the tenant verbally. Respondent states that respondent left several messages with the tenant finally got confirmation on October 17th. Respondent then mailed the escrow funds to complainant. A letter dated January 15th, 2014 from the new firm to their client states that they opened the new firm in 2013. A form dated February 8, 2014, and signed by complainant authorizing the new firm to direct deposit into complainant's account was provided by respondent. Several examples of correspondence between complainant and the new management firm were provided, so it appears the complainant knew which company complainant was dealing with, even if there was no formal notice of transfer given. HOAs do not fall under TREC jurisdiction, so it's legal counsel's opinion that this is not a conflict of interest that must be disclosed. Email correspondence from the tenant shows the tenant requesting the security deposit to be transferred by complainant by Monday, September 21st, 2015, with the transfer form attached, but the funds were not sent to complainant until October 27th, 2015 or later. Recommendation is $500 for violation of Rule 1260-02-.098. Trust money shall be dispersed in proper manner without unreasonable delay. And 9, trust money shall be dispersed within 21 days of written response.
Question.
Yes, ma'am.
So HOAs don't fall under TREC. Where do they fall?
They have to be registered with the state.
So whose jurisdiction is that?
I wasn't aware that they have to be registered with the state,
I
so
had
I
to
don't know.
drive the 250 miles to Nashville to get a copy for a lender the other day, and paid $20 to the state to get a copy.
I mean, was it from the Secretary of State's office that it came from? So they may just have to be registered as a business, not necessarily with an agency, a regulation agency. But that's just a contractual agreement between the HOA and the residents. I don't think they fall under anybody's agency jurisdiction.
Because they're not selling, they're maintaining.
Most of them, it seems like, from when they've come up in complaints, mainly just liaise between residents and the board is what it seems like to me in most cases.
Okay, so your recommendation is based on the fact that the previous management company wouldn't release money to the new management company?
That's the only thing I saw from the documentation that was provided. Just we have an email from the tenant saying, please give my funds by this. I think it was written on a Thursday or Friday. Said, please give my funds to the owner of the property by Monday, and it didn't happen until like a month later. So
it didn't. I mean, obviously, they can't necessarily demand it be released overnight, but the company still didn't release it within the 21 days from request.
Right.
And it was a security deposit?
Right.
Yeah, in escrow.
Chair is looking for a motion.
Do we want to increase that or keep it? I make a motion that we accept council's recommendation with the exception of raising the number from $500 to $1,000.
Second.
All right, you've heard the motion.
Do we want any classes?
And the motion simply says the civil penalty, if agreed to, would be $1,000. Further discussion. Let's vote on the motion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. We're going to take a break after the next one, it's a long one, and I want you all to know we get these in advance. But if I had to write this for me to read, it would drive me crazy.
Slit my throat.
I know. So go ahead.
That's
Ms.
why
Kirby.
we're over here and she's over there. She's near the exit door.
20150217691. Complainant seller states complainant made it clear to respondent that they need a bottom line amount in their pocket after all commission and fees were paid. Complainant states they signed a listing contract at their house during respondent's first visit on July 22nd, 2015, but never received a copy. Complainant states that respondent encouraged them that they could list for up to $515,000. Complainant states that as soon as respondent convinced him to sign a listing agreement, respondent asked him to have an appraiser. Respondent was promoting appraise the house. Complainant states that when complainants declined to do so, respondent offered to pay for the appraisal. The appraisal came in at $480,000, and complainants believe respondent overpriced the house to get complainants to sign the listing agreement, knowing that it would not appraise that high. Complainant states that the appraiser may work for someone in the same real estate company as respondent. Complainant states that an offer came in and was accepted on August 2nd, 2015, but during the inspection period, the buyers wanted $1,000 and painting done. Complainant said no because that would put the bottom line below what they originally determined, so the offer fell through. Complainant states that the house was removed from pending status and shown 2 more times on August 29th. Complainant states complainant received good feedback from both potential buyers, but did not hear from respondent for days after. Complainant states that once they heard from respondent never followed up regarding the 2 showings. Complainant states that due to extenuating circumstances, they had to postpone selling the house until spring. Complainant states complainant talked about postponing the listing until spring on September 1st, and respondent went into a rant stating respondent wouldn't let complainants out of the contract. Complainant states complainant could not reach respondent again by phone but never made contact, so complainants contacted respondent's broker. Complainant states respondent's brokers said complainants could either sign an agreement stating they would not sell during the contract period or give the contract to respondent in the spring. Complainant states that complainant finally heard from the respondent on September 10th. Complainants decided to give respondent another chance and gave respondent the conditions upon which complainants would keep working with respondent. Complainant states respondent ranted about how long respondent had been an agent, how much money complainants had cost respondent, and that complainants were the reason the first contract didn't go through. Complainants state they have not heard from respondent since their home is still on the MLS, but they have no way of knowing if it's being promoted. Respondent states respondent prepared comps for the listing appointment, and they were consistent over and over that the price points were in the mid to high 400s. Respondent states that respondent told complainants that listing at a higher price might run them into an appraisal issue and encouraged them to get an appraisal from an appraiser that was working for them and not for the buyer or lender. Respondents state complainants said they were expecting the house to appraise around $475,000 but wanted to list at $500,000 despite comps and advice from respondent. Respondent states respondent didn't even know if respondent had the listing agreement on July 22nd, and the listing agreement was not signed until July 28th. Respondent states complainant called and made an appointment with an appraiser right after the listing meeting on July 22nd, not after they signed the listing agreement as alleged. Respondent states that the contract offer was received and negotiations were taking place before the appraiser said he didn't think he could find the value of $500,000 but would do his best. Respondent states complainant then decided they didn't want the appraisal after the appraiser had done half the work, so respondent offered to pay for the appraisal to ensure the contract would close. Respondent states respondent gave complainant a page in the listing presentation that had 4 appraisers on it. Complainant picked one of those appraisers. Respondent states that after negotiations, a full price offer was accepted. Respondent was concerned about the appraisal, so respondent offered to discount respondent's commission by 1% in order to make the deal work and have the same net for the seller. During the inspection, the buyer requested for the seller to add a vent above the closet door that houses the water heater per codes and $1,000 for whole house painting credit, which the seller refused. Sellers offered another proposal, which included pushing closing out 2 more weeks, which caused buyer to cancel the contract. Respondent states complainants wanted to keep the earnest money, but when they were told they could not, they wanted to go back to the buyers and agree to do the work, but the buyers were done. Respondent states that respondent emailed feedback from showings as they received it from other agents, and that any other feedback complainants received they must have got by contacting agents directly. Respondent states complainant did not say they wanted to take the home off the market until September 1st. On September 4th, respondent states respondent requested that complainants reimburse respondent for marketing expenses or at least split the difference because respondent had spent over $400 in professional photos, $350 on the appraisal, a week of graphic design work on the marketing material, special paper, color copies, and staff time. Respondent states that complainants never returned respondent's call from the September 10th and declined showings after that. Respondent states that communication was great and complainants were very happy until the contract was canceled and complainants blamed it on respondent. Respondent feels like complainants expected respondent to give up another $1,000 for the repairs. Complainant submitted no supporting documentation. Respondent submitted transaction documents, email correspondence, and other related documents. There is documentation to support most of the respondent's versions of the events. The rest is he said, she said, while complainants did not sign the listing agreement until July 31st instead of July 22nd. As stated, there is no documentation to support that they were not given a copy at the time of execution. It appears that the listing agreement was signed by hand instead of via dot loop like the subsequent contracts and counters, etc., so counsel is unable to make a determination as to whether or not a copy was provided to the complainants. The recommendation is to dismiss.
Motion to approve council's recommendation.
Second.
Motion by Commissioner DeChara, second by Commissioner Hills, that council's recommendation be adopted and this complaint be dismissed. Discussion.
I'd just like to say one thing.
Yes, ma'am.
If someone does not want you to work for them, you do not want to work for them.
Right.
Don't cram things down people's throats. And now it's gotten to this point. So there's lots of times you don't need to take a listing,
Or
especially
walk
the
away.
second time.
All right. Thank you, Ms. Franks. Any other comments? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. I was wrong. We have one more short complaint.
20150217721. TREC opened a complaint against.
Motion to dismiss.
Second.
This is a complaint against the principal broker for failure to supervise the previous broker. Since we did not find the previous affiliate guilty of anything, it's hard to find the principal broker guilty of failure to supervise. So almost automatically, we'll get a motion to dismiss against the broker in a case like that, which we did in this case, made by Commissioner DeChara, seconded by Commissioner Franks. Is there discussion on the motion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now let's take a 10-minute break. We're going to keep moving as quickly as we can and as thoroughly as we can. Whenever you're ready, Ms. Kirby. And I know it may be a second.
Sorry. Yeah, peanut butter in her mouth.
She had to have some chocolate too.
Okay. 20150218701. Complaint was filed against respondent stating that respondent runs a company that buys, rehabilitates, and sells homes.
Wait just a
Wait a
second.
minute, you missed number 9.
No,
Are we on 9?
number
We
10.
did.
We're on
Number 10.
10.
Okay,
We
okay.
dismissed number
Excuse
9.
me. Okay.
You are correct. Sorry about that. 20150218571. Consumer filed a complaint alleging that respondent, buyer's agent, discovered a walk-in crawl space to a property 5 days before closing and did not disclose the information to complainant buyer. Complainant states that the crawl space exposed structural damage to the home. Complainant states that the local association heard the complaint and found respondent in violation of Articles 1 and 2 of the Code of Ethics. Complainant further alleges that respondent advised to have the garage removed and states that this is a violation because respondent is not a contractor. Respondent sent a response via an attorney who contends that respondent met all obligations to the complainant, stating that complainant was or should have been aware of the crawl space because complainant toured and inspected the property in person. Respondent states that complainant discovered the property and insisted on seeing it the same day, so respondent arranged for the listing agent to show the property. Respondent states that the exterior door is plainly visible, and complainant hired a home inspector who addressed the condition of the crawl space in his report. Respondent further states that the termite inspection report also made reference to the crawl space. Respondent also states that complainant waived the right to be present at a final walkthrough of the property prior to closing. Respondent contends that if structural damage did exist, the home inspector would have addressed it. Respondent denies advising complainant to have the garage removed and states that complainant acknowledged that the respondent was not a contractor in the buyer's agreement and disclaimer notice that was executed on April 22nd, 2015. Respondent requested the dismissal of the complaint. Office of Legal Counsel reviewed the transaction file and the home inspection provided by the respondent. There's a section in the home inspection labeled crawl space, which includes pictures and several notes. With regard to the foundation walls, the condition states satisfactory. There are pictures of the floor joists in the crawl space with a note stating, there have been some repairs done to the floor joists, but the floor is still slant in some areas. Monitor this item. With regard to the columns, there are pictures and a note that states, there have been some added steel and wooden columns, and the condition states satisfactory. The purchase agreement was entered into on April 23rd, 2015, and the home inspection took place on April 28, 2015. Property closing of the property appears to have taken place on or about May 18th, 2015. The recommendation is to dismiss.
Motion to accept.
Second.
Motion by Commissioner Hill, second by Commissioner Wood, this complaint be dismissed. Discussion, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes
And
unanimously.
on the history, it says litigation monitoring.
Yeah, that's there was a complaint filed several months ago that also had litigation in civil court. So we are awaiting the conclusion of that.
Different complaint.
Different complaint.
Okay,
Yeah.
that's what, thank you.
Number 11.
2015-02-18701. A complaint was filed against respondent stating respondent runs a company that buys, rehabilitates, and sells homes. Complainant states that respondent does not disclose or advertise respondent's firm affiliation. Respondent sent a response stating that all properties in question are owned by the development company, LLC, and none of its properties are being listed on the MLS but are sold directly by the corporate owner. Respondent states that the development company consists of 4 corporate entities which operate under the trademark name Hereinafter Development Company. Respondent is an owner of a development company who states that the license was obtained in April 2015 in order to purchase and list properties that the development company does not own. Respondent states that respondent has only listed one property that the development company does not own, and that the listing was done through respondent's affiliated firm with firm advertisement. Respondent questions whether or not the signage for the development company needs to include owner agent on it if one member of the company has a license. Respondent states that the development company wants to be in compliance with TREC regulations and has been proactive in reaching out to TREC staff to ensure compliance. It is respondent's understanding that the development company is operating as for sale by owner. Office of Legal Counsel reviewed the development company's webpage, which states that it buys homes, sells homes, and pays for credit restoration with the Lease to Own program. The website states that the respondent founded the development company, and it does not indicate respondent is a licensee. There are multiple homes listed as for sale, listed as available for sale for rent, and several properties represented as sold. Respondent states that the development company is exempt pursuant to TCA section 6213-104A1A. This chapter does not apply to an owner of real estate with respect to property owned or leased by such person. Person is defined in this chapter and does not include a limited liability company. In addition, according to the Attorney General, limited liability companies are not exempt pursuant to TCA section 6213-104A1F. It appears to legal counsel that respondent is a broker who is founder of an unlicensed firm engaging in the business of real estate, with the firm name being different than the name of the limited liability company. Further, on respondent's website under frequently asked questions, the answer is no to the question, are you real estate agents? Recommendations to consent order in the amount of $1,000 in violation of TCA section 6213-309, an unlicensed firm, and TCA section 6213-312B4, misleading or untruthful advertising. And that should actually say 14 at the end of there.
So it's 1,000 for unlicensed, and how much for the untruthful advertising?
I just put those together with the 1,000, but if you want to do 1,000 separately, you can do that.
So my understanding, I thought the reason for LLC was to separate it. So how does the owner of the LLC claim to be? I think there's a wedge there.
It's what we were talking about this morning about the LLC and the Attorney General's.
Right, and that's why I was saying I disagree with the fact that they think they fall under the
I don't
exception.
think they do.
Right.
I mean, because that's the whole purpose.
So you're agreeing with counsel?
Yeah.
Yeah, we're agreeing.
Low to be.
Agreeing with council, I say $1,000 for each.
All right, so we have a motion here
Second.
offered by Commissioner Taylor that instead of 500 for each violation, that it'd be 1,000 for each violation for a total of $2,000.
And they also have under legal review a duplicate complaint.
That's coming up.
That's the next one.
Okay.
That's coming up.
I would ask Councilman DeCharo, is there a
Well, they're not licensed,
Yep.
right? No, they're affiliate brokers.
The person, the founder of this company, is licensed individually
And is a broker.
as a broker, but the company is not.
I would say core course or 8 hours.
All right, and so the same language for the core course.
Licensed 2015.
Yeah, so
April of last year. Yeah.
Now, this is the affiliate broker.
That's what I'm confused about.
This says affiliate broker.
Yeah, this person's an affiliate broker.
Narrative.
I said that that he was a broker, had a broker's license.
So he's an affiliate broker affiliated with a firm, but he's also operating this other company that he's claiming he can do outside of his real estate license because of the owner exception.
Oh.
With the LLC.
Well, everybody's agreeing.
So is it the same, would you recommend?
I
wish we had a registry of classes, but
Next month.
Core would probably still be the closest thing to give him a broader spectrum of how he needs to be operating.
New things that they probably don't know.
But by being an affiliate broker, he's going to have the core anyway. So would it not be better to make
Have
it
something else?
make it a contracts class or something like that?
Well, I don't think contracts is what he needs. What do you think he needs, Bobby? You're an instructor too. What do you
teach, Bobby?
Maybe agency.
Let's not get off the topic.
Agency. What about agency?
Maybe a contracts, 4-hour contracts, 4 hours agency.
Yeah, that's good.
or ethics?
I thought it was. Okay, so the motion on the floor is to accept council's recommendation with the exception of increasing the civil penalty to $1,000 each for 2 violations and requiring the licensee to either attend a full meeting of the Tennessee Real Estate Commission within 180 days or taking 8 hours of approved education, 4 hours of which would be for contract and 4 hours of which would be for agency. In any case, according to the motion, those that attendance, those 8 hours would not apply to a continuing education standard. That's the motion. All right, let's vote. If you're in favor of that motion, vote aye.
Aye.
Opposed, no. That motion passes unanimously. All right, now number 12.
201502185991. This matter is duplicative to the above reference 201502187001 and should be closed as duplicative. Recommendations to close with no further action.
Motion
approved.
Motion by Commissioner Frank, second by Commissioner Hills, that council's recommendation be adopted and this complaint be dismissed. Discussion, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 13.
20150218721. TREC opened a complaint against respondent principal broker for failure to supervise the previous respondent affiliate broker in case 20150218701 above. Respondent states that prior to licensure, affiliate broker worked with several licensed agents at the firm to buy and sell properties for several years and decided to become licensed to buy properties for the development company and to make referrals to the other agents at the firm. Respondent told affiliate broker to be sure to disclose that he's a licensed agent and his personal interest when transacting for the development company. Respondent states that affiliate's broker's attorney created a personal interest disclosure document to have signed during any contract negotiations, which respondent states has been used since April 2015. Respondent states that any of the development company's properties listed through the firm are marketed as agent owner on the signs and include the personal interest disclosure on the MLS paperwork. Respondent states that affiliate broker's attorney advised that the development company's signs did not need to state agent owner. Respondent states that affiliate broker wanted to hire an agent and pay that person a salary as an assistant, and respondent told affiliate broker that it was not allowed. Respondent called TREC staff and learned that all money must go through a principal broker and firm, and that the affiliate broker could not pay the assistant agent a salary. TREC staff also advised that the development company likely needed a firm license and a principal broker. Respondent provided this information to affiliate broker, and they consulted with an attorney who stated this was not necessary. Affiliate broker met with respondent to discuss respondent becoming principal broker of the firm if they applied for licensure, but respondent wanted some questions answered before doing so. Respondent further states that the affiliate broker and attorney were in the process of checking with TREC staff to see if the development company could sell properties without using a real estate firm, and respondent has not received any information as of November 27th. It is apparent to legal counsel that respondent was knowledgeable about the development company and received information from TREC staff that the company needed a firm license and principal broker. However, it does not appear the steps have been taken to obtain licensure. Recommendation is consent order in the amount of $1,000 in violation of TCA section 62, 13, 312, B14, and 15. Failure to supervise.
So they're continuing, even though they've talked to TREC staff.
What it appears
And
to
it's
us.
a principal broker.
So, I guess your point is that TREC gave good advice. The principal broker understood the advice, but he didn't enforce.
Apparently, they were advised otherwise by their attorney.
So the fine or the consent order agreement is because instead of listening to TREC, they listened to an attorney. I'm trying to just
Doesn't
get it.
matter if they listen to an attorney or not. It matters if they didn't do it.
Well, I mean, if they have an attorney advising them, they don't have to. I'm not saying that's a mitigating factor, but at least it's an argument we hadn't heard before.
Right. I mean,
Bring their
you
attorney
can
in,
definitely
we'll talk
consider that.
We'll talk about it.
Real estate rules and regulations, that's it.
I'm not disagreeing. I just want to make sure I understand. Because I imagine if we take this consent order to this principal broker, he'll go straight to his attorney.
Who's probably his cousin.
Well, now don't know that.
Well, I think that the attorney was actually the attorney for the affiliate, and that then the affiliate broker just relayed the advice that his attorney had given him. I'm not sure that the attorney's actually advising the principal broker. I don't know that matters, but
I've asked enough. Is there a motion? Have we already got a motion on this one?
No.
Is there a motion?
I would raise this to 1,000 each.
it's just
It's
the
one-
one.
it's
It's just one.
So
14 and 15 failure to supervise. Oh, excuse me.
Unless you see another violation.
Right.
We'll be happy to go along with you if you find one.
Is 2,000 the most we can do? On
Just
1,000.
one. B14 is just the one that says the commission can authorize discipline for any violation of rules or statutes to tie in the civil penalty range.
Motion to accept council's recommendation.
grudgingly made
Second.
by Commissioner Hills. Motion to accept council's recommendation, seconded by Commissioner Franks. Discussion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 14.
201-502-18741. Complainant hired respondent's property management firm to lease out complainant's property. Complainant states that 6 months into tenant's 1-year lease agreement, the tenant put in 30-day notice to vacate. Approximately 45 days later, complainant notified respondent's firm that complainant decided to sell the subject property, and complainant states that respondent advised that the tenant decided to stay on a month-to-month basis. Complainant states that complainant was not notified of the change in lease agreement and did not agree to it. Complainant states that the tenants put in 30-day notice to vacate on August 17, 2015, and states that respondent's firm had not completed the final walkthrough. Complainant states that complainant's listing agent took pictures of the property showing repairs needed, and complainant requested this be paid with the tenant's deposit. Complainant states that respondent's firm has yet to respond. Respondent sent a response stating that complainant signed a 1-year property management agreement that renews yearly unless complainant notifies the firm in writing. Complainant states that there were tenants in the property when the management agreement began, and respondent performed an initial inspection. Respondent states that when the first tenant moved out, complainant decided to have the property interior and carpets professionally cleaned and replace damaged deck boards. However, complainant opted not to paint the interior walks or replace the blinds. Respondent states that the new tenant signed a 6-month lease with a month-to-month clause upon expiration and requiring 30 days notice to vacate. Respondent states that the tenant gave 30 days notice to vacate on March 19, 2015, but decided to stay. Respondent states that the office assistant notified complainant. Respondent states that the tenant moved out on August 20, 2015, and complainant's listing agent inspected the property on or about August 25, 2015, and shared photographs with the complainant. Respondent inspected the property on or about September 2, 2015, after talking with complainant about the photographs of repairs. Respondent states that the condo needed interior cleaning, replacement of blinds that were broken upon the tenant's move-in, fresh paint, and the carpets had a pet odor. Respondent stated that this tenant did not have a pet, but the previous tenant did. Respondent states that the tenant was notified in writing of the damages and the security deposit was forwarded to the complainant. Respondent explained to complainant that they could not charge for replacing the carpet and interior painting, but they could charge for interior cleaning, carpet cleaning, missing outlet covers, missing mailbox key, and touch-up painting. Office of Legal Counsel reviewed the transaction documents. The property management agreement was for a 1-year term from August 15th, 2014 through August 14, 2015, and following until 30-day notice is given. In the management agreement, the owner gave the agent authority to sign leases for terms not in excess of 1 year and to renew or cancel the existing lease and prepare and execute the new lease without additional charge to the owner. Respondent also provided a lease agreement for a term beginning October 17, 2014 through April 16, 2015 with a month-to-month holdover clause requiring 30-day notice. Respondent also provided owner statements for the management term, and it appears that the rental deposit in the amount of $650 was provided to the complainant on or about September 10, 2015. Respondent notified the tenant of the forfeit in writing on or about September 1st, citing damages found. The recommendation is to dismiss.
Motion to accept council's recommendation.
Motion by Commissioner Hill, seconded by Commissioner Taylor, that council's recommendation be adopted and this complaint be dismissed. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 15.
20150218811. Complainants were under contract to purchase a home with a financing contingency. Respondent was a listing agent. Complainant stated the purchase contract stated that the loan applied for would be a 100% rural loan, which was denied. Complainants further state that after being denied, they researched conventional loans and discussed the matter with 2 additional lenders but were not able to secure a loan with an affordable payment. Complainants state that respondent is refusing to return the earnest money to complainants. Respondent states that the earnest money was handled through the firm's and principal broker. Respondents state that the earnest money check was received by the respondent's firm on August 17, 2015. Respondent received the earnest money disbursement and release form from complainant's agent on September 1st, 2015, stating they had been denied for the loan. Respondent states that the earnest money was released on September 16, 2015, and complainants personally collected the earnest money disbursement check from respondent's office. Respondent states that the purchase contract required the money to be made out to a different company at a different address than respondent's firm, but the earnest money check was made payable to respondent's firm and delivered there, which caused a delay in processing the reimbursement request. The earnest money disbursement request and release was electronically executed by complainants on September 1st and accepted by the seller on September 17th. The earnest money disbursement check was dated September 16th and made out to complainants. The recommendation is to dismiss.
Motion to accept council's recommendation.
Motion by Commissioner Hill, seconded by Commissioner Wood, that this complaint be dismissed. Discussion? All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously.
20150227441. TREC opened a complaint.
Motion to dismiss.
Motion by Commissioner Char, seconded by Commissioner Hills, that this complaint be dismissed per council's recommendation. Discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 17.
In 20150218941. In 2008, complainants purchased 2 lots in a subdivision in which respondent's firm was the listing agent. Complainants state that the listing agent, previous principal broker, now deceased, advised that the sewer system was registered with TREC. In October 2012, a TREC representative advised that the sewer system was illegal or unapproved. Complainants have since learned that the sewer system is legal but can only service 9 homes with 27 bedrooms total. Complainants state that the owners cannot pull electrical permits to build until the sewer issue is resolved. Complainants state that respondent's firm may have known about the issue when the lots were sold. Complainants further state that one of the lots advertised a boat ramp, but there's no boat ramp on property to date. There have been several complaints opened against respondent by the other homeowners regarding the same issue. Respondent states that of the 14 lots of this subdivision, the previous principal broker, now deceased, sold 10 of them, and respondent was not involved in any sale with respondent. Respondent's response mirrors the response provided for complaint 201501857, which was presented in November 2015 and was presented as follows. Would you like me to read this or no?
I'd like to. No, I wouldn't.
Okay.
Haven't we heard this kind of before?
Yeah.
Okay. Then if it's okay, I'd like to just move to accept council's recommendation to dismiss.
Second.
I'm all about that, if you don't mind reading the last paragraph in
Sure.
the record.
Office of Legal Counsel reviewed documentation provided in complaint 201501857 and determined, while there seems to be a host of problems with the septic system on this development, it does not appear that respondent got involved until much of the problem already existed and respondent relied on information others had provided. It does not appear respondent made any willful representation, produced any misleading or untruthful advertising, or conducted any improper, fraudulent, or dishonest business. And the recommendation is to dismiss.
Okay, and that motion now is made by Commissioner Wood, seconded by Commissioner Taylor, that council's recommendation be adopted. Is there discussion? All in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
And therefore, I say dismiss.
Okay, this is, without reading it in the record at this point, Ms. Taylor's made a motion that item number 18, file number 2015-0218-961, be dismissed per council's recommendation.
Second.
Second by Ms. Franks. Is there discussion? All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 19.
2015-02-19231. Complainant purchased a property and respondent was the closing agent. Complainant states that the closing documents represented that the taxes on the property were paid in current, but complainant received a statement for back taxes due in the amount of $560. Complainant determined that the county taxes were paid, but city taxes were not. Complainant states that respondent advised the title search agent has missed the taxes in the search and asked complainant to pay the taxes and send respondent the receipt. Complainant did not have the money to pay and states that title search agents are insured to cover mistakes. Complainant states that respondent spoke to respondent's broker and stood firm that the taxes would not be paid. Office of Legal Counsel spoke to complainant, who confirmed respondent acted as a closing agent for the title company regarding a new mortgage complainant was taking out on the property which she already owned. A copy of a newspaper article was included in the file, which states that a complaint was filed in court alleging that a company that respondent is involved in illegally acquired properties through Tennessee's property tax sale redemption process by forging signatures of previous owners to buy back the property within 1 year of the tax sale. The complaint was delivered to respondent's office on or about November 23, 2015, where no response has been received to date. The recommendation is in a consent order in the amount of $500 for failure to respond in violation of TCA Section 6213, 313A2, and TCA Section 6213, 312B14, and also to open a subsequent complaint against respondent and the other licensee listed as a defendant in the court complaint.
I want to raise that amount to $1,000.
Do we need to wait, though, until this court complaint is?
Well, not necessarily on that. Now, is that two different violations that we can do 1,000 each on?
No, B14 is just tying in the civil penalty. The court complaint is concerning, obviously, so that's why I suggested opening a complaint based on that. But in this particular complaint, she was acting as the title agent and not as a licensee. I mean, there wasn't even a sale of property here. The person already owned the home, and they just took out another mortgage, I guess, to do some repairs. And so it really wasn't even a real estate transaction.
So the failure to respond, the failure to
Right.
respond is the problem, even though the complaint wasn't filed against an activity of a licensee. I mean, can you, does that?
Right. I mean, they're required to respond if a complaint is filed with the real estate commission and it's sent to them, they're required to respond by statute,
if it's-
regardless of whether the complaint is noteworthy or not.
Okay. So the motion, Ms. Franks, I'm sorry, Mr. Chara, is to increase the civil penalty to $1,000. Are you in agreement with opening the complaint?
Absolutely.
So that part of the recommendation sticks. And there was a second by Ms. Hills, as I recall. So the motion is to approve council's recommendation, increasing the civil penalty to $1,000. All other portions of the recommendation from the Office of Legal Counsel remain. Is there discussion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 20.
2015-02-19411. TREC opened a complaint against respondent principal broker for failure to supervise previous respondent affiliate broker in case 2015-02-19231.
Motion to dismiss.
This is a little bit different. because-
It's still, she's recommending dismissal on it.
I know. I'm all about it. I'm going to vote for your motion. I just want to make sure, you know, it's a little different.
But why? I'm
Well, there'll
not
be
sure.
another complaint opened against the
Okay.
broker
All right, that's
when the other
reasoning.
complaint's filed.
Okay. All right. I'm all right then.
Well, I think the logic in
Well-
this motion, from recommendation, is the fact that the complaint was against a person who wasn't practicing real estate. So there's no way the broker could be guilty of failure to supervise. Is that my?
No, that's.
I'm sorry, I misunderstood the question.
So the complaint that the previous licensee was involved in and failed to respond,
Mhm.
if that complainant had responded, let's say, and said, hey, I was acting as a title agent, not a real estate broker, there would have been no recommendation to do anything but dismiss.
Correct. And then open the other complaint.
Yeah.
But
Did the broker also, principal broker also receive the notice?
That was my question.
The principal broker received.
He responded.
Yeah, and the principal broker responded.
Yeah.
Okay.
So I think the recommendation is
Okay.
appropriate. It's just a
All right.
little different scenario.
Okay.
All right, let's vote on that motion, which is to dismiss. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 21.
2015-022-0041. TREC opened a complaint based on unlicensed activity. Respondent's first license was issued in July of 2005 and expired in July of 2009. Respondent reinstated the license in December of 2009 and it again expired in September of 2013. Respondent retested and reapplied and was issued a license on March 10, 2015. TREC records indicate that Respondent did not have a valid license from September 5th, 2013 until March 10th, 2015. The real estate firm published an article stating that respondent closed on a purchase on September 12th, 2013 from the firm during the respondent's license expiration. A second article was published on July 2nd, 2014 stating that respondent represented the buyer and seller in a sale during respondent's license expiration. A third article was published on November 12th, 2013 stating respondent represented two companies during their lease of a building. A fourth article was published on May 13th, 2014 stated that respondent represented the company in the new lease. Respondent submitted a response by and through an attorney stating that respondent joined the subject firm in 2012 and sent license renewal information in 2013 but failed to confirm the license had been renewed. Respondent's principal broker made respondent aware of the license expiration in 2015 and respondent immediately ceased all real estate activity and retested and reapplied for licensure. Respondent previously agreed to a consent order to pay $1,000 and attend a TREC meeting in resolution of an initial notification that the license was not properly renewed. Respondent had no knowledge that the license was not in good standing from 2013 through 2015. Upon being made aware, respondent took immediate action. Respondent requests the commission be lenient in their recommendation to resolve this matter, stating respondent has never taken actions to lose respondent's license, but the matter is with regard to renewal. Respondent concedes that respondent should have performed better follow-up to ensure license renewal. Recommendation is a consent order in the amount of $1,000 for violation of TCA section 6213-301 and 6213-312B14.
There are multiple issues here, though. First of all, do we believe what's published? That's number one. And if so, that tells me there's multiple offenses, aren't there?
Yeah.
I think you'd have the latitude. There are at least 4 occasions documented that he was practicing real estate without a license. So if you wanted to take the recommendation of council and multiply it by a certain.
I'd like to make a motion that we take the recommendation and we multiply it times 4 occasions and make the total cost $4,000.
Second.
Is that the total of your recommendation?
No, let's see. The 180 days or, all right, let's see, what do we want them to take?
While you're thinking, can I ask a question of Mallory? It talks about that that was published in an article. Yeah. Was it like something in a newspaper saying, look how good this person did? Or?
It was posted on their firm website.
Okay.
Like they have, yeah, it's on their website. There's like a tab where you can click like in, news or whatever.
Or they wouldn't put it on there.
Okay.
Purposely put it on. Probably in the MLS too.
So what course do they need to take 8 hours of?
Well, they're gonna have to have ethics anyway. They're gonna have to have core anyway.
There's a course that teaches people to pay attention. What would that one be?
Well, that's what I'm trying to think of, and we don't have a course that fixes stupidities, so.
We don't need that.
Contract?
Time management.
No.
Well.
What about a law class?
Just a suggestion, professional liability.
Oh, we have a class of professional liability.
So we have plenty of courses offered by hundreds of folks, but I'm saying that's one of the ones that you could pick from.
Is there an 8-hour course?
I don't know that for sure, but
I don't think so. I think there's 4. Let's do professional liability and contracts.
Yeah, that's good.
At least 4 in each.
Within 100.
Okay, the motion offered by Commissioner Franks is to amend council's recommendation take the consent order to $4,000, require the licensee to attend a TREC meeting within 180 days, or take 8 hours of approved education, 4 hours of which will be contract and 4 hours
Professional liability.
Professional liability. And I assume these hours don't apply toward the continuing education
That's correct.
requirement. And so add that to the recommendation as
And I
well.
appreciate Ross jumping in there. Thank you.
Okay, you've heard the motion. Let's discuss it. If there's no discussion, let's vote on it. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 22.
2015-0220081. TREC opening complaint against respondent principal broker for employing an unlicensed broker in complaint 20150220041 affiliate broker above. Respondent submitted a response by and through an attorney stating that at the time of the affiliate broker's employment at respondent's firm, affiliate broker was a fully licensed broker. Respondent states that affiliate broker's license lapsed in 2013 and did not advise the office. Respondent learned of the lapse shortly before receipt of complaint 20150081002 and immediately issued a cease and desist to affiliate broker in writing. Respondent states that affiliate broker acknowledged the mistake. Respondent states that the previous complaint was investigated and respondent believes the complainant's allegations were without merit, but due to the fact that affiliate broker was operating under a lapsed license, respondent agreed to accept the consent order with a $2,000 civil penalty. Respondent states that the current complaint arose from TREC office investigation due to the previous complaint. Respondent reviewed the 4 transactions mentioned on the online articles indicating that affiliate broker participated in the referenced transactions as a broker during the time in which affiliate broker's license was lapsed. Respondent states that affiliate broker had minimal involvement in transaction 3, published on November 12, 2013, transaction 1, published September 12, 2013, and transaction 4, published May 13, 2014, and the main real estate broker involved was another agent at respondent's firm. Respondent reviewed these transaction files and states there were no improprieties in the transaction and noted dissatisfaction indicated from any of the properties in the transactions. Regarding transaction 2, published July 2, 2014, respondent states that affiliate broker's only involvement was that the buyer was an acquaintance and the transaction was handled entirely by a different broker in the office. Respondent states that the parties were satisfied with the transaction. Respondent states that during the time in which affiliate broker's license lapsed, affiliate broker did not work independently on any transaction. Respondent further states that affiliate broker left the firm in April of 2015. Respondent regrets failure to discover the license lapse, and new procedures have been implemented to prevent reoccurrence involving education of agents to be aware of their obligation for a license renewal and continuing education and calendaring renewal dates for sufficient time to fulfill renewal conditions prior to expiration. Respondent requests that the Commission take into consideration the following. 1, the lapse was inadvertent and unknown to the office at the time, and immediate steps were taken to resolve the issue upon discovery. 2, all the core real estate functions in the 4 reference transactions were performed by fully licensed agents, and all parties to the transactions were fully satisfied with their results. 3, affiliate broker is no longer employed at the office, and 4, respondent has already paid a substantial penalty arising from the affiliate broker's conduct. 5, the firm implemented a new policy to prevent reoccurrence. Recommendations: consent order in the amount of $1,000 for violation of TCA section 6213-302. It is unlawful for any licensed broker to employ or compensate any person who is not a licensed broker or affiliate broker for performing any acts regulated by this chapter, and then also 62.312B14.
Really worried about this broker.
So where's the misleading advertisement? Broker says he wasn't involved. They were not involved in so many of the things.
But yet they put it on their website.
Yeah. So who's handling that?
Kind of talking out both sides of his mouth, isn't he?
This is one of those that's either get forgiven and get permission.
Yep. He's also grandfathered.
And they already have a consent order and $2,000.
And 2 TREC meetings.
Chair is open to a motion.
We're pondering.
Let's try this. How about if we make the recommendation that we make it a $2,000 fine?
Well, you'd have to cite another statute. I mean, there's only one statutory violation that I listed here, so it can only be 1,000, unless you determine that there's another violation.
Is misleading advertising not one we could use?
I mean, I suppose you could.
He's the one saying it.
And yet he put it on his website that he was.
I mean, you could. There's also multiple transactions here, so you could do
There
multiple
are-
occurrences of the same
There are also
violation.
multiple periods of time when the license was not active.
I mean, could we not do the same thing to him and do $4,000 since he paid him 4 different times?
They don't seem to be learning. That's one of these that'd rather pay the 4,000, I think.
Core would be a good one for him.
So I'm still waiting on a motion.
Well, we're still discussing.
Well, I make a motion.
Thank you, Ms. Taylor.
That we, fine him $1,000.
I'm not sure him attending this meeting's done him much good so far.
And I'd say one thing: all of this had already been done. Like all of this had already taken place before the first consent order went out. So it's not like they signed the first consent order and then did more, and then it's back in front of us. Like it was all this.
It's not the same occurrence.
Well, the initial complaint was based on a specific transaction that wasn't any of these. And then
Then he came to the
then
meeting.
then the affiliate broker, when we were reviewing the first complaint back several months ago, we looked at, we always look up their license history to put for y'all to see. And we saw that this person had a 2-year lapse in their license. So then we went and looked on to see if they had been practicing during that time, and that's when we found these other 4. So it was all within the same time period that happened before the first complaint even came to in front of the commission.
But that broker has attended 2 commission meetings since.
I'm not sure if they've both been completed yet. I don't think the 180 days has lapsed yet.
Okay.
I'm pretty certain that one of them they've attended one of them. I'm not sure about the other one.
All right, at the moment, I have a motion offered by Commissioner Taylor that says civil penalty of $4,000 and completion of a core class, 6-hour core class within 180 days.
Or attendance at commission meeting.
Well, you had tried to preempt that by saying you didn't think it did much good.
Well, but that was still her motion, so.
I think we have to be consistent as we're doing that out too. If we've given everybody else
That option.
the option.
All right, so I understand your motion to be that a second option would be to attend a full meeting of the Tennessee Real Estate Commission.
I had said that first.
All right, I'm with you. Now, so he might or she might have to already come to 2 meetings. This would be the 3rd then, as I understand it.
They'd rather take the class online.
Well, let them make that decision, but everyone, here's the motion. Who made the second?
I did.
I thought so. Commissioner Hill seconded that motion. Any discussion on the motion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. The motion passes unanimously. 23.
2015-022-0151. Sorry. A complaint was filed against respondents stating that respondent's firm required a non-refundable $595 reservation fee in order to view a rental property. Complainant states that the property was shown to complainant in the dark because electricity was not turned on, and respondent's firm refused to refund the money when complainant did not ultimately sign the lease. Respondent submitted a response stating that complainant submitted an extensive rental application with a $35 application fee on June 1st, 2015, and was approved as a tenant. Respondent states that complainant was initially interested in a different property, but ultimately inquired about the subject property. Respondent states that complainant viewed the townhome twice on June 2nd, 2015, and submitted a $595 security deposit along with the executed move-in agreement and proration schedule for move-in on June 4th, 2015. Respondent states that under paragraph 1 of the move-in and deposit agreement, the $595 is a security deposit for the anticipated lease, which is refundable upon successful completion of the lease. The agreement states if for any reason you change your mind or do not move in or no longer want the property, all the money paid to the firm will be forfeited. It is also understood that if the first month's rent has not been paid on or before the agreed move-in date, all security deposit money and application will be forfeited to the firm. Respondent provided the email correspondence stating that complainant called to change the move-in date because complainant's current landlord required a June 15 rent to be paid to them. Respondent states that if the tenant had paid a security deposit, the firm will hold the property for no more than 30 days. Respondent states that the property was held until the end of June, and an employee of the firm made several attempts to contact complainant to come in and sign the lease. But complainant never informed the firm that complainant did not intend to move in. Respondent states that complainant's allegations are unfounded. Respondent states that the firm does not require a prospective renter to sign a rental agreement and provide a reservation fee before looking at or choosing a property. Respondent states that the only requirement is a nominal application fee after somebody chooses a property to start the application process, which is used to offset the credit report. Office of Legal Counsel reviewed the transaction file, and the fine of $595 appears to be a deposit pursuant to the reference move-in agreement. However, it does appear that the person identified by the respondent that showed the property to complainant is not licensed with the commission. Consent order in the amount of $500 for violation of TCA section 6213-302. It is unlawful for any licensed broker to employ or compensate any person who is not a licensed broker or affiliate broker for performing acts regulated by this chapter, and 6213-312B14.
Hang on, John.
While you're looking, my question is, when it said that that person showed the house, could there be a distinction between, like, can a unlicensed person just go over and open the door and they say, how's this going to work? And he says, I don't know, you need to talk to somebody that's licensed. Can they be a door opener?
Well, they do. We do have an exception for like resident managers for like apartment complexes. So if you have somebody in a leasing office at an apartment complex, it like shows you the apartment or whatever. That could be, but this is a single family residence from what I understand. So I don't think that would, I don't know that there's any exception there.
Okay, recommendation for $1,000 consent order and attendance at a TREC meeting or a 6-hour core course within 180 days.
Second.
Okay, you've heard the motion.
Second.
I got Ms. Hills beat you there.
Oh.
Sorry, though, I appreciate
Ms. Hills is fading on us over there. She's getting lower and lower.
All right, so we're going to accept council's recommendation. However, we're going to amend the consent order to include a $1,000 civil penalty, attendance at a full meeting of the Tennessee Real Estate Commission within 180 days, or at the licensee's option, taking the core class within that same 180-day period. Discussion on the motion. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 24.
2015-0222211. Complainant purchased a timeshare on July 7th.
Motion to dismiss.
Second.
Motion by Commissioner DeChara, second by Commissioner Franks, that this timeshare complaint be dismissed. And for the audience, timeshare people keep more paperwork in the best order ever seen, and no complaint that's ever really been offered against them has gone anywhere based on the files they provide. I think that's the justification for your motion and your second.
And its license is expired.
As well as the firm's license or the licensee?
The licensee, it looks like.
Which is the firm.
Respondent is currently in expired status.
Okay, got it.
12/31/15.
All right, you've heard the motion. It's to dismiss. Discussion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 25.
2015-0222231. Complainant was the potential buyer in a transaction with respondent acting as a listing agent. Complainant alleges that respondent and seller knowingly misrepresented information on the property disclosures with regard to the foundation. Complainant states that it was discovered that the property had been moved from its foundation, and complainant alleges that respondent explained that it had been lifted from the foundation but not moved. Complainant states that the property was moved approximately 10 feet back from the street. Respondent states that in June 2015, the seller met with Public Works and it was established that the subject property had been pinned incorrectly by the surveyor and was built approximately 6 feet closer to the street than approved. Respondent states that in order to become compliant, the seller had to lift the house, add onto the existing foundation, and reposition the subject property correctly. Respondent states that the property was inspected by codes and was approved. At that At that time, respondent and seller spoke to an attorney, a lender, and a title company seeking their opinion on whether or not the property had been moved from one foundation to another. Respondent states that all three parties agreed that the house had not been moved since it used the existing foundation. Respondent met with complainant and complainant's agent on site to discuss miscellaneous requests from complainant and typical blue tape cosmetic items prior to purchase. On August 31st, 2015, respondent states that complainant's agent contacted respondent asking if the house was moved, and respondent forwarded the questions to the seller. Respondent also offered to allow them to get a structural engineer to inspect the property if it was a concern, even though the inspection period had lapsed. Respondent forwarded the seller's response and offered to mutually release complainant from the contract and refund the earnest money if complainant did not feel comfortable moving forward. Respondent states the complainant accepted the mutual release on September 1st, 2015, and it was countersigned by the seller, respondent, and principal broker on September 2nd, 2015. Respondent does not believe the complaint carries merit and states that if the buyer is uncomfortable in the transaction, respondent believes it is in everybody's interest to mutually part ways. Respondent denies collaboration with the seller and purposeful misrepresentation to complainant and or complainant's agent at any time during this transaction. Respondent requests dismissal of the complaint. The file contains an executed residential property condition exemption notification stating that this is a transfer involving the sale of a dwelling provided that the builder offers a written warranty. Seller further marked no to the question. Seller knows that a single-family residence located on the property has been moved from an existing foundation to another foundation. The earnest money disbursement was returned to complainant on or about September 2nd, 2015. The recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Franks, second by Commissioner Taylor, that this complaint be dismissed per council's recommendation. Is there discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 26. Related to the previous complaint.
2015-0222251. TREC opened a complaint against respondent principal broker for failure to
Motion by
supervise.
Commissioner Taylor to dismiss, seconded by Ms. Franks. Is there discussion? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 27.
2016005371. TREC opened a complaint against respondent principal broker regarding information received that respondent's firm did not timely refund a $2,445 to purchasers of a timeshare upon their notice of cancellation. This matter was presented with regard to the exempt timeshare registration in December 2015. The records reflect that the purchasers purchased a timeshare interest from respondent's firm in November 2013. The purchasers entered into a contract with the timeshare exempt registration on May 28, 2015, and sent multiple notices of cancellation on June 2nd, 2015, which is within the 10-day period, and elected to be restored to their original contract. It was determined that respondent's firm was responsible for processing the cancellation request and issuing the refund, which was not processed until October 20th, 2015. The purchaser's timeshare interest has since been restored to its original ownership by respondent's firm. Respondent sent a response stating that the developer of the timeshare plan, who entered into the May 2015 contract, is in an exempt timeshare registration, and the developer accepted the previously authorized consent order regarding the facts presented in December. The timeshare interest purchase was a multi-site timeshare plan, which consisted of individual component site resorts. Respondent states that one of the resorts was developed by respondent's firm, which was the entity that sold the timeshare interest to the exempt timeshare registration. The earnest money deposit in connection with the purchase was placed into the respondent's firm escrow account in accordance with Tennessee law. Respondent states that regrettably there was an administrative error which led to delay in refunding the purchaser's deposit. Respondent states that the refund has been paid in full and the prior contract with respondent's firm was reinstated. Respondent has further implemented new procedures to ensure that this type of error will not happen again. It is respondent's intent to comply with the Tennessee laws and rules of the commission. Recommendation is $1,000 for violation of TCA section 6632-114A. Refunds must be made within 30 days of notice of cancellation. And TCA section 6632-121F2E.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hill, seconded by Commissioner Char. The council's recommendation be adopted. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 28.
2015-0222271. Complainant states that respondent listed respondent's property without complainant's approval and states that respondent ignored complainant's calls. Complainant states that respondent finally told complainant that respondent does not confirm ownership of property and trusts the person listing it, but that ownership would be discovered at closing. Complainant notified TREC staff on December 11, 2015 that complainant would like to remove the complaint. Respondent stated that this is a misunderstanding. This misunderstanding was worked out.
Dismiss.
Motion by Commissioner Franks, seconded by Commissioner Hills. This complaint be dismissed. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
201502225511 and 201500222551. A complaint was filed by property owners against Respondent 1, affiliate broker, and Respondent 2, principal broker, who acted as the property managers for the subject property. Complainants entered into a property management agreement with Respondent's firm on March 17, 2014, and state there were consistent problems with Respondents in carrying out their duties as property manager. Respondents state that there was a 63-inch plasma TV owned by complainants that remained in the subject property for tenants' use. Complainants state that they learned from the tenants on August 27, 2015, that Respondent 1 removed the TV from the property at the beginning of the lease, approximately 1.5 years earlier. Complainants state that initially Respondent 1 stated Respondent 1 did not know what happened to the missing TV, then later stated that the TV was stolen and stated a police report was filed in June 2014. Complainants state that Respondent 1 stated that it is normal practice to avoid conflict between owners and tenant and that the TV would be replaced with a similar model. Complainants state that Respondents knew about the missing item and hid it from complainants. Complainants further state that Respondent 2 informed the tenant in writing that complainants instructed the firm to have the TV removed, which complainants deny. Complainants terminated their agreement with Respondent's firm and requested a refund of the cost of the TV, the management fees that have been paid to date, and the tenant's security deposit. Complainants state that Respondents provided a release letter and returned the tenant's security deposit, but have not compensated complainants for the missing TV. Complainants further state that they contacted the police department and learned that Respondent 1 filed the police report 7 days after the principal broker wrote the letter to the tenant stating the TV was removed at the owner's request. Respondent 1 states that complainants approved the tenants against Respondent 1's advice, and Respondent 1 negotiated an additional security deposit due to the tenant's credit issues. Respondent 1 states that Respondent 1 went above and beyond for complainants, stating that Respondent 1 took pictures for complainants for a maintenance request on the microwave. Respondent 1 denies giving anybody permission to remove the TV from the subject property. Respondent 1 states that upon initial walkthrough of the subject property, Respondent 1 informed the complainants that it was not a good idea to leave the TV in the home and suggested it be removed. Respondent 1 states that upon discovery of the missing TV, complainant notified Respondent 2, who instructed that Respondent 1 file a police report and notify complainants. Respondent 1 states that complainants were informed verbally by phone in June of 2014. Respondent 1 states that when complainants called in August of 2015, Respondent 1 recalled the June 2014 conversation and advised of the police report. Respondent 1 denies that either respondents advised tenants that the TV was removed per complainant's request. Respondent 1 states that the tenants added that wording to a previous email from Respondent 2 when forwarding that message to the complainants. Respondent 1 states that the TV was not part of the lease agreement, and complainants were notified that if the TV was left at the property, then it would be a courtesy of the tenants. Respondent 1 states that the firm will not pay for the TV since complainants can file an insurance claim with the filed police report. Respondent 1 further states that no management fee was provided up front, and the firm does not intend to refund management fees as requested. Respondent 1 was instructed by Respondent 2 to stop all communication with the complainants, and Respondent 2 has consulted an attorney. Respondent 2 states that Respondent 2 has never visited the home and cannot account for the type of TV, and states that everyone at the firm carried out their duties to the fullest extent possible and beyond the normal call of duty, stating that complainants impeded the duties of the firm at times.
Mallory, move to dismiss. Second.
I have a motion by Ms. Franks, second by Ms. Taylor, that this complaint be dismissed per council's recommendation. Any objection? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
201502222191. A complaint was filed by a buyer against Respondent who represented the seller in transaction. Complainant states that there were several issues with the home that were not disclosed by Respondent who had knowledge of the home. Complainant states that Respondent visited complainant at the subject property and commented regarding the home issues, stating that the buyer should have caught the issues and complainant would have to make repairs out of pocket. Complainant further states that there were repairs to be made per the contract that Respondent had not completed, but attested that they had been completed. Complainant further states that Respondent has slandered complainant's name and no contractor is willing to work on the repairs. Complainant has filed legal action with regard to the home repairs. Complainant states that Respondent disclosed all information provided to the Respondent about the listing to complainant's agent. Respondent states that complainant's agent requested contact information on contractors, and Respondent sent estimates and contact information. Respondent states that the estimates were done prior to closing, but that the mortgage company did not require repairs prior to closing. Respondent states that Respondent accompanied a contractor to the subject property on August 10, 2015, per complainant's request to evaluate damage of flooring in an upstairs bedroom, which was under a window that had an air conditioning unit attached. Respondent states that the contractor suggested this was damage from rain blowing in through the window unit. Respondent states the complainant had a home inspection on the property prior to closing, which did not reflect flooring damage.
I'm going to suggest that you read the last paragraph and see if that'll help us.
Office of Legal Counsel reviewed the transaction file. The inspection report dated July 8, 2015 included several comments. The floors were listed as satisfactory and the windows were listed as fair condition, stating that several windows are stuck or painted shut and that and that there are functioning windows without screens. It also stated that the upstairs had 2 window units for cooling and that they are in satisfactory condition. The property condition disclosure was executed by the seller on June 25, 2015. The seller listed that the seller was not aware of any defects, malfunctions to any item. The seller stated that repairs have been made to the roof, deck, patio, paint, and 3 new toilets. A majority of complainants and complainant's agents' allegations are potential wrongdoing by the seller, not the respondent. Seller filled out the property disclosure, and there's no documentation showing respondent have any knowledge to the contrary. Respondent cannot force the seller to do anything or to behave in a particular way. The allegation that respondent started idle gossip about the buyers cannot be substantiated. The recommendation is dismissed.
Move to accept council recommendation.
Motion by Commissioner Wood, second by Ms. Hills, that council's recommendation be adopted. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 32.
201502192771. This complaint was filed by respondent's previous principal broker. Complainant states that respondent left notice on August 9th, 2015 that respondent was moving firms, and respondent took respondent's license off the wall. Complainant states that the TREC 1 form to release respondent was faxed to TREC on August 10th, 2015. Complainant states that the day before, August 8th, 2015, respondent had communicated with complainant regarding a property that respondent was showing. Complainant states that the offer was written for the subject property with the new firm's information and executed by the new firm's principal broker through the new principal broker was not involved with the showing, negotiations, inspection, or closing of the subject property. Complainant states the contract was accepted on August 11th, 2015, and states that respondent was not affiliated with the new firm at that time. Complainant states that respondent handled the transaction when the property was updated to close status on the MLS. Respondent's name was noted. Complainant states that when the complainant contacted the listing firm's principal broker, the MLS was changed to reflect the new firm's principal broker's name again. Complainant contacted the new firm's principal broker, who agreed to pay 1/3 of the 3% commission, but calculated this with the sale price of $125,000, but the sale price was actually $129,900. Complainants allege that the new firm's principal broker should have known the sale price if involved in the transaction. Complainant has requested a copy of the transaction file with the remaining balance for records and has not received it. Complainant also states that respondent had a total of 7 listings with complainant's firm. Complainant printed the listing history on each listing and discovered the respondent updated these listings to expired status. Complainant states that respondent changed the expiration dates, removed the extensions from the files, added new font pages to the listing to make it appear that it expired. Front pages, sorry. Complainant states that 3 of the listings appeared at the new firm within a couple of days. Complainant states that all listing agreements with the firm are for 6 months. Complainant further states that one of the owners confirmed that the listing was not set to expire until November, but the file has been changed to show an expiration date of July 1st, 2015. Complainant relisted with the owner immediately. Complainant alleges that respondent contacted the owner, inducing the owner to sign a listing with the respondent's new firm. Complainant spoke with 2 other owners who stated that respondent promised the new firm would allow for more exposure than complainant's firm. Complainant further states that complainant's home and firm address are beyond the 50-mile requirement. Complainant alleges willful misrepresentation, malicious intent motivated for personal gain, and improper, fraudulent, dishonest dealing. On December 18th, 2015, respondent's attorney corresponded with TREC staff advising of representation and requesting an extension to respond. Respondent's attorney also requested procedural information regarding withdrawal of a complaint by complainant. Office of Legal Counsel reviewed the documents provided. A printout of the MLS dated September 11th, 2015 shows the property's closing date as September 10th, 2015, with respondent listed as the selling agent. The sale price is reflected as $129,500, and printout of the MLS dated September 16th, 2015 reflects respondent's principal broker as the selling agent. There was a check from the respondent's new firm written to the complainant's firm in the amount of $1,125, which reflects the subject property name, and the amount calculated was 1/3 of the 3% commission for a $125,000 sale. Respondent sent a response stating that Rule 1260-02-.13 prohibits the commission from intervening in settlement disputes between firms, brokers, and their affiliates. Respondent contends that the allegations of complaints are related to such dispute. Respondent states that on August 8, 2015, respondent showed 2 properties on the same street and faxed respondent's termination of affiliation and fee to TREC staff. Respondent states that TREC staff asked for respondent to resend the fax on August 10, 2015. Respondent contends that the affiliation was terminated on 8/8/2015 pursuant to Rule 1260-02-.01, which states licensee shall not act under a contract with another firm until completion and transmittal to the commission of the change of affiliation form accompanied by the proper fee. Respondent states that despite the rule, TREC staff advised that the termination of affiliation was not effective until posted on the TREC website. Respondent states that in the meantime, one of Respondent's client asked Respondent to write an offer to one of the properties shown on August 8, 2015, but Respondent was unsure how to handle it since the affiliation transfer was not posted to TREC. Respondent states that the new principal broker advised to list him as the selling agent instead. Respondent states that the new principal broker represented the client as a selling agent per acceptance of a contract on August 11, 2015. Respondent states that upon closing, the listing agent mistakenly listed Respondent as a selling agent on the MLS. Respondent denies responsibility for the error. Respondent states that upon discovery, the error was corrected. Respondent states that on September 14, 2015, complainant contacted principal broker and demanded payment for the property. Respondent defers to principal broker for response. Respondent states that Respondent's compensation was with both offices as the same, and Respondent has no financial gain by placing this transaction with the new firm. Respondent states that complainant's allegations are without basis in either fact or law. With regard to the 50-mile rule, Respondent points out that the distance should be a straight line calculation pursuant to the rule and not driving distance as alleged. With regard to the allegations that Respondent moved existing listings, Respondent states that pursuant to the information provided by complainant, none of these listings were under current contract, all of which had expired prior to the transfer of Respondent's license on August 8, 2015. Respondent states that property 1 listing expired 2/18/15 has never been listed with the new firm. Property 2 expired 6/5/15 and was listed with the new firm on 8/23/16. Property 3 expired on 2/1/15 and was listed with the new firm on 11/23/15. Property 4 expired 8/5/15 and was listed with the new firm on 8/16/15. Property 5 expired 2/8/15 and was listed with the new firm 8/16/15. Property 6 expired 12/29/14 and was never listed with the new firm. And property 7 expired 2/24/14 and was never listed with the new firm. Complainant included printouts for the following listings. Property 1 history was changed on 8/10/15 as withdrawn with the most recent expiration of 3/18/15. MLS was printed on 8/11/15 showing that it was listed with complainant's firm and Respondent as a listing agent with an expiration of 9/19/15. History was changed. Property 2 history was changed on 8/8/15 with an expiration of 8/7/15. The listing in the file shows 2/24/14 through 10/24/14, an extension for 12/5/14 through 6/5/15. MLS was printed on 8/11/15 showing an 8/7/15 expiration. The MLS printed on the 9/11/15 relisted with the new firm on 8/23/15. Property history was updated 8/10/15 with an expiration of 8/8/15. The listing agreement states that it is for 5/13/15 through 7/1/15. The MLS printed on May 19/15 did not include the expiration date. This is the property in which complainant states that the owner confirmed the listing was through November and it was relisted with another agent in the firm according to the MLS with an expiration of November 2015. Property 4 shows that history was updated to expire on 8/7/15. The MLS printed on 5/27/15 shows an expiration date of 8/15/15. The MLS printed on 9/11/15 shows an expiration of 8/5/15. This was relisted with Respondent's new firm on 8/15/15 according to the MLS. Property 5 shows a history that was updated to expired on 8/7/15. The listing agreement is for the 8/8/14 through 2/8/15 with no extension provided. The MLS printed on 8/11/15 shows an expiration of 8/7/15. The MLS printed on 9/11/15 shows it was listed with the Respondent's new firm beginning 8/16/15. Property 6 shows a history updated to expired on 8/9/15. The listing agreement was for 9/29/14 through 12/29/14 with no extension provided. The MLS printed on 8/11/15 shows an expiration of 8/9/15. Property 7 shows a history updated 8/10/15 is withdrawn with the most recent expiration of 6/13/15. The listing agreement is for 1/20/11 through 7/20/11 with the extension for 8/24/13 through 2/24/14. The MLS listing printed on 8/11/15 shows an expiration of 8/20/15 with Respondent at the old firm. According to TREC records, Respondent's affiliation with the new firm is 8/11/15. The distance between Respondent's home and firm affiliation is 46 miles as the crow flies. Consent order in the amount of $3,000 in violation of TCA Section 6213-312B14, improper, fraudulent, or dishonest dealing, and Rule 1260-02-.023. When a licensee terminates his affiliation with the firm, he shall neither take nor use any property listing secured through the firm unless specifically authorized by the principal broker, which is the old rule in effect at this time, and for the initial property and for additional properties 3 and 4.
Would anyone like Ms. Kirby to read that again? Unbelievable. All right.
She's fading.
One more.
Don't be saying that.
So properties three, and other than the first one where the new principal broker actually paid part of the commission, that other than that one, properties 3 and 4 were the ones where we had printouts that said an expiration date passed when, like beyond when this person changed affiliations, that were then later listed as something else with the new firm. So we only had like 2 that actually show documentation of that. The other ones is just kind of, we don't know.
It appears the agent was extending the expiration date without any kind of paperwork.
Well, yeah, it looks like possibly they removed the extensions from the file, like the complainant said, because it was once listed as an expiration of like September, and then after she switched firms, it now has an expiration of before she switched firms. So
Will you tell us where you've shown any leniency in your recommendation?
I did $1,000 for each property. So the initial one where the new principal broker paid part of the commission back to the complainant, and then the 2 that we have the documentation for. So I did $1,000 per property.
That's where the 3,000 comes
That's where
from.
the 3,000 comes from.
Okay, and you didn't put any civil penalty or associate any civil penalty with taking property listings with you?
I put
Or is
those
that-
together. So you could technically do, so we have one statutory violation, 1 rule violation. So you could technically maximum do 6,000.
That's what I was looking for right there. So is there a motion?
That we send a consent order for the maximum of $6,000 with the option to attend a 2-day commission meeting, or I think they need some ethics training. And yes, professional liability or risk management or one of those.
Well, name one. I mean, just.
Which is more readily available, Ross, the professional liabilities or the risk management type? Okay.
Okay, so the motion on the floor is to adopt the council's recommendation with a few amendments. One is to increase the civil penalty to $6,000, and the second is to give the licensee the option of either attending a full meeting of the Tennessee Real Estate Commission within 180 days, or taking 8 hours of approved education, 1/2 of which would apply to ethics and 1/2 would apply to professional liability. And I assume those course hours would not accrue to education requirements.
That is correct, and it has to be done within 180
Yeah,
days.
got that. Okay, everybody understand the motion?
I want to ask a question after we vote.
You don't want to ask? Can't hear you.
Let's say if the ethics class is a 6-hour class and the professional liability is a 4-hour class, that's the only way you can get it. What do we do?
I'd say they have to have a minimum 4-hour ethics and a minimum 4-hour professional liability,
And
so that if they're more than that, that's okay.
And I think we need to change our wording on our next, should we bring the subject up again?
Which I certainly will.
Can the other 2 extra hours be counted towards CE then?
Yes, because we're only
Requiring
8.
Okay.
Y'all have fun keeping up there.
All right. Any other discussion, questions? Let's vote. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. We have one more to go.
2015021991. TREC opened a complaint against respondent for failure to supervise previous respondent in case number 20150219271 above, hereinafter affiliate broker. Respondent asked TREC if complainant was able to withdraw the complaint and states that respondent was a broker beginning August 11th, 2015, and the acts alleged in the complaint were prior to affiliate broker's new affiliation. Respondent denies violation of any TREC laws or rules with regard to failing to supervise affiliate broker. With regard to showing the property on 8/8/15, respondent states that affiliate broker showed the property and submitted the TREC 1 form fee via fax on the same day. Respondent states that information given by TREC staff was in direct contradiction of the rule and states that the faxing of the TREC 1 form on 8/8/15 at 11:44 p.m. made affiliate broker's license valid to practice real estate under respondent's firm. Because respondent and affiliate broker did not receive a clear set of guidelines regarding the transfer, respondent worked the offer for the property that was shown. The contract was accepted 8/11/15. Respondent realized that affiliate broker's previous principal broker, previous complainant, would have issue with the contract proceeds because the date of the initial offer was listed as 8/8/15. Respondent states that since the acceptance of the contract was on 8/11/15 while affiliate broker was at respondent's firm, respondent allowed the contract to remain at respondent's office with the intention of paying the appropriate commissions to the previous principal broker upon closing. Respondent states that the closing occurred on 9/10/15. Respondent received the commission on 9/14/15. Respondent states that the previous principal broker contacted respondent the same day and immediately wrote a check. Respondent admits to making an error on the calculation using the listed sales price instead of the actual sales price. Respondent states that the unpaid balance was promptly forwarded. Respondent states that the previous principal broker stated that no complaint would be filed if she was paid in full. Respondent further states that affiliate broker lives within 50 miles by straight line calculation. There's no violation of TREC rules. It is legal counsel's opinion that respondent failed to supervise the affiliate broker by allowing the affiliate broker to relist previously referenced properties with respondent's firm, although previous complainant had not authorized the removal of the listings. The recommendation is the consent order in the amount of $3,000 for violation of TCA Section 6213 312B15, failure to supervise.
So you got the $3,000 by
The three properties.
3 properties. So you slapped them hard on that one. I mean, we don't have any room to go, do we?
Well, I mean, you could. So I've only cited failure to supervise on here. 3 instances of failure to supervise for the 3 properties. If you wanted to, you could put on the same, the 1260-02-.023 about listing properties secured through the firm unless specifically authorized by the principal broker, possibly. Or you could also call that improper, fraudulent, or dishonest dealing. I mean, you could add other ones if you wanted. I just put the failure to supervise on here for the 3 properties.
I have a question before we decide on that. It says that respondent states that information given by TREC staff was in direct contradiction of the rule and states that faxing the form was acceptable and they could practice. Do we have any verification that TREC staff gave that information out?
Well, I didn't really even hone in on that part because I didn't think it was relevant. Their whole thing that they think is the issue is that this person was doing this with the new firm before the transfer of firm was processed, which really isn't relevant here because even if they had processed the transfer of firm before all this took place, they're still listing properties that they don't have authority to list.
But if they're out showing properties and they have been released from one firm but not accepted at the other firm, they can't practice real estate when their license is not with a firm.
Well, I think they had submitted the TREC 1 form with the new firm on there. The rule
That was by fax, and at the time, fax did not give you immediate acceptance. You had to print the thing from the website showing that you had transferred the license. Otherwise, it had to be posted. Was that not
If they
correct?
fax it, how do they pay the money?
Yeah, because back in those days, you had to pay the money before you could
You could only fax the broker release.
fax it. You just couldn't practice until your money had been paid.
I think what they're saying is the old rule states the form must be faxed, mailed, or emailed to the commission to be effective. So I think they're interpreting that as once it's faxed, it's effective.
But that's
That
not
and the
No.
money.
Yeah, and that's not true, so I don't care really what their interpretation is. They were practicing real estate while their license was in limbo.
So I think council agrees. The question
So
is,
I think the broker has failure to supervise issues there,
And that's what she has.
that's what she has.
big time. Well, but not just on the listing the properties.
On him practicing too.
Yeah, on him practicing too.
Mm-hmm.
If they're not legally with your company, are you legally bound to supervise them?
Well, if the other brokers release them, that, we've gotten into this before about where does the responsibility lie. But the new guy's not denying that he belonged to him.
Well, the old rule says the principal broker's supervisory responsibility for the future acts of the licensee shall terminate upon the commission's receipt of the release form. So I don't think that the old principal broker is responsible.
No.
I mean, they were the complainant, so I don't think that would even.
But I think
matter here,
once they have done their part and released them, they're no longer under their supervision. It's just like if somebody's coming to my company and I mail the form in, if I mail it in or fax it without paying the money, then they're my responsibility. But if they're out there practicing real estate before that's posted, then they're practicing without a license.
How about if I make a motion? How about if I make a motion, we accept council's recommendation?
Is there a second?
Second.
Motion by Commissioner Wood, seconded by Commissioner Franks, that council's recommendation be adopted as presented. Discussion on the motion.
Do you want to?
No, we want.
I'm tired, I want to go home.
No, we need the education in the 8 hours.
Cheer for the audience.
Right?
Do you want to amend the motion that's on the floor? Does it-
8 hours.
8 hours of what?
Either attend here or, let's see, this is the principal broker.
I really wish we had some broker courses.
Mhm.
We
We
don't
don't because
have
they're
any
grandfathered.
kind of broker courses.
Because brokers don't, a lot of them don't have to have education.
He needs a law
class.
A law class.
Okay, the motion gets amended like this. They can either come, within 180 days, they can either come to this meeting, or they can take they have to take a 4-hour agency class and 4 hours in contracts.
Is there a second to that?
Second.
Okay, so the motion without objection that now incorporates an educational component as well. Is there discussion on the motion? Is to accept council's recommendation and add participation at one of these meetings or take 8 hours of courses, specifically foreign agency and foreign contracts. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, no. The motion passes unanimously. All right, that concludes the legal report. Thank you, Ms. Kirby. Do you have another short report, or is it just for the record?
Oh, the consent order?
Yes.
It's just for record. It's been condensed to one page, you might notice, so it's a little easier to read.
Thank you very much.
But it just shows what consent orders have been sent out and whether they've been accepted, rejected, returned, still waiting, that sort of thing.
Thank you. To the audience, we're gonna reconvene tomorrow at 9 o'clock. And to get your 8 hours credit, you need to be here for both days. So if you will, sign out today. Make sure you sign back in. Please be on time tomorrow. We have a judge. It's a courtroom setting, and we need you here as quickly and quietly as possible. Have a good evening.